board, staff, everybody who has a cell phone, please make sure it's turned completely off.
So we're good to leave there. They put out, this is out, what it is, it's about, so if you're a member of the media, you can come see me. I've got a copy of the Supreme Court order.
All rise. Criminal Court Division 3, Knox County is now in session. The Honorable Mark Ward, Senior Judge, presiding.
Please be seated. I guess I should start off by saying technically we're not in criminal court, but obviously we had to have a physical facility to conduct this evidentiary hearing, and the board here was gracious enough to allow us to have access. I thank everyone from Knox County for allowing us. I'm Judge Mark Ward. As you well know, I've been assigned to handle this matter at this stage. Could the lawyers introduce themselves?
Your Honor, we begin with Federal Defender Services of Eastern Tennessee, here on behalf of Ms. Pike.
What's your last name?
It's Ihnen,
And it's pronounced Eden.
Ihnen.
Eden.
All the answer, Your Honor.
Eden. Did I get it right that time?
Yes, sir.
Okay, before we start, I enjoyed reading your materials, and I'm probably going to butcher all of your names, so I apologize.
Good morning, Your Honor. Stephen Farrell, Federal Defender Services.
I got that. That's an easy name.
Good morning, Your Honor. Suzanne Bales with Federal Defender Services.
Bales?
Yes, B-A-L-E-S.
And Your Honor, we have our paralegal here.
Hi, Patricia McIntosh.
And for the state.
Morning, Your Honor, Will Ayers here for the state.
Your last name again?
Ayers, A-Y-E-R-S.
Enjoy reading your materials.
Your Honor, my name is David Wickenheiser for the state. And it's W-I-C-K-E-N-H-E-I-S-E-R. Thank you.
Good morning, Your Honor. Samantha Morris, also from the state.
And we also have Kim Alexander, our paralegal, and Catherine Klein, who is an attorney whose practice is pending admission.
Nice to get to put names with faces. Both sides have been giving me a lot of reading material over the last couple of weeks. So nice to put names with faces. Anyway, we're here. I understand that we're being live streamed, and I've authorized the camera to be in the courtroom. So if anybody is interested in this proceeding, they have access to that without having to be here. That being said, for all the folks that are here, I don't think I have to say it, but we're going to keep this in an orderly fashion. Everyone has a right to be here as long as they're not disruptive. I have no clue what to expect, but we're not going to tolerate any unusual disruptions to what should be an orderly process here today. So I'm not speaking to the lawyers, I'm speaking to the people that in the audience. As I said, I don't know what to expect. With that being said, I'm not sure that everyone really is on the same page as to what this proceeding is going to be procedurally. So I wanted to kind of set the stage first by talking about what I perceive we are doing here procedurally, and then give both sides an opportunity to correct me if I've interpreted wrongly, or to make comments or suggestions to me about what we're about to undertake here. And so I'm going to open that up to both sides in just a few minutes. Now, the way my understanding of where we are procedurally, obviously, and I'm assuming that Ms. Pike, you can hear what's going on?
Mute your mic.
Ms. Pike, can you hear and see what's going on now?
She needs to unmute her microphone.
Yes, I can. Hello, good morning.
Good morning. I just want to make sure you can hear what's going on. I've been designated a special master, but my technological skills are not that special, so I'm going to count on the lawyers to assist me in making sure that we keep Ms. Pike informed of what's going on during this proceeding and to help you with the technology as you present your materials to the court. Be that as it may, I'm looking at the court's order, and I have distributed copies of the court order in the courtroom. My understanding is that she has completed the three-tier appellate process to challenge her death penalty sentence that was arrived at Knox County, and that on September the 30th of 2025, the Tennessee Supreme Court set an execution date for Ms. Pike for September the 30th, 2026. It's also my understanding that sometime in January of 26, Ms. Pike filed a challenge to the method of her execution in the Chancery Court of Davidson County. And I'm going to abbreviate, but subsequent to that, Ms. Pike has filed a motion in the Tennessee Supreme Court entitled Motion and Request to Appoint a Special Master pursuant to the Tennessee Supreme Court Rule 12-4E. And in response to that motion, the Tennessee Supreme Court construed the motion to be asking for a stay of execution for Ms. Pike in order that she will be allowed to pursue her collateral litigation in Chancery Court in Davidson County. And in response, the court entered this order that I'm looking at, it was July the 10th, and has appointed me as a special master to conduct an evidentiary hearing on the matters specifically referred to in this order. Pursuant to this order, I'm to receive evidence. And then, on August 21st, 2026, I'm supposed to transmit back to the Supreme Court the record of the proceedings and special master's report of findings of fact and conclusions of law. And then, a week later, on August 28th, 2026, the parties can file any objections to the special master's report. And thereafter, provides that issues not specifically referred to in the special master are hereby held in abeyance pending completion of the special master's report. The court will set a briefing schedule on issues upon receipt of the special master's report. So I read this order as anticipating that after I submit my special master's report, that both sides will be given an opportunity to brief and argue in the Tennessee Supreme Court, requesting that that court grant a stay of execution so that Ms. Pike may pursue her collateral attack upon the method of execution. That is not a challenge to her death sentence, it's a challenge to the method of her execution. What is currently before the Tennessee Supreme Court interpretation is a request for a stay of execution, and according to the Supreme Court rule, despite that, not despite, that request will or will not be granted in large part or solely upon determination by the Supreme Court of the likelihood of success in that collateral litigation. And so that's where I see we are. This is not the collateral litigation. And this is not a hearing designed to serve as an attack for collateral attack upon this. It's really the Supreme Court telling me that in order for them to effectively rule upon Ms. Pike's motion, that they need to know certain things. And they listed those 5 things that they need to know. I don't anticipate them thinking that I am going to rule on the motion. They just want me to give them the facts, findings of fact, and the conclusions of law on these 5 specific questions, and they will make the ultimate decision of whether we're going to stay. If I miss something or I mischaracterize anything, I'm going to let both sides go. I think it's important that we all are on the same page about what we're about to do. Is there any comment or anything about where you think we are procedurally?
No, Your Honor, I think that your understanding is the same as ours.
What about the state?
I would agree with the court's characterization. The state does have a couple of matters to bring to the court's attention related to the scope of the proceedings. We can make that motion now, or if the court would like to say some additional remarks, we could wait. But there are 3 specific issues related to those 5 in the Supreme Court's order that are going to affect the scope of the testimony this morning, that will have some cascading effects throughout the hearing. These are issues we've raised in our pretrial brief, but we'll await the court's direction on that.
Okay. But procedurally, I haven't missed anything?
No, Your Honor. I think we're all on the same page.
All right. Well, the next thing that I was going to ask is if the 2 parties could agree on anything, I guess I could just stop there. With regard to the 5 questions that the court has to, I was going to talk about those 5 questions. You submitted a pretrial brief that addressed those, raised certain issues. The brief of Ms. Pike did not address those issues. In fairness to them, to the order that filed your briefs.
You said feedback in here. Can you hold for just a second?
Sure.
Let me see if I can
We're
do
going to
this.
pause just a moment.
Test, 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 test. 1, 2, 3. Test.
As I was about to say, the state submitted a brief that is arguing for an interpretation of these 5 questions in one way. The defense submitted their pretrial brief that didn't respond to that. And the defense, they couldn't respond to it because the briefs were due at the same time. So I don't know, I was going to ask, what I had envisioned was asking the attorneys to tell me if they could agree on anything on this topic, and if not, talk about the 5 questions involved. You say you're going to make a motion, or?
Yes,
Your
Your Honor.
lawyers want to address it. We obviously have to talk about these 5 questions.
Yes, Your Honor. But maybe we can start with, as you suggested, what we can agree on. I think the parties have agreed on issue number 5, and the parties have filed a joint stipulation as to issue 5, which is related to Ms. Pike's spiritual advisor being present with her in the execution chamber. The Department of Corrections granted that request. That will be allowed, and the parties agree on that. And so they filed a joint stipulation that essentially answers that question number 5. I'll let Mr. Dean say
Well,
anything.
I mean, does that mean that Ms. Pike is no longer claiming that there is a problem with the protocol as it applies to her as a result of issue number 5? Or is it just that you're stipulating that the evidence is going to be?
The former, Your Honor, yeah, we've agreed with the state that that is not an issue that we will be hearing.
So,
Here you go. Just wait.
Did you hear me, Your Honor?
I did.
I'll do that.
So colloquially speaking, that is off the table. Okay, so we've got 4 issues. Can the parties agree on the scope of any of the other 4 issues? If not, we need to talk about it.
Well, let's talk about issue number 2, if we could, Your Honor. And that is the issue that pertains to Ms. Pike's transport to Riverbend, which is where executions are carried out in the state. She's currently housed at what's called the Deborah Johnson Rehabilitation Center, which is a separate facility. So there will need to be a transfer at some point to effectuate the death sentence. Issue 2 has to do with when that's going to happen. There is a factual predicate or assumption in that issue that's submitted by the Supreme Court that she will be moved to Riverbend 2 weeks prior to her execution. And there's a second factual assumption, which is that for the time that she is at Riverbend, she will be observed by male correctional officials. Now, the state filed in a declaration with this pretrial brief from Assistant Commissioner Lynn Thomas, a sworn statement that Ms. Pike will not be moved to Riverbend until no sooner than 24 hours before her execution on the 30th of September. And so the state is committed to that in a sworn statement before filed. The state is also committed to staff Ms. Pike's observation while she is at Riverbend with female correctional staff. And that's also a position that's made in a sworn statement that's been filed with the court. Now, the parties have discussed this, and in credit to the defense, they've been willing to be flexible, and we talked about it. We have not been able to reach an agreement such that we can stipulate. But it's the state's position that in light of these statements and commitments from the Department of Correction, that neither of these factual predicates in issue 2 is present. And so that there is no evidence to hear on issue number 2. She's not going to be Riverbend for 2 weeks, and she's not going to be observed by male guards while she's there.
Here, Mr.
Thank you, Your Honor. Can you hear me? I'd like to back up a little bit here. I think there's a little bit of confusion as to issue 2. We actually agreed with the state that the Tennessee Supreme Court, when they sent this issue to Your Honor, misstated the facts as we both understand it in the record. The Tennessee Lethal Injection Protocol specifically says that Ms. Pike would be transferred from Deborah Johnson to Riverbend 48 hours before her execution. I think when you read the protocol that way, I think the state reads it that way, and that's the way that we pled it in the Rule 12 motion. And the Tennessee Supreme Court has sent this question to the court, which misstates that fact.
Please pause just a moment. Judge Green shared a lot with me, but not as much.
While we're waiting, there's another issue that I'd like to address, if possible. Your Honor, one thing that occurred yesterday evening and this morning is we had arranged for counsel to be present with Christa Pike during this hearing, which no one is right now. And because we're a small just a small unit, there's only 4 attorneys, and one of Christa Pike's attorneys in another matter volunteered to sit with her, answer any questions, give her some advice, contact us if it was necessary. That attorney asked for permission to go to Deborah K. Johnson facility on Friday. It was denied last night at 6 p.m. Eastern. She went to the prison this morning, is standing by, ready to go. She informed us that armed guards are present, telling her not to be on the property. She is a member, her name is Angie Bergman, Bassberry and Sims, and she represented Ms. Pike on a civil matter concerning her solitary confinement. They have a relationship. Ms. Bergman has been to that facility many times without incident, and she's standing by, and we would like to get permission for her to sit with Ms. Pike during these proceedings, and perhaps that would help with the technology. I don't know if that would, where Ms. Pike wasn't used to how to mute herself or turn her voice on when it's time for her to talk. But we wanted to raise that matter with the court this morning before we got very far underway, because we think it's important, and pursuant to this court's order, that she be able to consult with counsel, and that was our understanding, is that we would be able to have someone there. And Ms. Bergman is willing to make a limited notice of appearance if that's necessary, or if it has to be someone from our firm, we would arrange for someone to be there tomorrow. But the most expedient thing would be for Ms. Bergman to be given access to the prison and be able to sit with Ms. Pike during the proceedings, and that's what we've asked for.
Ms. Ayers, you have a dog in this one, so to speak?
Yes, we do, Your Honor. We object to this for several reasons. The first of which is the timeliness of it. The court's order came out on August 3rd, and our office did not have notice of this request until yesterday. And it was not even until last night that we knew that this attorney who was in Nashville had any connection to counsel for Ms. Pike. We had asked this attorney, or an attorney from their office, if they intended to make an appearance in this case. They said, no, we don't. The case that they represented Ms. Pike on was settled years ago. So, to our knowledge, there is no active matter on which Ms. Pike is represented by these lawyers. This is a distraction. It could have been worked out earlier, perhaps, if the state and the department had had more notice. But coming as this did, just at about the last minute, not only is it not contemplated in the order, what's required in the order is that the state make a video feed available to Ms. Pike, which they've done. She has access to a telephone, so she can call her attorneys at any time during these proceedings. She's been provided with phone numbers so that she can do that. And that's what the order requires. It does not require counsel to be present there. As Mr. Farrell said, if they want to send an attorney out there from their office who's representing Ms. Pike, we don't have a problem with that. But the late nature of this request just creates a distraction, such that we're cutting it now in the time that we could be using to address these issues and address the scope of what's before the court. And as we can all see, the terms of the order have been met. Ms. Pike has access to the proceedings. She can see, she can hear, she can communicate with her counsel. And so the state's position is that we don't need to get into this last-minute request.
Well, do you anticipate that Ms. Pike is going to testify in this proceeding?
We do not at present, but if Your Honor had questions for her, we would like for an attorney to be present. We don't plan to call her to testify.
And neither does the state.
Well, I don't see any harm in allowing this lady in. Your only objection is the timing?
The objection is also that it goes beyond the scope of the court's order, which does not require counsel to be present in the room with Ms. Pike, so long as she can communicate with her counsel, which she can do.
Well, it is late to be raising this, but I'm going to allow her to be in there with at this time. But we're not going to delay this while that takes place. So we continue on. I don't know how we need to communicate to the prison that she is allowed in. Can you take care of that for me?
We can. There is another issue related to this, though, Your Honor, that I wanted to raise. This request also came with a request to bring in electronics, I think at least a laptop and a cell phone, things that are not normally allowed in the prison, that plus obvious security concerns. If the court is going to allow this visit, we request that the attorney would be allowed to enter, but not to bring in any equipment that could pose a security concern, which could cause further delays, because law issues.
It's a good compromise.
Yeah, and we're fine with that, as long as she has access to a telephone to contact us.
Apparently there's one there.
Yes, and that we weren't aware of, so just,
We don't need to be distracted by this, so let's just move on, and I will allow her to go in. So,
thank you, Your Honor.
communication, everything's back, and you were about to address me about.
I was about to say something brilliant.
Question number 2.
And again, just backing up a little bit here, I've got in front of me the Tennessee lethal injection protocol, and this will be made an exhibit, so I don't think that this is anything out of turn here. But in the protocol, it says 48 hours before execution, central office personnel oversees transfer of female inmate from DJRC to RMSI if applicable. Our understanding of that provision is that Ms. Pike would be housed at the Deborah Johnson Center for the isolation period 2 weeks prior to her execution, and pursuant to the protocol would be moved to Riverbend Maximum Security Institution 48 hours before her scheduled execution. I believe that's the state's understanding of that provision as well.
Wait a second, so, say that again, for 2 weeks she's going to be,
So the Tennessee lethal injection protocol, if you select lethal injection, which is the default method of execution, you are required to be isolated for 2 weeks. At Riverbend Maximum Security Institution, my understanding, and the state can certainly correct this if I'm wrong, but that they move the inmate to a separate part of the unit where death row inmates are housed. For that 2 weeks, they are kept in isolation, essentially solitary confinement for those 2 weeks. And then 48 hours prior to, if it's a man, their execution, they would be moved to what's called the capital punishment unit. For Ms. Pike, my understanding of what the protocol says is that she would still observe that 2-week isolation period, but pursuant to the language of the protocol, that would be at Deborah Johnson Center. And then 48 hours prior to the execution, she would be moved to the capital punishment unit at Riverbend, same as the men.
so when you say isolation, what does the protocol provide for her during those 2 weeks? Is she allowed visitors during those 2 weeks?
My understanding is, yes, visitors, attorneys, spiritual advisors may be allowed as long as that's scheduled with the Riverbend facility.
Is she allowed out of the cell? At all?
I'm not sure, Your Honor.
The word isolation, I'm sure, they have different interpretations.
Sure, and let
If
me
you're
ask you.
isolated and you get visitors, are you really isolated?
Let me find what the language here is in the protocol.
I guess, and are you in solitary confinement if you get visitors?
So,
I guess it depends on how long the visitation is, I guess.
Okay. So the protocol says 14 days before the execution, central office personnel directs the initiation of the continuous observation logs, which record all daily activities of the inmate beginning 14 days before the execution. The logs are maintained at each post where the inmate is located until the execution occurs or a stay of execution is issued. Now, how that provision has operated in practice is that, again, the male inmate is moved to a separate part of Unit 2, which is the unit that houses death row inmates at Riverbend, and then they are continuously observed in that sort of isolation situation for those 2 weeks. And I'm not, the state might have more specifics beyond that.
It provides 2 weeks of continuous observation. I'm not sure it provides 2 weeks of solitary confinement. Those are different things. If the protocol allows for visitors, I thought I read somewhere where they cut the visitors off 12 hours before.
12 hours issue.
So, anyway, I interrupted you. Go ahead.
Well, and part of the problem with the protocol in general, and this is exceeding the scope of the Tennessee's criminal jury, but so much of it is secret and confidential and not provided to counsel. And so all I can testify to the court today is how this provision has operated in practice. And that has been that the male inmate has been moved to a separate part of the unit, isolated for those 2 weeks, and then continuously observed 24 hours a day during those 2 weeks. Getting back to the issue of Ms. Pike, my understanding is that that provision would apply equally to her at the Deborah Johnson Center. And then 48 hours prior to her execution, she would be moved over to the capital punishment unit, where she then is observed 24 hours a day as well. That's, like I said, our understanding of the protocol. I believe that's the state's understanding of the protocol. That's the way that we pled that claim in our motion. And then the Tennessee Supreme Court, when it referred issue to Your Honor, misstated the fact that Ms. Pike would be moved to Riverbend during that 2-week period. So that's not our understanding of the protocol. That's, again, not the state's understanding. That is the way that the Tennessee Supreme Court framed this question. But I think it's clear that what the court is asking Your Honor to do is evaluate whether Ms. Pike's post-traumatic stress disorder, bipolar disorder, will be impacted by that observation period at a men's prison. That's the, we believe, crux of this issue. And if the state's argument is basically that this issue was moved when the Tennessee Supreme Court drafted it. And obviously that was not the intent of the Tennessee Supreme Court. And so that would be our response.
So let me get down to the bottom line. You believe there still is issue number 2 still on the table?
Yes, Your Honor.
And we should address it during this hearing.
Yes, Your Honor, and let me just give one more reason for that. So my friend stated that the Tennessee Department of Correction was committed to staffing that isolation period, that observation period of Ms. Pike with female guards. Ms. Thomas, who actually is scheduled to speak today, she did file a declaration, but it says that they would make every effort to assign only female staff. So I believe that that is a factual issue that the court should consider.
So your position is on issue number 2 that the court should consider for movement and for observation, whether they consider that as whether that causes her serious illness and needless suffering due to her cited history of sexual assault and diagnosis of post-traumatic stress disorder.
That's correct, Your Honor. Whether it's 24 hours or 48 hours, she is going to be moved to the men's prison. She is going to be continuously observed. And the state, despite what they've said, has not assured that only female guards will be taken.
What do you hear, Ms. Ayers? That's what they want. That's what they want. What's your position?
So, Your Honor, the parties did negotiate this issue and discussed it, and in the course of those negotiations, the state asked, well, what would be an acceptable transfer time? And the answer came back, in the neighborhood of 24 hours. So the state committed to that. And the other issue was observation. Would it be acceptable if she was only observed by female guards? The answer came back yes. So the state, to the best of its ability, committed to that. Now, what counsel for the other side seems to desire is a guarantee that no male guard will ever observe Ms. Pike while at Riverbend. As the court knows, we're not in the business of guarantees here. The department has made a commitment to staff her observation, to not assign any male officer to that observation during the time while she's at Riverbend. People's cars break down, they get sick, things happen, and so the state cannot make an absolute 100% guarantee that no male guard would ever walk in there. And there's no amount of factual development that could establish that. And it would be hard to imagine a court order that required absolute perfect guarantee in that regard. I think the sides agree, more or less, that the Supreme Court's issue that was referred to this court has to do with whether the transport and observation, given her stated mental health concerns and her history, are going to cause serious illness and needless suffering. The question is, are the transport and observation even an issue anymore? Given that she's not going to be transferred, whether it's 2 weeks, whether it's 48 hours, whatever measure we want to pick, it's going to be no sooner than 24 hours before. And during that time period, however long it is, she's going to be observed by female guards, as best as the department can ensure. And so, it's hard to imagine what evidence the court would receive that will inform this issue. Other than perhaps asking the assistant commissioner, well, do you really mean what you said? Well, she's already stated under penalty of perjury that this is what's going to be the case. I do want to correct, the state's position is not that this issue is moot as drafted. Our position is that it's moot in light of the concessions that the state has made, and so that there is no evidence to receive on this issue.
Well, I've been instructed to address and have evidentiary hearing on 5 issues. The parties agree that issue number 5 is no longer necessary for me to have a hearing. There's disagreement with regard to issue number 2. And it's pointed out that the way the Supreme Court phrased the question is whether movement is like would have been maximum security before the execution, which you will be observed by male prison officials for 2 weeks prior to the execution, would make it sure or very likely that the challenge protocol will cause Ms. Pike serious illness and needless suffering.
Okay, I found this on the web for serious illness and suffering. Check it out.
Sorry about that.
Did you find anything helpful for Ms. Pike, Your Honor?
I should be able to turn off an iPhone. Anyway, I think it's been pointed out that the motion that Ms. Pike filed, if you read it really, really closely, it doesn't say that she's going to be transferred to this. But you have to read it pretty closely. The first 6 times I read it, when you put a conjunction between those 2 phrases, it makes it sound like that. You were saying that. I had to go back and read it 6 or 7 times the way it was worded. But anyway, be that as it may, this question involves her post-traumatic stress disorder and a history of sexual assault. I am going to allow you to get into her movement and her observation. If the facts don't support it, they don't support it, but if you're not willing, if you're going to go forward and say that her observation, likely by female, is going to cause her psychiatric problems, I'm going to let you do that. I'll let you go forward with your proof in the state with your proof, and we'll go from there. I think at least the spirit of that question requires me to consider her post-traumatic stress disorder and her movement, however long it is, and her observation. And we'll see what the proof shows. So, I think that is something that's allowable. Where are we? We've still got 3 other questions to talk about. So any agreement on the scope of those other 3 questions?
Your Honor, if we can speak to issues 1 and 3, the state will move to limit or exclude testimony regarding a central line, first of all. The court is probably aware that in the protocol, there is a provision that allows a physician, if necessary, to set a central line. Now, this court is limited by Rule 53 of those issues referred to it. None of the issues in the Supreme Court's order refer to a central line or contemplate a central line. In fact, the Supreme Court's order specifically mentions twice peripheral IV access, which is not the same as a central line. We articulate that in our pretrial brief. And so the issues referred to this court concern peripheral IV access. And under the protocol, who's responsible for that is the IV team. And the parties don't dispute that the qualifications and experience and so forth of the IV team are relevant and will be explored during this hearing. That's not a dispute. But the expert reports and briefing from Ms. Pike have focused extensively on this issue of the central line. But there is no logical connection between that and any issue for this court. Again, the Supreme Court's order focuses on peripheral IV access. And related to that is the qualifications of the physician who places the central line. And this is particularly relevant in light of the Supreme Court's order last week in the Hines case. And as we explained in our pre-trial brief, in that case, another inmate who's convicted has been sentenced to death. Anthony Hines had filed a motion in the Supreme Court arguing that he was entitled to a stay of execution and a special master to explore the issue of the physician's qualifications, specifically the physician who participated in the attempted execution of Tony Carruthers back in May of this year. He argued that he would suffer unconstitutional superadded pain if the same physician were to participate in his execution, which is scheduled for this coming Thursday. And his argument was that if the department replaced this physician with what he believed was a qualified physician, then there would be no constitutional issue. Similarly here, Ms. Pike argues that there's a supposed alternative method of execution by central line inserted by a physician that she considers qualified. Now, the Supreme Court rejected this argument. First, it observed that there was no evidence in the record before it that this physician wasn't qualified. And that's a remarkable thing because they didn't receive just a motion and legal arguments. They received proof, including a declaration by a physician who offered extensive opinions on the standard of care for a central line, whether or not ultrasound should be used, what position the patient or the subject should be placed in, and so forth. But the Supreme Court considered that and concluded that there is no evidence that shows that that physician was unqualified. And in addition, there was a declaration from a witness to that attempted execution, an attorney named Maria Deliberado, who Ms. Pike's attorneys intended to call as a witness. The Supreme Court also did not find that evidence to show that the physician was unqualified to set a central line. There's nothing different being offered here. And so there is no reason to get into the proof of what constitutes a qualification to set a central line, whether or not this particular physician who participated in a past execution was qualified to set a central line. Again, the issues are limited by Rule 53 to the issues referred to this court, and that is simply not an issue. It's also notable that in the Hines order, the Supreme Court observed that even if they took the allegations as true, that Mr. Hines would not be able to establish a constitutional violation because, and I'm going to quote the order here, an isolated mishap alone does not give rise to an Eighth Amendment violation, precisely because such an event, while regrettable, does not suggest cruelty, or that the procedure at issue gives rise to a substantial risk of serious harm. And in doing so, they quoted the Bays versus Reese case from the United States Supreme Court. So that contention for Mr. Hines that an unqualified physician setting a central line would be some kind of constitutional violation was foreclosed as a matter of law. It added that this was just speculation, and that was not sufficient to show a likelihood of success on the merits. The same arguments apply here. Ms. Pike is arguing that if this same physician who participated in Carruthers' execution is to participate in her execution, there is a high likelihood that she'll need a central line and that she will suffer if a central line is placed. But Hines forecloses that argument. And so when we read Hines together with the background principles of Rule 53 and the issues in the order, a central line, the qualifications to set a central line, and what happened during Tony Carruthers' attempted execution are not relevant, they're outside the scope of this court's referred issues, and it would be a distraction. I will stop there. If the court has any questions.
No, Mr. Mayor.
Well, Your Honor, just a few quick points. The Hines litigation, as I understand it, was about the specific identity of the physician that would be performing a central line should Mr. Hines need it as part of his execution. That was the issue that was referred to the Tennessee Supreme Court. That was the issue that they ruled on, and all of the discussion about whether or not Mr. Hines' legal team could establish anything in violation is not applicable to what we're trying to get in this litigation. First, I think Your Honor has already addressed part of the state's concern in your order on the state's motion to quash the subpoena. We submitted as Exhibit A to our TDOC subpoenas, Topic 3, Central Line Capability and the Physician's Qualifications. Your Honor, you actually struck the last part of that topic, which was dealt with the physician who was involved in Tony Carruthers' execution. But the topic still stands, the qualifications, training, and certification of the physician designated for Pike's execution, including whether the physician is qualified and certified to place a central venous line. And Your Honor also already entered a protective order protecting any identities or information that could be used to reveal the identity of that person. The fact is that the protocol calls for a central line if IV access cannot be yes, Your Honor.
You're not responding to the question. The question is central line placement, the qualifications of the physician, and what happened in Tony Carruthers' execution beyond the scope of question 1 and question 3.
What happened in Tony Carruthers' execution is not applicable to what's going to happen with Spike's potential execution.
You're not going to try to put on evidence of what happened in Tony Carruthers' execution.
Not as it relates to the specific identity of that physician, no. But if you look, issue 4 of the order that was referred to the special master states whether Ms. Pike's proposed alternative methods of execution would significantly reduce the substantial risk of severe pain. On page 25 of the motion that we filed with the Tennessee Supreme Court, alternative 1 says use of the 23-gauge butterfly needle or central line. So central line is contemplated in issue 4 as one of Ms. Pike's proposed alternative methods.
We're not talking about issue 4, we're talking about issue 1 and issue 3. Is central line qualifications of the physician and what happened in Tony Carruthers relevant to 1 or 3?
Well, issue 3 deals with vein access, and we've alleged that Ms. Pike accessing Ms. Pike's veins is going to be problematic. Under the protocol, if that's the case, the central line is then established. So I do think that any facts or information that we're able to reduce related to that issue is relevant to issue 3. Again, Your Honor, you've already limited the scope of this issue with on your order on the motion to quash.
Wait a second. You're not suggesting because I let you subpoena information that I've already ruled on its relevance.
No, Your Honor, but we've not prepared a case, given that order, that predicates on anything revolving the identity of the physician involved in Tony Carruthers' execution. Similar to the Hines case that just came out, was about the identity of the physician from Mr. Carruthers' execution, whether that same physician would be present for Mr. Hines' execution. What we are asking this court to consider is what are the qualifications of any of the physicians that would be required to place a central line? What circumstances would a central line be required? And we've alleged that Ms. Pike fits a lot of that criteria because of her small compromised veins. And we've also, like I said, Your Honor, as to issue 4, we've pled that as an alternative in our motion to the Tennessee Supreme Court.
Well, we'll talk about 4 in a minute. The way I read, the question 1 is given Ms. Pike's diagnosis of thrombocytosis, whether achieving peripheral IV access pursuant to the current lethal injection protocol would make it sure or very likely that the challenge protocol would cause Ms. Pike serious illness and needless suffering. And the way I read that is they want to know whether achieving peripheral IV access will cause her suffering, not whether central line placement may cause her suffering. No mention of central line placement in there whatsoever. It ends after they achieve peripheral IV access. That's what they want to know. Is her condition going to cause problems with achieving peripheral IV access? So, and the other question, number 3, is whether the small veins will cause trouble with peripheral IV access. So on 1 and 3, I don't see any relevance to central line placement, qualifications of the physician who might be making a central line placement, or what happens in anybody else's execution. And so tell me where I'm missing as far as 1 and 3. We're going to talk about 4 because I think 4 opens stuff maybe we discuss it. But what relevance is that central line placement for 1 and 3?
Your Honor, the proof that we anticipate to put on will say that given Ms. Pike's diagnosis of thrombocytosis, given the fact that she has small compromised veins, a central line is the best alternative in order to effectively deliver the lethal injection drugs. The protocol explicitly calls for a central line if peripheral IV access cannot be gained. And so it's necessarily part of the question. I understand that it's not specifically referred to under issue 1 or 3, but the way that the
It's
protocol...
not specifically referred to, then I'm really going beyond the scope of what the Supreme Court has to do. And I'm not saying that in your ultimate litigation in Chancery Court that those might, I'm not proposing anything, but the Supreme Court's trying to evaluate whether there's a likelihood of success in your collateral litigation in order to determine whether you're going to do slave execution. And you've done an excellent brief and motion and could have probably, obviously, filing more briefs and motion trying to convince them. And they've said, okay, we need these 5 things in order to make an intelligent decision on this case. These are the only 5 things we need. I don't know what that means with regard to the other facts. They may be accepting that it's true, they may think they're irrelevant, I don't know. But they've said 5 things, and with 1 and 3, they've said achieving peripheral IV access. They haven't asked me of any other aspect of the protocol other than achieving peripheral IV access. So I think we have to limit 1 and 3, and I do think central line, that's an argument down the road, but not for answering question 1 and 3. That's my thoughts, but I'm going to let you attorneys have another shot at convincing me otherwise. I assume, Mr. Harrison, you don't disagree.
No, I think we're on board with that, Your Honor. I would just add that the matters pleaded in Ms. Pike's motion might have merit on the road, as the court stated, but that's not what we're here this week to resolve. It would be everybody's benefit if we can stick to the scope of the Supreme Court's order. And, relative to the central line, as to any issue, whether it's number 4, 1, or 3, it's in a protocol that the central line can be placed if necessary. And so, if they are looking to establish whether or not TDOT can establish a central line if necessary, that's the fact that it could be stipulated to, because it's right there in the protocol. It's just not, doesn't bear on any of the issues before the court. Now, if the court has specific questions about issue 4, we have additional arguments, but our position is that the central line issue, qualifications to set it, and the corroder's execution are not relevant to 1 or 3 or 4.
Well, I can't see why it would be relevant to 4, but why do you think it's not, we don't have to talk about 3 enough? Do you have anything else to say about 1 and 3?
Just, Your Honor, the central line is necessarily contemplated as part of the lethal injection protocol. The only reason it was an issue in the Crow's execution was because they could not achieve peripheral IV access. So we we would object to that narrow reading of those two issues, but other than that, nothing further.
So let's talk about four. Because four is the fourth question. Whether Ms. Pike's proposed alternative methods of execution would significantly reduce a substantial risk of severe pain. One of her proposed methods is to flip the order of things and to skip the peripheral IV access and go straight to central line placement with a qualified physician. That's one of the proposed alternatives. How do I exclude them from presenting the proof of their proposed alternative?
So this question, referring as it does to proposed alternatives, requires the court to look at what counts as a proposed alternative under the binding precedent. And what counts as a proposed alternative is a distinct method of causing death. That's clear from Supreme Court precedent dating back decades. Lethal injection, execution, hanging, firing squad. Those are the methods of execution that the Supreme Court has repeatedly discussed. And so under the Bayes-Glossop pleading standard, for these kinds of challenges to execution protocols, it's the burden on a plaintiff to plead an alternative method of execution. And usually that is it's always a distinct method of causing death, and the state agrees that Ms. Pike has pleaded one such method, and that is hanging. But these other two that she couches as methods are either just equipment swaps or slight deviations. For example, the use of a different size needle or allegedly different size needle. There's no proof yet as to whether or not that's even available. That's an equipment swap. That's not a method of execution. The method under that would still be lethal injection by pencil arbitron. And so there is no different method, no alternative method pleaded. Similarly, the central line is the same method, lethal injection by pencil arbitron. It's just the equipment used to deliver it. That is not a distinct method. It's just an equipment swap. It's a procedure issue. Now, this notion that the central line is necessarily contemplated in the protocol proves nothing, because there are all kinds of things in the protocol that are contemplated. For example, if the first injection of pentobarbital is not successful, the protocol contemplates a backup and a second injection. Could a plaintiff someday bring a claim based on that? Maybe so. Is it necessarily contemplated in the protocol? Yes, it's right there in it, but it doesn't mean it's at issue in this action. And so again, the Tennessee Supreme Court is focused, zeroed in on achieving peripheral IV access. If there were any indication that the court was interested in central line or anything like that, it could have said so in the court, and yet it doesn't. The method, the alternative method before the court in which the court will hear proof on is hanging. Anything else is a mischaracterization under binding precedent. And so that's why we don't believe the central line is relevant to number 4. And we certainly don't believe that the Carruthers execution is relevant to number 4 either. We'll have to argue why. It's fundamentally the same reasons as we just discussed.
Let me hear from Ms. Raymond. Knowing that I'm already leaning your way, what do you,
Jar, I would just rebut that the Tennessee Supreme Court, issue 4, specifically asked this court to consider alternative methods of execution. Ms. Pike, like we said on page 25, pled central line as one of her
let me interrupt
proposed
just a second
alternatives.
because I'm not 100% clear. I read in your pleadings that Ms. Pike is a Buddhist and that she has the alternative of choosing electrocution but is unable to choose electrocution because of her faith. And yet she is able to choose made sense to me. Why does her faith prevent her from choosing an alternative method that would do away with any problems from peripheral IV access or central line placement, but allows her to choose death by hanging? I'm confused. Tell me about it.
Your Honor, the answer to some of that, I think, would be attorney-client privilege. We've had conversations with Ms. Pike about potential alternatives, what that would look like. She's expressed her opinions on those to us. But I will say, as the court's well aware, that the glossip requires Ms. Pike to...
She's choosing, I don't want to spend a lot of time in this hearing talking about hanging if she's not choosing to be hung. Is she choosing to be, that's her desired method of death is to be hung?
Yes, Your Honor.
Okay, all right. Then we can move on from there. I just wanted that clarification. So she's got the 23-gauge needle as an alternative. The suggestion that we commence with central line placement, do away with peripheral IV, and that she be executed by hanging.
That's correct, Your Honor.
So, why would the central, my understanding is that I have to make a comparison between lethal injection and death by hanging. I got to make a comparison for the Supreme Court. I'm look at all her methods. So, I think you can, I'm going to allow you to put on evidence what's involved with the central line, prove your alternative, and prove that it offers better results for Ms. Pike, especially considering her unique circumstances. So, I think that's relevant to this inquiry. What I don't think is relevant is the qualifications the doctor that is going to do the central line under the protocol, or the ones that have done other central lines, or anybody else's execution down the road. But I do think you're offering that as an alternative. Legally, it may not be an alternative, but you're offering it. So I think the benefits of that, I think are relevant to the inquiry. Anything else?
Just one more distinct issue that I think would also be relevant to issue 4, Your Honor, and that is that the state would move to limit or exclude testimony about the effects of pentobarbital specifically, and more specifically, any mention of pulmonary edema, or that is a specific effect of pentobarbital. As the court is aware, that was discussed extensively in the briefing before the Supreme Court. The Supreme Court did not see fit to refer that issue to this hearing. There is no mention of pentobarbital in the order. There's no mention of edema in the order. And so whether the Department of Corrections is aware of the effects of pentobarbital, or any expert's testimony about how pentobarbital is working here is not relevant. Again, what the Supreme Court is focused on is the peripheral IV access, and whether or not any proposed alternative is, compared to the protocol as written, going to be a substantial reduction of serious harm. And so, again, hewing to Rule 53 and the limits on this court's scope of evidence, there is no scope to get into how pentobarbital works. Does it cause pulmonary edema? Other things like that, because the court is to be focused on this issue of peripheral IV access, and then whether or not an alternative compared to the protocol as written is going to reduce that constitutional level of pain. Mr. Andrew?
Yes, Your Honor. We believe the effects of pentobarbital, I think, are well known. They've been widely reported. The way that it relates to Ms. Pike specifically, and we've pled this in our motion, is that her specific medical conditions, the thrombocytosis, will make that the experience of that pulmonary edema even worse for Ms. Pike, leading to very likely what the base standard of a torturous execution. And so we would say that that issue is relevant to the first issue submitted to this court. And as to issue 3, vein access, we've alleged, our experts will put on proof that the nature of the drug, the way that it's injected, can cause extravasation. It could leak into Ms. Pike's bloodstream. It can be extremely painful, and that's all relevant to issue 3 as well.
Well, I find myself agreeing with both of you on this one. I do think that on issues 1 and 3, that the extent and duration, seriousness of the pain that Ms. Pike will undergo after achieving peripheral IV access is essentially irrelevant to questions 1 and 3, but I tend to agree with Ms. Pike's attorneys that at least with regard to the extent to which Ms. Pike will experience pain and the duration of that pain is relevant to the court ultimate assessment that the Supreme Court is going to make as comparing pain to death, lethal injection. How can you compare those two methods without considering, with regard to each, the extent and duration to which the individual will experience pain? So I think that I'm not opening a Pandora's box to everything that happens after achieving peripheral IV access, but I'm certainly going to allow you to establish the extent to which, especially due to any unusual circumstances, that she would experience pain under the protocol. So I'm going to allow that part of it. Any other? Have we discussed them all, and does everyone have a thorough memory of what we're going to allow and what we're not going to allow?
Nothing else from the state this time around.
Nothing else to know.
You want to take a short recess before we take our first witness? I'm assuming you're going to want to commence with witnesses and not statement. Why don't you line up your first witness? We'll take a 10-minute recess.
I don't think we're in the new. I'm pretty sure just. Producers are handling the floor.
And do you plan on showing it on the screen?
Yeah, nothing in the screen. Producers are doing the board rock update. Projects number 5.
Because live is the version I worked with still. Yeah, I think you should. I have to plug in that charger in the morning. Oh, you don't have a friend? Plug it now.
So it's already on.
No, just didn't know.
Looked at it. They took the
socially, but that's where they're usually.
Yes, Your Honor, I believe the state has made Ms. Thomas available. And did we figure out what she's going to be able to see?
So she says she can see the
As long as we share them on the screen.
So we'll just have to play it by ear.
Okay. But we have to share any exhibits on the screen.
And just so you know too, she has physical copies of her declaration.
Okay.
So that's
Ms. Thomas, can you hear?
I can, Your Honor.
Okay, great, thank you. Raise your right hand, ma'am. You swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you.
Good morning, Ms. Thomas.
Good morning.
Can you hear me okay?
I can.
I think to look at you, I have to look this way, but I might be turning to the TV because you're over here, so I apologize if that's confusing. Can you state your full name, title, and position with TDOC?
Linda Thomas. My position is Assistant Commissioner, Prison Operations.
And can you describe your role and responsibilities as it relates to the lethal injection process in Tennessee?
I have an overarching role, primarily with the team members. I sign off on team members as part of the process, and I also, at a point in time, 30 days out from the execution, I have several roles to include verification of training of the staff that will be participating in the execution. I direct observation logs. I verify credentials of those that will be participating. And those are my primary roles. I oversee practices, and accountability of the drugs.
Okay, thank you. How long have you served in this position?
Since June 21st of 23.
I'm going to pull up, this is going, I'd like to mark this document as Pike Exhibit 1. And Ms. Thomas, my understanding is that you may not have all of these in front of you, so I think we're going to try to put them up on the screen if that works for you.
Your Honor, may I approach? Please.
Ms. Thomas, can you see the document that we put on the screen?
I can.
Okay. Have you seen this document before?
I have.
Okay. Can you tell me which of these topics you were selected to testify about today? And if we need to scroll through those, we can.
We would need to scroll through.
Okay. Topic 1.
I am prepared to discuss that.
Okay. Next page, please. Any of these?
Two.
Okay. Next page, please.
Seven. Generally 8. Generally 9.
Okay. Next page, please.
10, generally. 11, generally 12. In a general sense, 14, and I can speak to 15.
Okay, and I believe there's just one more.
Yes.
Okay, thank you. Yeah, I'd like to mark Tennessee lethal injection protocol as Pike Exhibit 2.
Mark, the first exhibit, the subpoena, and the exhibit one.
Yes, Your Honor. May I approach?
Two, the Tennessee Department of Correction lethal injection execution protocol.
Ms. Thomas, we have the protocol up on the screen, but my understanding is you actually do have a copy of this in front of you, is that correct?
That is correct.
And is it substantially the same as the one that's being shown on the screen?
I only see the first page of the one on the screen.
Yeah, that sounded like a trick question, it wasn't. Can you scroll through this? Ms. Thomas, does that look like the protocol that you have in front of you?
Yes.
You already testified a little bit about your general role in executions, but I want to talk a little bit more about what that looks like. Do you plan and direct pre-execution activities?
I do.
Can you explain what those are, without revealing any identifying or confidential information?
Practice and preparation.
Okay. And then do you plan and direct execution activities?
It's part of our practice and preparation.
I think I'm making the distinction about the actual day of execution as opposed to anything that happens prior. What is your involvement on the day of execution, I guess?
Observation and oversight.
Oversight of what or whom?
The process.
And then do you direct and plan post-execution activities?
I do.
Okay, and what does that consist of?
Objection here, I'm not sure what the relevance of the post-execution activities are in challenging what the actual execution, whether that causes pain and suffering.
I can withdraw that question. Okay, can we turn to page 9 of this document? Do you have that in front of you, Ms. Thomas?
Yes.
Okay, can you read what the heading is on this page?
composition, selection, and training of department and non-department personnel.
Okay. Can you tell me, my understanding is these are all members of the execution team, is that correct?
Yes,
Okay. Can you tell me which of these teams that you select or supervise?
all of them.
Okay. How do you make the selections for the members of these teams?
Objection, Your Honor. I'm struggling to see the IB team isn't on here, and I thought this was, I thought this testimony was centered around peripheral IB access. I'm not sure how the selection of the warden or the special operations team or the street team or the escort team has to do with what peripheral IB access is.
Your Honor, I can lay some foundation on this. Can you flip to page 7 of the protocol, please? Do you see that, Ms. Thomas?
I do.
Okay, and under Special Operations Team, can you read what it says there?
The Special Operations Team is responsible for preparing the lethal injection chemicals for administration.
Okay, so without revealing the names or identities of any of these members, are the members of the Special Operations Team involved in the IB process for executions?
Would you elaborate on what your definition of involved means?
Well, what does preparing the lethal injection chemicals for administration mean?
It means preparing them for the process. Without getting into specific details, I think preparing is pretty specific in that they handle the chemicals.
Okay. Can we turn to page 11 in this document? You see that, Ms. Thomas?
I do.
Okay, and under number 1 there, can you read which team that is?
Which number 1 are you referencing?
Number 1 at the top of page 11. Sorry about that.
IB team consists of at least 2 members who are either physicians, physician assistants, nurses, emergency medical technicians, parentheses, EMTs, paramedics, military corpsmen with relevant medical training, or other certified or licensed personnel, including those trained in the United States military. All team members are currently certified, licensed, and/or qualified within the United States to place IV lines. IV team members are selected by the commissioner.
Okay. And you just read that last sentence said that these members are selected by the commissioner. Do you have any oversight over the IB team?
Oversight as in what your question, if you can be more specific, what you mean by that?
Do you check any of the qualifications of the members of the IB team?
I do.
And what does that entail?
I verify their license and their certification.
And how do you do that?
Your Honor,
I go to-
sorry, AC Thomas. Your Honor, I'm just gonna briefly object, and I'm not sure that we've gotten there yet. I just want to be clear here that the state is going to take a position that, if we get into exactly what the jobs are of these folks, that is reasonably identifying information. And so, to the extent that AC Thomas is going to discuss exactly how these folks are qualified, we'd ask that the court really instruct AC Thomas and instruct the council to make sure that stays general to a higher level, like, decades of experience or, like a general kind of description of their position as opposed to getting into the details of that, because I could identify those individuals.
I can do that, but the question is going to be whether Ms. Thomas misunderstands the question and learns out a specific, regardless of what I say. Ms. Thomas, I am going to direct your attention to the fact that the identity of all these people on this team is privileged, and we do not want you to testify about anything that could be used to identify these persons. So I want you to keep your responses as generic and general as possible. And if you need to pause and hesitate before you answer a question, give it some thought, please do so. That being said, I ask counsel if you could try to make it as obvious as possible that you're asking for general questions as opposed to specifics. If you know the answers to the questions, as far as I'm concerned, you may be, unless we get an objection from the other side.
Ms. Thomas, I think I just asked you how you check the qualifications of these members. And again, with the admonition from the court, not revealing any identities, not revealing any type of information that could reasonably be tied to any of these members, what is your process for verifying the qualifications of these members?
I checked the Tennessee Department of Health license of people that participate in the team to make sure they are currently licensed in the state of Tennessee.
And what type of license is required to be a member of the IB team?
The state of Tennessee, I look for license. We identify in the protocol in section 1 what their job titles may be. The job titles are described, and I check to see if they're in good standings with the state of Tennessee.
And so is there any specific type of license or certification that a member of the IB team must have?
Objection, I mean, so to be clear here, the licenses are, those do describe the specific job, right? So I mean, there's folks that have licenses to be EMTs, paramedics, nurses, doctors. So the licensure, if she reveals exactly the licensure of these folks, that is identifying their job. So, you know, I think Casey Thomas has said that she checks that they have the licenses. I don't know if we need to delve into what those are specifically.
What was your question again? I thought I understood it a different way.
Which type of license or certification is required to have to be a member of the IB team? I understood counsel's objection in this court's admonition to be revealing personal identifying information about individuals on the IB team, not what their qualifications are to serve on the IB team.
I interpreted her answer that it was the licenses of the relevant professions listed in this paragraph that you elicited. And then I thought your question was, is there a specialized license devoted strictly to execution? But apparently I misunderstood the question. So, there's a part of you which say that this question has been asked and answered, but maybe I misunderstood.
That's fine, Your Honor. I can move on. Ms. Thomas, as part of your check on these licenses, does that include any check about whether any of these individuals are under any kind of disciplinary action?
Again, I checked the Tennessee Department of Health. The information that's contained on there is what I use to verify.
Does the Tennessee Department of Health include on a license verification whether or not someone has been disciplined?
I'm not sure about that. I say that I know that to be a fact. No, I don't know.
Can you tell me who selects the physician for executions?
Number 2 in the protocol indicates the physician is selected by the commission.
Do you play any role in verifying that individual's credentials or license?
Your Honor, I thought we weren't going to get into the qualifications of the physician to set a central line. That would be, I think, the only qualification of the physician, unless I'm mistaken, and if the council can certainly correct me, would be their qualification to set a central line. And so if we're not getting into that, I'm not sure how this is relevant.
Your Honor ruled that Ms. Pike could explore the central line option. That necessarily requires us to understand there are specific qualifications and certifications that someone must have to place a central line. And I'm just asking Ms. Thomas if they verify that.
No, I would, you could not get into the specific qualifications of the position under 1 and 3. You can get into your proposed qualifications of a hypothetical position under your clause 4. But the qualifications under question 1 and 3 of this position is not relevant to the scope of that inquiry for those two questions.
Just so I understand Your Honor's ruling, we could present evidence on the ideal qualifications of a physician that needs to place a central line, but not what qualifications that an individual might have that
Well, your proposal
TUC hires
is a central line by a licensed physician that's qualified, so I expect you to put on the first line without that.
But we can't ask Ms. Thomas what those what TUC considers qualified? Is that,
Yeah, I think that's all on the table. You could do that by independent evidence, but the qualifications of the physician that TUC actually uses is not relevant. So the one, but I'm not totally cutting you off, but it's a fine nuance.
I understand.
You got a proposal, and I'm gonna let you make your proposal, put on the evidence about that proposal, but the fact that your proposal may not be in effect now, as we're very, except it was in effect, you would be asking for it, I guess.
Can we turn to page 12 of the protocol? You there, Ms. Thomas?
I am.
Okay, can you read what that second heading is?
Second, as in monthly practice sessions.
Yes, ma'am.
Okay.
Can you describe your role in the monthly practice sessions?
I observe practice, I monitor the training to make sure all participants are there, and I oversee the practice.
Does the IV team participate in those practices?
They do.
Does the IV team, do they practice in any other way beyond these monthly practice sessions?
I don't understand your question.
Beyond the monthly practice sessions authorized by the protocol, does the IV team have any type of specialized practice?
I can't answer that. Don't know. I don't know.
Can you read right above where it says monthly practice sessions? Can you read number 2 right there?
At least annually, the warden or designee reviews the protocol in its entirety with the execution team. This review is documented.
And Ms. Thomas, are you involved at all in that process?
I am.
When was the last time that this protocol was reviewed?
Last year, as indicated in the protocol, annually at the end of the year.
I'd like to pull up the declaration you filed in this case.
Okay.
Do you have that in front of you? Can you see it on the screen, Ms. Thomas?
Yes.
Okay. Can you read paragraph 4 for me?
In my current position, among other duties and responsibilities, I am responsible for several aspects of TDOC's lethal injection execution protocol, including overseeing the transport and observation of inmates sentenced to death.
Okay. And in your current position, will you oversee the transport and observation of Ms. Pike?
I will.
Has TDOC made any provision to ensure that female corrections officers will observe Ms. Pike?
Yes.
Can you describe what steps have been taken?
Without being specific, it's the same steps we use for everyone else. We select staff, speak to them, and then we go through a normal process of assigning the work or the transportation as we would do with any other inmate in the transportation process.
Has TDOC made any provision to ensure that female corrections officers will transport Ms. Pike to Riverbend?
We have given thought. All of our staff that work transportation are trained to transport, but we would definitely use female, but that's the extent that I can commit to. We would use female staff.
Do the officers involved in the transport have specific training on dealing with female inmates?
Ms. Pike is housed at a female institution, and we do have female staff trained in transportation.
Is it your testimony that female staff from Deborah Johnson will be transporting Ms. Pike to Riverbend?
That is not my testimony. My testimony is that she's housed at a female institution, so we do have staff who are trained in transportation. But we also have staff that are trained throughout in transportation, the state.
Can you read paragraph 5 of your declaration for me?
TDOC plans to transfer Christa Pike, who is currently housed at the Deborah K. Johnson Rehabilitation Center, to the Capital Punishment Unit at Riverbend Maximum Security Institution no earlier than 24 hours before her scheduled execution at 10 a.m. on September 30th, 2026.
And what does the lethal injection protocol say about the transfer of a female inmate to Riverbend?
What part are you referring to?
We can pull that
please.
back up, Ms. Thomas. I'm on page 6.
I'm sorry?
Well, we're going to pull that back up for you.
Okay.
Page 16. Can you read number 3 there, under 48 hours before execution?
Overseas transfer of female inmates from DJRC to Riverbend Maximum Security.
Thank you, Ms. Thomas. I'd like to mark the next set of documents as Pike Exhibit 3.
I'm ready, Coach. Sure.
those up, Ms. Thomas. Your Honor, can we just have a second?
Let's take a short recess. I'm not going anywhere. We're going to recess.
Your Honor, if we want to go back on the record, I think we'll move on from this exhibit. We're back to it. That's okay. Ms. Thomas, we're having some IT troubles here, so we're going to move on from that exhibit if that's okay with you.
Yes.
Can you, going back to your declaration, can you read what paragraph 6 says?
TDLC will make every effort to assign only female staff to observe Ms. Pike while she is housed at RMSI.
Good. And what efforts has TDOC taken to ensure that Ms. Pike will be observed by female corrections officers?
As I previously testified, we identified female staff that, much like we do with the male staff, and we have identified female staff that we will utilize.
Do you know how many officers typically work an observation period in the CPU?
I don't.
Do you know how long each of those shifts are?
I don't.
Do you know how many female corrections officers are employed by Riverbend Maximum Security Institution?
I don't.
Do you know how many female corrections officers are employed by TDOC?
I don't.
Are you familiar with the PREA? PREA?
Are you referring?
Objection, Your Honor, I'm not sure what the relevance of the Prison Rape Elimination Act would be in this particular context.
Well, I confess ignorance. What is it that you're asking?
The Prison Rape Elimination Act requires female inmates to be observed by female guards. It's got certain requirements about who can be involved in that process, and I'm going to ask Ms. Thomas about her understanding of that law. Basically, her declaration is basically stating what the law already says.
Your Honor, if they wanted to bring a PREA case, they could. This is about whether or not there's a constitutional amendment or a constitutional injury that's occurred. Here we put in a declaration of this is what's going to happen. I'm not sure what the impact of PREA could be on all that.
What is the impact?
Your Honor, there's a 2023 audit report by the Tennessee Department of Comptroller of the Treasury that found certain violations by TDOC with PREA, and so I'd like to ask Ms. Thomas about that as it relates to the staffing of Ms. Pike's case.
Yeah, I think that's irrelevant. I'll just leave that.
Can you read number 7 of your declaration?
Ms. Pike will be the only inmate in the capital punishment unit during the entire time she is housed at RMSI.
To your knowledge, are there usually inmates housed in the capital punishment unit outside of executions?
No.
Can you read number 8 for us?
In addition, a privacy screen will be available while she is housed at RMSI.
Can you explain what a privacy screen is?
It's a screen that affords privacy.
Do the male inmates transferred to the capital punishment unit get access to a privacy screen?
They do.
Why would Ms. Pike need a privacy screen if she's being observed by female officers?
The privacy screen affords a person a degree of privacy when they are using the restroom, or taking a shower.
specific medical conditions of the inmate that's scheduled to be executed?
We do.
Does TDOC implement any sort of additional practices regarding those inmates' specific medical conditions?
Where appropriate, yes.
In what situations is that appropriate?
I confer with our clinical staff, and based on the information provided, if there's a need to make adjustments or some type of accommodation, we do.
Has TDOC ever made an accommodation for an inmate scheduled to be executed based on their specific medical conditions?
It's not based on their specific medical condition, it's based on the information that's provided to me by our clinical providers.
Have you or TDOC conducted any assessment about Ms. Pike's specific medical conditions?
I have consulted with our clinical providers about her, any type of medical condition that would have an impact on our execution process.
Has TDOC taken any steps to implement changes to the protocol based on Ms. Pike's specific medical conditions?
Changes to the protocol, what does that look like, please?
Well, I believe you call them accommodations, so maybe that's the better word.
At this point, we have not.
Do members of the execution team receive any sort of additional training based on an inmate's specific health concerns?
If it's appropriate or recommended by our clinical providers.
Has TDOC ever implemented a specialized training for members of the execution team for an inmate scheduled to be executed?
Rephrase the question, I'm not sure I understood.
Has TDOC ever implemented a specialized training for an inmate's specific medical conditions for someone that's scheduled to be executed?
Yes.
Have you or TDOC had any discussion about an inmate's psychological history or mental illness prior to an execution?
Yes.
Have you had any discussions about Ms. Pike's specific psychological history or mental illness and how that may affect her execution?
Yes.
Do you or TDOC evaluate alternative methods of execution?
You may need to clarify. If there is an alternative electrocution, or you talking about other than that?
Ms. Thomas, I'll clarify that question. When an inmate proposes a specific alternative method of execution, do you or TDOC evaluate that?
No.
One second. Ms. Thomas, can you see, is that how you share it?
I'm sorry?
I'm sorry, we're dealing with some IT issues here.
Okay.
Can you see on the screen, Ms. Thomas?
I can.
And I believe we marked this as Exhibit 3. I'm going to ask my paralegal to turn to page 56. Do you see this page on your screen, Ms. Thomas?
Yes,
Have you ever seen this document before?
yes,
Is this document part of the Tennessee Lethal Injection Protocol?
yes.
Can you tell me where to find this document in the Tennessee Lethal Injection Protocol?
They're post orders for the staff that work the post. I really can't tell you where to find it, but they are part of the protocol.
Would you like us to pull up the protocol, Ms. Thomas?
I don't need it pulled up, it's part of post orders.
I think my question was, where in the protocol is this document?
I can answer that.
Would you agree with me that this document is not in the Tennessee Lethal Injection Protocol?
Again, I can't answer that.
Okay. Can we pull up the lethal injection protocol, please? Ms. Thomas, I'm going to have my paralegal scroll through the protocol. Will you tell me to stop when you see this document, please?
Post orders.
Can you go back to that? Is this the one you were talking about?
They're post orders now. If I don't recall exactly the one you put on the screen, but they are post orders.
Can we go back to that document? Are these the same documents, Ms. Thomas?
Okay. So can you,
Go back to the other.
okay. So go to the one you had. That's different.
Okay. Can we go back to the... Ms. Thomas, under primary responsibility, do you see that there?
I do.
Can you read what that second paragraph says?
Female inmates sentenced to death will be transferred to Riverbend Maximum Security Facility and housed in the Capital Punishment Unit at least 12 hours before the scheduled execution. There are not all, these are not all inclusive duties, therefore staff are subject to other duties as assigned.
Would you agree with me that this document says that Ms. Pike would be transferred to Riverbend 12 hours before her scheduled execution? At least 12 hours before her scheduled execution?
That's what it says, yes.
Okay. Would you agree with me that your declaration says that Ms. Pike would be transferred to Riverbend 24 hours before her scheduled execution?
Yes,
And would you agree with me that the lethal injection protocol says that Ms. Pike would be transferred 48 hours before her scheduled execution?
Yes.
I think that's all I have, Your Honor. That's all I have, Your Honor.
This exhibit 3, you would get back into that later.
What else in there?
It says a lot of things in the paper. The one, cross-examine.
Hello, AC Thomas. My friends over here have already covered a lot of the stuff that I had planned to ask you, so I think I'll try to keep this relatively short. You mentioned that you have been in that role since 2023. Could you describe to me your work history before that?
Prior to coming to Tennessee, I worked just slightly under 30 years, where I retired from the Federal Bureau of Prisons in 2016. Following my employment there, I worked at Core Civic, a private agency, for just over 3 years there as well, just over 3.5 years prior to coming to Tennessee.
And what was your role at the Federal Bureau of Prison when you retired?
I was a warden.
And what was your role at Core Civic?
A warden.
Do you still have that declaration in front of you?
I do.
I don't think that's been marked as an exhibit, so I'd like to mark that as State Exhibit A, and I have a copy of it. Sorry, we do numbers and such, but we do State Exhibit 1.
So let me be clear. It's the intention of the parties to not consecutively number the exhibits for both sides at one time?
Okay.
Or you, each side want to?
I don't know if we really worked that out here on there. Or we do, because that is, okay. So
I
we
guess
have 4.
I guess what I'm asking, have you decided already? If not, we're just going to have one set of numbers.
Okay, that's perfect. Okay. We'll do Exhibit 4. Your Honor. So,
And when you introduce an exhibit to the best extent that you can, ask the witness to give us some kind of indication of what it is.
yes, Your Honor. AC Thomas, do you recognize this document? The declaration?
I don't see it on the screen, but I have it pulled up on mine in front of me.
What is it?
I don't see anything on the screen.
I'm talking about the document I sent you earlier today. The exhibit I sent you earlier.
Oh, my declaration. Yes, sorry.
And I'd like to mark this Exhibit 4. Could you please take your time and read it? Let me know when you've had a chance to read all of the paragraphs.
I read it.
Is the declaration still accurate today?
It is.
Where is Ms. Pike currently housed?
She is currently housed at the Deborah K. Johnson Rehabilitation Center.
And the staff at DJRC, are they men and women, or just women, or just men?
Both.
Is that different from
It is not.
I'd like to touch a little bit on Mr. Heenan talked to you a little bit about observation. Could you describe to me what the purpose of the observation period is and the continuous observation laws?
Continuous observation documents activity of the inmate over a period of time. Their recreation, their eating, their property, their reading, any type of activity in the cell. But in addition to that, the recreation, showers, visits, etc.
And why do you all do that observation and keep those laws?
We do it, we do that, it's actually a ACA standard when a person is in a continuous lockdown status. It's a standard that the American Correctional Association requires that we document it. And it's also good correctional practice in my over 35-year history. I honestly don't remember not using that form, a similar form for a person that's in continuous lockdown status. It documents activity, it allows for staff who visit those areas, leadership, medical, mental health, unit team, correctional supervisors to be able to review the document to see what's going on, making sure that we are all observing what's going on while the person is in that status.
And the observing officers, what are the observing officers' responsibilities when they're performing that task?
To observe the inmate, to be able to respond to any direct request, to have one-on-one observation during that period of time and document it.
Are they observing any other inmates at that same time?
No, it's one-on-one, no.
So there'll be no other inmates at RMSI near Christa Pike when they're doing that observing?
That is correct.
I'd like to change tracks a little bit, talk about the IB team. Mr. Greenan asked you a bit about the licensure for those folks, and I just wanted to clarify that specifically. Do all members of the current IB team meet the qualifications described in the protocol?
They do.
Okay. And without giving any identifying information or anything that could reasonably lead someone to discover who those folks are, do you know if those individuals' current occupations involve IB access?
They do.
And again, not identifying years of experience exactly or anything like that. Do you know roughly how much experience all of these individuals have in providing IB access?
I would say decades.
Decade. Each of them has decades?
Yes.
Okay, I'd like to talk a little bit about the process of establishing peripheral IB access. Do you know how many needles are in the execution room?
Yes.
How many?
4.
Do you know what the size of those needles are?
I do.
What are they?
18, 20, 22, and 24.
Since your time as Assistant Commissioner, are you aware that whether the IB staff has ever requested different size needles on the cart?
I'm not aware of that, no.
Is there a 23 gauge butterfly needle on the cart?
There is not.
Okay. Mr. Newman also asked you a accommodations made to folks who would have an execution upcoming. Without revealing any identities, could you just describe the process that you described for how you find out whether an accommodation will be made for a physical or mental ailment?
I reach out to clinical professionals and confer with them. They review the medical record, and then we have a discussion of whether or not they're, in their professional opinion, that anything that is in their record would have any type of impact on our ability to carry out an execution.
And I think I heard you testify this, but I wanted to make sure. Have you followed that process for Ms. Pike?
I have.
And from those conversations, are you making any accommodations on the protocol from those conversations?
Not at this time, no.
Could you tell me what a post order is?
Post orders are a general guideline that gives correctional staff an idea of what things we would like for them to accomplish during their shift.
Okay. Who has the ultimate authority over when Pike is transferred?
Ultimate authority would be the commissioner.
I'd like to also just briefly touch on the alternative forms of execution that Mr. Eden brought up. Since you've become assistant commissioner, has TDOC ever considered hanging?
No,
Do you know if TDOC has anyone on staff with experience carrying out judicial hangings?
not that I'm aware of.
Do you know if TDOC has the equipment to carry out a judicial hanging?
Not that I'm aware of.
Has TDOC ever considered using 23 gauge butterfly needles?
No.
That's all the questions I have.
Ms. Thomas, you just testified that Ms. Pike is currently supervised at Deborah Johnson by male and female corrections officers, is that correct?
I don't think I said that.
Okay. Do male and female corrections officers currently work at Deborah Johnson, 3 locations?
Yes,
Is Ms. Pike currently observed 24 hours a day at the Deborah Johnson, 3 locations?
I don't know.
Can you explain what continuous lockdown status means?
Continuous observation?
So your testimony is that continuous lockdown status means continuous observation?
Will you repeat your question, please?
You testified that inmates on continuous lockdown status receive one-on-one observation. I'm asking you to explain what continuous lockdown status means.
Continuous lockdown is, again, an American Correctional Association term where people are removed from the general population and does not have free movement throughout either the facility, the unit, or the area where they're housed.
Is continuous lockdown status different from solitary confinement?
There are differences.
Can you explain what those are?
Solitary confinement is an old term, it's an outdated term. It's called restrictive housing today, and restrictive housing has several different forms. There is a punitive side of restrictive housing, and there is an administrative side of restrictive housing. So you have two different forms of restrictive housing.
What is the punitive form?
Punitive is when a person has gone through a disciplinary process and sanctions of punitive confinement is imposed by a hearing board member or team.
Do those inmates receive one-on-one observation?
Some do, some don't.
Are those inmates limited by their break time, their ability to leave their cell?
Your Honor, I'm gonna have to object. I think we've gone, the protocol has specific conditions. Whether or not other folks in the prison have those specific limitations, I don't think is relevant. Whether or not there's a constitutional violation to what the protocol requires. I think comparisons to other inmates is not helpful in that analysis, and I don't think it's relevant.
I'm not making comparisons to other inmates, I'm making a comparison to what she's testified to as continuous lockdown for death row inmates in solitary confinement. We had both agree about that. Ms. Thomas, what is one-on-one observation? What does that entail?
One-on-one, respectfully, is exactly what it says. One person, a staff member and one inmate.
And is that the status of inmates that are moved to the capital punishment unit?
Yes.
Can you tell me how you verified that members of the IB team have decades of experience?
Spoke to them, and their records indicate, based on the Tennessee Department of Health, their dates of initial certification and licensure.
You said you speak to clinical professionals before making any decisions about execution accommodations. Is that a fair representation of your testimony?
Yes.
Are those clinical professionals employed by the TDOC or are they outside?
The person whom I speak to are clinical staff that works for TDOC.
Was it multiple people or just one? You testified there was professionals earlier.
Depends on, I've spoken to more than one person.
Nothing further. Anything else?
Thank you, ma'am. I think they're willing to let you go now.
Thank you, Your Honor.
Anybody need a break? Our next witness.
Your Honor, I'd like to call Warden Kenneth Nelson.
This is going to be about prison.
Yes.
And what was the name again?
Warden Kenneth Nelson.
Yes, sir, I can.
Swear in now.
Little small detail. Raise your right hand, sir. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir.
Good morning, Warden Nelson, how are you?
Good morning, sir. I'm doing well, thanks.
And I said this to Ms. Thomas, but the camera is in front of me, but you're over here, so I may be looking both ways. So I apologize if that's a little confusing.
Yes, sir.
Can you state your full name, title, and your current position?
Yes, sir, it's Kenneth Joseph Nelson. I'm currently the warden at Riverbend Maximum Security Institution
And how long have you held that position?
since June of 2024.
And where were you before that?
I worked for 6 years in the South Carolina Department of Corrections.
How many executions?
And
I'm sorry. How many-
Sorry, prior to that, I retired from the New Jersey Department of Corrections after 25 years.
How many executions have you overseen as a warden?
4.
How many executions have you participated in?
4.
I'd like to pull up the lethal injection protocol. This is our exhibit 2, I believe. Warden Nelson, can you see that on the screen?
Yes, sir.
Are you familiar with this document?
Yes, sir, I am.
Can we flip to page 9, please? Okay, Warden Nelson, I see your name listed there, number 2. Can you tell me which of these teams you supervise?
So during the process, I would supervise the entire process as it goes. So I would say most of them.
And do you select any of the members for these teams?
The only team I select is the escort team.
So you do not select members of the IB team?
That's correct.
Do you supervise members of the IB team?
I do not tell them how to do their jobs because I don't have that technical expertise.
Do you know what type of training the members of the IB team receive?
I do not.
Are you involved in any way in the training that the IB team members receive?
I am not.
I'd like to turn to page 36 of the protocol. Can you read what that says at the top there, Warden?
Specific post orders, restraint team.
And under primary responsibility, can you read what it says there?
Objection, relevance. The restraint team is not relevant to any issue before the court.
There's some relevance there.
Your Honor, this goes to issue 2 regarding Ms. Pike's time at Riverbend. How should be observed in the county punishment unit? How should be removed from her cell and strapped down to the very prior to execution?
Question number 2 was focused on her movement to Riverbend and her observation for 2 weeks. They wanted me to talk
may in fact be relevant to your underlying litigation down the road, but the court directed me to two specific things to look at. And beyond that, it's not appropriate to answer these questions, is what I'm trying to say.
Warden, do you know how many female corrections officers work at Riverbend?
I do not.
To your knowledge, has TDOC made any provision to ensure that female corrections officers are assigned to Ms. Pike when she's transferred to Riverbend?
Are you talking about the transfer of her from DJRC to Riverbend?
I'm talking about once she is at Riverbend.
Yes, I know there's steps being taken to have female officers observe her.
How many officers work in the capital punishment unit?
Are you talking about during the 48-hour observation, sir?
Yes.
It would be 4 individuals at a time,
And how long are those shifts?
12 hours.
Is the capital punishment unit separate from Unit 2 where the death row men are housed?
It is.
Is the capital punishment unit used for any other purpose than executions?
It is not.
Outside of executions, are there ever any inmates located in the capital punishment unit?
No, sir.
Warden, I'm putting an exhibit on the screen. You see that there?
Yes.
And,
The copy you gave me has no page numbers.
yeah,
I just looked for 30 minutes for your last piece.
I can pull them out for you.
That's all right. I found it.
We talked about this with Ms. Thomas. I'd like to go to page 56. Have you seen this document, Warden?
Yes, sir, I have it.
To your knowledge, is this document in the protocol?
It is not.
Do you know why that is?
I'm going to object.
No, I do not.
I'm going to object to the relevance of this line of questioning. Whether or not a document is in the protocol speaks for itself, and this issue is not relevant to the issue before the court.
Well, he's just asking him to state the obvious. I'm going to overrule it, but I don't know where he's going with this. So I'm not forbidding you from making another objection if he goes too far, but the fact that it's not in the protocol, it is.
Warden, can you read what it says under equipment?
In addition to accounting for your assigned key ring, radio, and handcuffs, ensure you have your post logbook and a supply of CR 2857 forms to document showers, recreation, meals, telephone calls, visitors, and any other non-routine activities. For this post, a handheld metal detector, handcuff key, and grill door key is required.
Can you explain what a CR 2857 form is?
I believe that is the continuous observation form.
Can you go one page?
So let me interrupt just a second. So is this what is going on during the 48 hours or the 14 days?
The capital punishment unit is the 48 hours.
So they have a telephone in the cell with them?
I'm not sure.
And visitors? And recreation? I got the impression that you were trying to say they were like in some kind of solitary confinement, isolated from the world.
Your Honor, I read this to say that the forms document those things, not that the individuals necessarily have.
Okay, that's just the subject for the parties to deal with. Go right ahead. What is, and you were asking about that point.
Yeah, Warden, is this CR 2857 form?
It is not.
What type of form is this?
That is what I thought was a CR 2857. This is a monitoring report for behavioral health is where it's generated from.
Okay, under primary responsibility on this page, can you read what it says there?
The post commences 48 hours before scheduled execution. You have the responsibility of continuous direct supervision of the inmate while he or she is housed in a holding cell in a capital punishment unit in preparation for his or her sentence being carried out. You'll be positioned immediately outside of the inmate's cell with a direct line of sight inside the cell. Female inmate sentenced to death will be transferred to Riverbend Maximum Security Facility and housed in a capital punishment unit at least 12 hours before the scheduled execution. These are not all-inclusive duties, therefore staff are subject to other duties as assigned.
So, Warden, does this section apply to female inmates as well?
It would, yes.
And can you explain what continuous direct supervision means?
So the officer is positioned outside the inmate's cell. They have to have a constant visual sight of the inmate and to observe all their activities.
You see that on your screen, Warden?
Yes.
Okay. I'm looking at where it says allowable in-cell items. Can you read the sentence starting with shaving items?
I'm going to object to relevance again. What's allowed in cells, not relevant at all to any issue before this court.
I don't know, go ahead, I don't know what's allowable or not. If I knew, I could maybe rule, but I got no clue.
Starting with shaving items, Warden?
Shaving items will be issued. However, you must be supervised at the designated time prior to the execution. Females may have feminine hygiene items as needed.
You can
Upon
stop.
completed use of returnable items, they must be retrieved from the inmate. Requested items not identified above must be approved by, then it's blacked out, and documented.
Okay, Warden, if Ms. Pike needed to shave for any reason, would she be allowed to do that?
Yes,
Does Riverbend have female staff capable of supervising that pursuant to this instruction?
I'm not sure why a female officer would have to supervise her shaving, but yes, we have plenty of female staff here.
Does the sentence say that use must be supervised?
Yes, it says you must be supervised.
Do you know if Riverbend has feminine hygiene products should Ms. Pike need them?
I'm not sure.
Can you read the next page? Can you read what number 4 says?
Document inmates' actions that are not indicated on the observation record log in the post logbook.
What is the difference between an observation record log and the post logbook?
Well, every post is required to have a logbook where you document the daily activities in the unit. The constant observation form is more for the individual.
Can you turn to page 111? Or would this be an example of a post logbook?
Yes, sir.
And we've already looked at a sample of this form, but I want to talk about it real quick. So I'm in the middle column. Looks like the date is 8-1-0800. Do you see that, Warden?
Yes, sir.
And would that be August 1st at 8 o'clock a.m.?
Yes.
And there's an activity code there. Can you read what that says?
It's a little blurry, but it looks like 19.
And does that correspond to an activity code listed above?
Yes, it says talking.
Can you go 3 lines down and read what that entry says?
It looks like 820 something, I can't see it, it's kind of blurry. And it says 1, which is other, and then it says he's showering.
Object relevance again, the question is whether or not male or females will be observing Ms. Pike, and parsing this form has nothing to do with that.
I'm assuming you're introducing a form that shows the type of observations that are made typically for men.
That's correct, Your Honor.
I'll let you do that, but realizing that observations for men might be different from observations for women. More importantly, you handmade an exhibit 3, a bunch of other records. How many pages is in that exhibit? 153. The hard copy doesn't have any pages on it. And I just spent 30 minutes trying to find the one piece of paper that you talked to. One of the witnesses. I can envision the Tennessee Supreme Court as they're trying to understand this record, being quite frustrated that they've got to spend 30 minutes going through 158 pages to find one page. Our exhibits, if you're going to introduce a massive exhibit and call attention to individual pages, there's different ways we can handle that. One would be if you kind of mark the total exhibit with page, sequential page numbers. The other way you could do it, I guess, would be to introduce the whole thing and then individual pages separately, just to highlight them for the convenience of everyone trying to review this record. They're going to have to review this in a very short period of time. I don't think we need to have them searching through 158 pages to find one somewhere in there. Anticipate we'll have, I'm mentioning this now because we're probably going to have a number of exhibits coming up. Let's be conscious of the fact that we have to have a way for them to be referenced in some kind of logical way. That being said, I'll overrule the objection and let you show what they do to observe in it.
Thank you. Warden, is there a shower in the capital punishment unit?
There are showers in each of the cells, yes.
Okay. And how is that observed?
The officers are on the outside of the cell observing them through the bars.
Warden, have you had any conversations with Ms. Thomas or any of the TUSC officials about the staffing for Ms. Pike's execution?
Yes, we've talked about who's going to staff the observation.
Have you engaged with TUSC about any of Ms. Pike's specific medical conditions?
I have not.
Have you or any members of the IB team received specialized training about any medical conditions?
I can't answer for them. I have not received anything.
Have you made any assessment about Ms. Pike's difficulty with blood draws?
No, I have not.
Have you been involved in any discussions about contingency plans on a placement situation?
No, I have not.
Have you been involved in any discussion about an inmate's psychological history or mental illness?
No, sir.
Have you been involved in any discussions about Ms. Pike's specific mental illness?
I have not.
Warden Nelson, thanks for being with us. Can you hear me?
Yes, sir.
So as warden, you testified earlier that you are present during executions, is that right?
Yes, sir.
In your role as warden, do you give any consideration to the inmate's experience during the execution process?
I don't understand the question.
Sorry, that was a bad question. As warden, do you give any consideration to the inmate's comfort during the execution process?
Yes, we do.
Why do you do that?
So when it comes to the inmates like showering, using the toilet facilities, we have privacy screens that we put up so they're not uncomfortable. One of the inmates has medical conditions, so we have hospital beds in place for that. And then just any reasonable accommodations we'll look at and discuss it with central office.
And thinking in particular about procedures in the capital punishment unit during the execution, do you take into account the inmate's dignity?
We do.
How do you do that?
Just by being professional, by understanding what they're going through, treating them with dignity and respect during the entire process, helping them where we can, facilitating visits for them.
As far as you know, has the department ever done anything during an execution to purposefully increase pain?
No, sir.
And as far as you know, has the department ever done anything during an execution to purposefully increase psychological distress?
No, sir.
Now, you mentioned accommodations. Do you personally receive accommodations requests from inmates related to executions?
Mostly from their attorneys, we received them.
And has Christa Pike requested any accommodations?
Yes, there were some religious accommodations that she's requested.
And were those granted?
Yes, numerous ones were granted.
Are you aware of when Ms. Pike is going to be transferred to Riverbend?
No earlier than 24 hours prior to the execution.
And will she be under observation at Riverbend while she is housed there?
Yes, sir.
Are you responsible for that observation?
Yes, sir, I am, as well as picking the individuals who conduct the observation or putting together the schedule for the observation.
Will any male staff observe Ms. Pike while she's housed at Riverbend?
The agency's goal is to put all female staff back there.
Now, you testified a minute ago that there are 4 people at a time working in the capital punishment unit during observation. Is that correct?
Yes, sir, during the 24-hour observation, there's 2 officers assigned outside the inmate's cell, 1 officer inside a control room, and the 4th individual is a supervisor in charge of that detail.
And of those 4, how many are responsible for the observation that you described?
So the 2 officers are responsible for the documentation and conducting the observation.
I don't think he answered the question. Can you ask it again?
Yes, the question, Warden Nelson, was of those 4, how many are responsible for that, the observation that's described in the protocol?
Well, they're all responsible for it. I apologize, I thought you meant who is required to document and be the individuals constantly observing them, but it's a team effort.
And is it your testimony that the department is assigning females to that role?
Yes, sir, that's the goal.
How many methods of execution can be carried out in Riverbend?
2, lethal injection and electrocution.
And why those 2?
Those are the only two approved by Tennessee law.
Can any other method of execution be carried out in Riverbend?
No, sir.
Are you aware of hanging as a method of execution?
I have heard of it, yes.
And your opinion is more than could a hanging be carried out in Riverbend
No, sir.
or not?
We don't have the equipment to conduct that execution. It's not approved by Tennessee law. And just logistics, we wouldn't be able to support that.
To your knowledge, does the department employ anybody who has any expertise in execution by hanging?
None that I'm aware of.
Do you even know where the department could find such a person?
I do not. I'm not aware of any states that conduct executions by hanging anymore.
Are you familiar with the IB team that takes part in executions at Riverbend?
Yes, sir.
Have you seen the equipment that they use?
Yes, sir.
Do they use needles to place IVs?
Yes, sir. They have 4 different size needles that they utilize, 18, 20, 22, and 24 gauge needles.
Do you know what a butterfly needle is?
I do.
Does the IB team ever use a butterfly needle as part of
No, sir.
executions?
Sorry, no, sir.
Those are all my questions. Thank you, Warden.
Warden, you testified that there are 4 officers in the capital punishment unit. Is that correct?
Four staff members, yes, sir.
Staff. And 2 of those staff are responsible for observation. Is that correct?
Yes, sir. The 2 that are outside of the cell are required to document their findings, their observations.
And I just want to clarify your testimony. Is the plan for Ms. Pike that only those 2 members will be female, or that all 4 of those staff will be female?
It's my understanding all 4 of them will be female.
Anything else of this witness?
No, Your Honor.
All right. Thank you, sir. We're through with your testimony.
Thank you, sir.
So, lawyers, what do you want to do about lunch? Well, no, Is it 30 minutes?
45 minutes.
No, 30 is fine with me. I've just never had a lawyer ask for 30 minutes. I brought my lunch. Everyone, is 30 minutes enough? I can make it longer.
We might need a bit longer.
Okay.
Right, we're from out of town.
Oh, yeah, we'll take an hour break. What's the plan for this afternoon?
Your Honor, Suzanne Bales again. One of our witnesses is Maria de Labrado. The state is objective of her testimony. I would like to call her, put her on the stand, and try to establish relevance. If the court disagrees with that, I would like to make an offer of proof of her testimony.
Well, it depends on what, your offer of proof depends on what she testifies to. You can get close. It's not even close. I'll address that. I assume you want her to, what do you testify?
Your Honor, she's going to testify to what the isolation unit looks like, where the inmates held. She's going to testify to the extraction process, the process of strapping the inmates' arms down, which is relevant to IV placement. And then I would like for her to testify to the previous attempted execution, the IV team's efforts to place the lines, and also the execution team's efforts regarding the super line. And I understand the court
In
earlier.
that execution that I said wasn't relevant.
Yes, I understand, so I would like to make an offer, make an argument as to why that's relevant.
Well,
and make an
I
offer.
guess, is she available?
She is, yes.
I understand if she is going to testify or not, you want to get her on the road. So we'll take that right after lunch.
Okay, thank you, Your Honor.
But what else, I mean, what do you, that's going to be your anticipated next week.
Yes, and after that, we have an expert witness, Dr. Nick Warner.
You think she'll take the rest of the afternoon?
Partly depends on how extensive the cross-examination is. We do have another witness available after her if we get to that.
Okay. And how late do you lawyers want to work?
We would like to get this done as quickly as possible, so we're willing to go late if we need to go late.
Well, we'll just see where we are at 5 o'clock. We'll work at least till 5 o'clock or 6. We'll see where we are with regard to the witnesses. If it's we finish the witness and it's a good stopping place to stop. If not, we'll just keep going. But we won't be leaving until 3:30 or 4.
Very well, Your Honor.
Let's see. It's 12:15. We'll be in recess for an hour. See you back.
also relevant to the issue before the court, what the physical facilities are in observation unit. The question is whether or not male officers will be observing Ms. Pike. And so the facility layout, a lay witness's perception of that is not relevant to that issue. Further, they indicated that Mr. Alvarado is going to testify about when Ms. Pike is strapped to the gurney and extracted from her cell. Those also are discrete parts of the protocol and the process that are not in the Supreme Court's order. They have nothing to do with peripheral IV access. The teams that accomplish those steps are not the IV team, as stated in the protocol. And so there is no relevance to get into that would be outside the scope of the Supreme Court's order. And finally, they indicated they would like to make an offer of proof about Mr. Liberado's testimony about Tony Carruthers. We would argue that that's procedurally improper. The whole point of an offer of proof is to preserve the issue for appeal. The Supreme Court's order did not indicate that there's going to be an appeal to evidentiary issue in this hearing. They're free to make arguments in their proposed findings of fact and conclusions of law, as well as any objections they might want to make after this hearing. But to make an offer of proof would be a waste of time, and especially when it's outside the scope of the court's order, and on a topic the court has already ruled is irrelevant.
So the three topics that you want to get into are?
Your Honor, I'd like to let Ms. elicit testimony about the isolation cell where Ms. Pike will be held immediately before her execution. I'd like to offer testimony about the extraction process and then strapping her down to the gurney. And I'd like to offer testimony about the numerous IV attempts and Mr. Carruthers' attempted execution, as well as the central line issue in that attempted execution. And I'm prepared to argue the relevancy of each of those, point by point.
Tell me how the layout of the rooms.
Your Honor, it's not necessarily the layout, in terms of diagram. It's what the isolation cell, the remoteness of it is relevant to the claim 2 that is in front of the court. We're talking about a woman that has PTSD and the trauma, and we need to establish the appearance of that area where she will be held. And relevance, I'm sure the court...
I'll allow that. That part of the testimony.
Thank you, Your Honor. I'd like to elicit testimony about the extraction process, which involves 4 guards approaching Ms. Pike and physically picking her up and placing her on the gurney. And that's relevant also to claim 2.
So let me interrupt you a second. I understood the protocol. This woman could not have seen that process. Unless I misunderstood the protocol.
I believe the attorney is usually allowed to go with the extraction team. But if she hasn't seen it, then she wouldn't be able to testify about it. It would be limited to her first-hand observation.
I was led to believe that they came and extracted her, and they were all strangers. And now you're telling me the lawyer of the inmate gets to come with the extraction team.
Your Honor, the attorney does get to go. It may be that a representative from the AG's office does as well. I'm not sure, but
I don't have a clue.
Right.
I'm glad I don't know.
the attorney does accompany or get to go back to that area where the extraction occurs.
Go back to there while they're extracting.
Yes.
And the attorney is there in the execution chamber.
Yes, yes, Your Honor.
And
She
the
is.
attorney is there when they're actually strapping her to the chair.
Well,
I thought there was a curtain and everyone was escorted from the room, and no one saw that. You can clarify all that.
Okay, it's helpful to know what the court
Is
is
she
interested
listening?
in.
She's here in the courtroom. She can clarify all that.
She's going to be remote.
Okay. Well, she can't testify about anything that she didn't observe herself.
Correct.
So we'll see whether she observed anything when you get on there. And the third thing, clearly ruled that that's not appropriate, and you want to make an offer of proof.
I do, Your Honor. And I understand the state has argued that this issue is foreclosed by Hines, but the Hines case is actually on appeal before, or is seeking cert from the United States Supreme Court. It is still an active issue, and all of these cases end up on appeal. So we do need to make an offer of proof on that issue to preserve the issue.
Well, as she submitted a declaration, I'm trying to think of some way that you can give an offer of proof that doesn't require retractive evidence. And I wanted, let's make an offer of proof, but if we make an offer of proof about everything that I rule out in this case, in excruciating detail, and so some of these people, their inadmissible stuff, we could submit declarations on, assuming the state doesn't want to cross-examine the offer of proof. If they want to cross-examine an offer of proof, we kind of have more offer of proof.
Your Honor, there is a detailed declaration that Ms. De Liberato prepared, and we would be happy to submit that for the ID access issue and for the central line placement. I don't believe it's in her declaration, the extraction process.
We'll get to those two. I'm going to let her talk about the layout and what the room looks like and all that stuff. And I'm not sure what she's saying that she hasn't.
And we'll address that.
But the others, is the state okay with the declaration being offered proof? Now, the one thing about that is it doesn't allow you to cross-examine.
Right, Your Honor. I will point out that Ms. De Liberato did file a declaration in the Hines case, as I stated earlier. And as I understand it, she'll be talking about most of the similar things she talked about in that declaration. And it's worth noting again, the Tennessee Supreme Court considered that declaration, still denied Hines' motion. And while, that may be on appeal, that is binding precedent on this court as of today. So, and again, the issue too is focused on, in this order, whether males are going to observe Ms. Pike every week. Her extraction, which by the way, Mr. Liberato would only be testifying about Carruthers extraction, which is what she saw. So to the extent she's going to do that, that's going to be irrelevant under this court's prior ruling. But the extraction, the layout of the facility, none of that's relevant to whether a man is going to observe Ms. Pike.
Well, don't I have to consider the extraction, the layout of their proposed facility for the hanging?
There's already been testimony on that. Again, these are issues that they could have elicited testimony about from two people who work for the Department of Corrections.
I mean, they can choose whoever they want to put their evidence up, but they don't have to put it on. I mean, you can't control who they call as their witness, even though they may all have some knowledge. But I have to make that comparison between how this execution is going to look with a hanging. And so what room is she going to be in during the hanging? Who's going to, the officers, are they going to come get her and tie her up in the hanging? And I don't know what proof they're going to put on about how this hanging is going to look, but I have to compare how they're going to say this hanging is going to look with how this lethal injection is going to look. And so I'm assuming they're going to tell me what the room that she's going to be in prior to the hanging looks like. So I'm going to make those comparisons. So I'm going to let them, I'll let you talk about the physical layout. Let's see what she actually knows. But the other will be considered an awful proof unless you're willing to just let them do. I think they're willing to do her declaration. But in order for that to be the offer of proof, you have to give up cross-examining her. It's attempting. So I'll let you make the call. If you want the offer of proof to be oral,
That'll be verbal.
Verbal. All right, so I'm gonna, let's get her here and see what she knows. Can you hear this?
Can you hear us, Ms. De Liberato?
Yes, I can hear you. Can you hear me?
Yes. Your Honor, for clarification, is this?
Thanks for reminding me.
Okay, I
Would you
forgot
raise your
that.
right hand,
There we
ma'am?
go.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
For clarification, is all of her testimony an offer of proof, or just to make sure I understand the court's ruling?
We will, this is her direct testimony right now, and lay the foundation, and we'll see. We're going, I've already identified one topic, and then you were going to try to lay a foundation that she had personal knowledge of the other.
Okay. Introduce yourself to the court.
Yes, my name is Maria De Liberato, and I'm a capital defense lawyer currently with the ACLU.
And did you represent a Tennessee death row inmate recently?
Yes, Tony Carruthers.
Okay. And what was one of your responsibilities in your representation of him?
I was designated as his attorney witness for the scheduled execution on May 21st, 2026.
I'd like to just focus on that day. And by the way, the camera's up there, so I'm looking at you. I know that feels a little awkward. I'd like to start, just focus on the day of the attempted execution. And where were you in the prison when you went back to where the cell extraction occurred?
So I first started my day with the last legal visit from 7:30 until approximately 9. So I was back in the area where Mr. Carruthers was, and then I was escorted back to the front area of the prison. And then myself and Assistant Attorney General were escorted back by the warden to the cell area for the cell extraction process. We had a bit of a false start because the court hadn't ruled. Do you want me to sort of walk through that process?
No, that's okay. So did you see the cell where Mr. Carruthers was held?
Yes.
And could you describe that cell for us?
Yeah, so there's like 3 cells along a wall, and then a catwalk, and then another set of bars, and then a hallway, and a control room that's looking directly into those cells. When someone's on death watch, there's only a single person in that cell, so Mr. Carruthers was in the first cell as you walk right into the room, and he was seated on his bunk with his prayer shawl.
And did you go into the cell?
I did not go into the cell. They had myself and the Attorney General stand in the hallway. I was approximately 10 to 15 feet away, I would say.
Did you, for any of the legal visits there, did you go into the cell?
No, the legal visits were in like an ante-room, sort of just outside the control room in that area where they brought us to have a legal visit in that room.
Okay, so I think that answers the court's question. She saw, or my question as well, she saw the outside of the cell. We'd offer that testimony in support of Ms. Pike's claim too.
Is that all you know?
No, I would just, Ms. De Liberato, let's talk about the extraction process. Can you tell us, did you see the extraction process?
Yes, I did.
And tell us,
I'm going to object to relevance based on what happened with the Carruthers execution and this being part of the testimony that's excluded prior to the court's prior ruling.
I'm going to sustain that objection, but we'll consider the rest of the issue off.
okay, and the objection is it's not relevant to claim 2, Your Honor? Okay. And I think I stated earlier, we believe it is relevant because it goes to the trauma and the PTSD claim, and whether there's, and whether that extraction process will be the cause of serious illness and needless suffering.
So, what you're saying is it caused trauma to Mr. Carruthers, it caused trauma, it's going to cause
I'm saying is that I think we need to understand how the extraction process is carried out. And we have a witness for how that extraction process is carried out.
We also have the protocol that says how it's carried out.
I don't think it goes into detail about that, Your Honor. It
Doesn't
just,
that mean that protocol with Mr. Carruthers may be different? What actually happens with Mr. Carruthers might be different than what happens with Ms. Pike if the protocol doesn't give specifics. So you're saying that whatever happened to Mr. Carruthers is going to be duplicated with
Your
Ms.
Honor,
Pike?
we do believe that's the case,
Okay.
at least for the extraction process.
Okay, well, okay, I understand. Go ahead and make your offer.
Okay. Could you describe the extraction process that you observed?
Yes, and my understanding is, because I asked, this was my first execution witness in Tennessee. I've observed executions in Florida, which is very different. But this extraction process was informed to me that it was for every single execution. So I was standing in the hallway just immediately outside the cell with the Attorney General. They rolled the gurney in past us from the execution chamber, which was like just kind of directly behind us. Mr. Carruthers was seated, calmly in his cell. He wasn't combative in any way. As I said, he had his prayer shawl on. The warden stood in front of his cell and told him that the guards would be entering his cell. There were 4 to 5 guards, sort of all dressed in black, looked a bit like a SWAT team. And they all stood sort of shoulder to shoulder, kind of with their hands on the shoulder in front of them, and sort of in very loud commands, told Mr. Carruthers they were entering his cell. They ordered him to kneel on the bunk, place his forehead on the wall, and then they restrained him in the cell. And again, this was standard procedure. Mr. Carruthers was not combative in any way. And then they took him out of the cell into the hallway. They were all sort of around him. He was shackled, belly, hands, and feet. They all stood behind him. Again, all these men all dressed in black, and they lifted him onto the gurney, which was in the hallway. And then they strapped him down. It took a considerable amount of time securing all of the straps. Mr. Carruthers' hands were handcuffed, and he remained clasped in prayer while they were strapping him to the gurney. That happened in the hallway, and then after that, they rolled him into the execution chamber, which we followed. Do you want me to continue as to what happened in the chamber with the continued securing?
Yes, continue.
So once they got into the execution chamber, they secured the gurney to the floor, and then they started to put the arms on the gurney, each side of the arm, the left side and the right side, and then they unhandcuffed Mr. Carruthers' hands and then outstretched his arms along the gurney, and then that was, once he was sort of all secured in the gurney with arms outstretched, is when they began the process.
Okay. I'd like to turn to the obviousness that happened. If you want to do that.
Okay, so
If I may,
they
objection
started.
would be-
We have an objection.
The court's invitation for offer of proof, to our understanding, did not include IV attempts on Mr. Carruthers. It included the layout of the facility and restraining and the extraction, and that was it.
Your Honor, I have it in my notes here that I had informed the court earlier that there would be an offer of proof on the IV attempts as well as the central line placement. And before the break, the court found that those areas were not relevant to the court's determination, but that we would come back for an offer of proof. So the court's already said I've already informed the court at least twice about IV attempts and the central line placement.
I'm kind of overruled with objection, because this is an offer of proof, but can you elicit from her? I was led to believe from reading the protocol that prisoner faced off was alone. Prisoner was extracted alone. The prisoner was strapped to the gurney alone. Prisoner was arms were tied to the left and right side alone.
seems to me to be contrary to what the protocol says. And so I'm curious, and then I was led to believe under the protocol that once they're strapped down, that everyone leaves the room except the IV team, and the curtain is pulled, and that the actual attempts at IV were done with the curtain pulled, and that the prisoner was alone. And now I'm hearing the prisoner is not alone. And so, as you make this offer of proof, would you try to clarify some of those things?
Yes, Your Honor. So you, Ms. De Liberato, you went from the area where your client was extracted and then placed on the gurney. And could you pick up again with your testimony there?
Yes, and sort of to clarify and to answer the court's question, again, this is how it occurred in the previous executions to the one I witnessed, because I asked the attorneys for the previous executions exactly what I would be witnessing so that I could be prepared. So this wasn't like an unusual thing with Mr. Carruthers. This is exactly how it was supposed to happen. But I witnessed the entire process. So did the Attorney General. And then the plan was for, once IV access was established, then myself and the Attorney General were going to be led into the room where the media witnesses and the other witnesses were waiting. So they were behind a curtain on the other side. They could hear what was happening inside the chamber, but they couldn't see. So we never got to that point because they were never able to establish IV access. So we stayed in the chamber the entire time until the execution was called off. I can certainly walk through the IV attempts. I've sort of picked up to where we've gotten into the room, if that answers the court's questions and your questions.
Just to clarify, you were in the execution chamber with your client when the IV attempts occurred?
That's right, I was like 5 to 7 feet away from him.
Okay, could you tell the court what you observed?
Yes, so they began trying to insert the IV along his right arm, and it took, I could tell sort of from the beginning that they were struggling to establish access. They were able to get a line in after about 7 or so minutes of trying into the right arm, and then they moved on to the other side. And there were, just to sort of set this stage, there were 3, I'll call them corrections personnel. I assume that's who they were. They weren't dressed in medical gear, but they were the IV team. There was 3 of them. It was two women and 1 man who were attempting IV access.
Objection to naming the genders of the execution participants. This is violating the court's protective order.
We're very.
Oh, I'm sorry.
That's okay. You know what we're trying to prevent, so let's be cognizant of that.
Okay, I apologize, Your Honor. I didn't know that was something I wasn't allowed to say.
Okay, so we're not, specifically, do not identify the gender of anyone in the execution chamber. I don't know that I told you that.
Okay. I didn't know that, I'm sorry. Okay, so the 3 members of the IV team were trying to establish access. After about 7 minutes, they got access in his right arm, and then they moved on to his left arm, and that is when they were unable to get a vein. That took about, it was from like 10:32 to 10:44 is when they were trying to put it in his left arm. And I noted about 6 or 7 sticks. They then, each time a needle was used, they would drop it into the receptacle. And that was a corrections officer who was putting the needles. The corrections officer was handing the IV team the needles and then putting them into the receptacle. And then at one point, one of the IV team members said that they had gotten a flash, but it wouldn't flow. And then another team member said that the line was not infiltrating but not flowing. I noted visible effort on the faces of the IV team member as they tried to gain access, some sort of grunting and pushing. And Mr. Crothers was wincing through most of these needle sticks. And then they moved to his left hand, and that was at approximately 10:48. They tried to get access into his left hand, and then they said it was not flowing, that the IV was not flowing. And then at 10:54, so we got into the chamber at 10:22 is when they were when they started trapping him in. They started IV access at 10:24, and then 30 minutes later, they hadn't yet established an IV, and that is when the physician entered the room.
Did they ask?
Do you want me to continue?
Yes, let me ask the question first. Did they ask the physician to come in, or?
I don't know, so it was, they were not speaking out loud, they were communicating via like hand signals and talking in like very low tones. I could hear them say things about the veins rolling and not access and all that, but they were like communicating via hand signals to like I guess a two-way mirror. So I don't know if one of those hand signals indicated for the physician to come out. I just know that the physician came out.
And what happened when the physician came in?
When the physician came out,
Objection relevance. This has been clearly ruled on by the court. There's no need to offer an improvement.
Your Honor, we could stipulate to her declaration concerning the physician's appearance in the chamber. But I do think we are allowed to make an offer of proof to preserve the record for the Tennessee Supreme Court as well as for the Supreme Court.
How long is this?
It shouldn't be much longer.
Go ahead.
Okay, continue.
when the physician came into the room, I'm just going to use physician so that I don't run afoul of the court's order. When the physician came into the room, the physician instructed the IV team to take off Tony's socks to look for veins in his feet. At 10:56, they took out an infrared vein finder and dimmed the lights so they could try to use the vein finder. At 10:57, the physician said they got a flash, but it wouldn't run, and that was in Tony's feet. I couldn't tell if they actually got the line in his foot or not, but they were sticking him in his feet. And at that point, I asked the warden when he was going to stop this, and he said he would not intervene unless instructed. And at that point, I asked to use the phone. There is a phone in the chamber and in the media room, but they would not let me use that phone. They escorted myself and the Attorney General out of the chamber, so I was out of view of my client. And then I used a phone that was in the cell area where Tony had been. They had to plug it in so that it would work because it was unplugged. And then I was able to contact co-counsel to tell them what was going on because I had a sense that the next potential part was going to be the central line, and I wanted to sort of let them know what was going on. This was obviously something that was going very wrong. So I couldn't see or hear anything that was happening in the chamber for those few moments that I was on the phone. And then I returned to the chamber at 11:06, and the physician and the IV team were still trying to gain access into Mr. Crothers' left foot. Again, Mr. Crothers was wincing and appeared to be in pain. The physician then announced that he was going to place a central line. But before he did that, at 11:09, the physician asked members of the IV team if any of them had experience with jugular access. One of the team members said they did. So then the IV team and the physician undid these chest straps that Tony was strapped to the gurney, and turned his head to the side and then started to feel around Tony's neck. At 11:10, they turned on the lights and brought out the infrared vein finder, again, that they had used on his feet to try to assess his neck. And then at that point, the IV team member who had indicated that IV team member knew how to do jugular access said that he didn't feel like he could do this. And then it was determined by the physician that the physician was going to place a drape over Tony's face and body to do the central line. And at 11:14, the physician asked whether the patient was allergic to lidocaine, referring to Mr. Crothers as the patient. The prison staff didn't know. At 11:15, the physician stuck Tony with the needle and administered the lidocaine just below his right clavicle. They said they would wait 5 minutes for that to take effect. I asked again to use the phone and went back out, and I was out of sight for those 5 minutes talking to counsel, explaining what was happening, and opposing co-counsel let me know that in a previous deposition, the physician had indicated that the physician was not qualified or had hospital privileges to set a central line, and they advised me to object. I went back into the execution chamber, and the physician was standing over Tony. I did object that the physician was not qualified to place the central line. The physician snapped back to me, "Yes, I am too qualified." The warden said, "Doctor, do your job." At 11:20, the physician began poking Tony with a needle in the area where he had administered the lidocaine, which was below his right clavicle. He asked Tony if it hurt. Tony said yes, he could feel it. The physician responded, "Well, it may just be some pressure." And then then after that, the physician proceeded to insert the needle under Tony's right clavicle. Tony began gutturally groaning and said, "It hurts, it hurts." I later learned that this groaning, this sort of moaning and groaning, was audible to the media witnesses that were behind the curtain. I noted about a $50 sized amount of blood. The blood was oozing from the puncture wound, and then the physician would wipe it away as the blood was coming out. I observed at least 2 attempts to insert the needle, so I could see at least 2 puncture wounds. It's possible that there were more, but I'm certain there were at least 2. And the physician tried to thread something into one of the spots where he had inserted the needle. Tony was moaning and groaning in pain this entire time, a sound that I can still hear. It was incredibly vivid and very clearly painful. At 11:22, the physician said they would not be able to set a central line. And then the physician started to try to get IV access into Tony's right shoulder, which was, again, the same arm where the first IV access was. At 11:28, the physician appeared to set a line in Tony's shoulder. I could see blood backfilling the line, so I don't know if it was swelling. Like, it was very clearly to see blood in the line. At 11:30, someone announced that they had flow. At this point, at 11:30, Tony had a line sticking out of his right arm and right shoulder, and there was visible blood backfilling the shoulder line. At approximately 11:34, the warden left the room and then came back, and at 11:40, one of the phones on the wall of the execution chamber rang, and the warden answered. I could only, of course, hear the warden's end of the conversation, but when he hung up, he said we were not moving forward with the execution, and he said now, and I said, does that mean, I didn't know if that meant like right now or today, and he just said not now, and instructed the IV team to remove the IV lines and take Tony back to his cell. As they did that, I could see blood filling the lines. Tony was clearly in pain. And I would say over the course of the process, he was stuck over a dozen times. I asked Tony to be evaluated by medical staff, and then they took him back to his cell, and they took me out of the execution chamber back to the front building, and they said I would be able to see him once he was taken back to like the death watch area, not the same death watch area. He was taken to like back to the unit, but it's still in isolation. And I can talk about what happened when I went back there, but I left for a period of time to the front.
Okay, let's
Good afternoon, Mr. Devereaux. I'm Will Ayers here for the state. I have just a few questions for you.
Yes,
Have you ever set an IV line?
I have not.
Do you have any medical training?
I do not.
I noticed your eyes moving from side to side several times during your testimony. Were you reading from anything?
I have my declaration in front of me so that I could make sure that I was testifying accurately.
But did you disclose that you were reviewing your declaration while you were testifying?
Nobody asked me, but yes, I was looking at my declaration.
Were you looking at anything else?
No,
What other documents do you have in front of you right
that's it.
now? Have you communicated with anyone while you were testifying today?
No.
Those are my questions.
Just quick, redirect, and of course, everything you testified to, you took an oath to tell the truth today, didn't you?
Yes, I did.
And did you tell the truth?
Yes, I did.
No further questions from you.
You concur?
Yes.
Okay, you're free to go.
Thank you.
Your Honor, our next witness will be anesthesiologist, Dr. Van Gorman. And I think if we could just have a 5 or 10 minute break to get her documents and get her squared away.
Can you please stay? swear to tell the truth?
I do.
Okay, introduce yourself to the court.
I'm having a little trouble hearing because there's a breakup at side. Maybe, can you hear me okay?
I can hear you very well. Is this
Okay.
I'm moved over a little bit. Can you hear me?
That's better. Thank you. My name is Gail Van Norman. I'm Professor Emeritus of Anesthesiology at the University of Washington, Department of Anesthesiology and Pain Medicine.
Okay. Let me approach. Dr. Van Norman, we placed a document on your, for you to review. Are you able to see it?
I am.
And can you identify that?
Yeah, this is my curriculum meeting.
And do you want to take a moment and make sure it accurately reflects your educational and professional background?
You would have to scroll through all the pages for me, I think, but yeah, I mean, this represents the first page of my curriculum vitae. I recognize it.
Okay, Your Honor, we move proceeding into evidence.
No objection. All right, we'll mark this exhibit.
Dr. Van Norman, starting with medical school, could you give us your academic or educational background?
Yes, I attended medical school at the University of Washington in Seattle and graduated with an honors MD in after an undergraduate degree in microbiology. After medical school, I did internship and internal medicine residency at Virginia Mason Hospital in Seattle, Washington, and then practiced for several years as an internist in the community before returning in 1986 to the University of Washington to do anesthesiology residency. I completed residency in anesthesiology at the University of Washington, followed by a fellowship in cardiothoracic transplant anesthesiology at the University of Washington, and then went out into private practice for a while, returning to be on faculty at the University of Washington in 1994. I actually remained on what's called clinical associate faculty throughout that time, so I periodically came back to the U to teach residents, but I returned to be on full-time staff. In the interim, I trained in the Department of Bioethics as a bioethicist, and I also became certified in perioperative transesophageal echocardiography. I also had achieved board certification in both of my specialties. In Virginia Mason, in internal medicine in 1984, and in anesthesiology. My memory is 1990, but I think you'd have to flip the page to remind me what the year is. It's getting to be a while ago anyway.
And how many years did you work as an anesthesiologist?
Over 40 years.
And was that mainly in the operating room?
Yes.
As an anesthesiologist, how many times did you place a peripheral IV?
We don't keep track, but the average anesthesiologist does around 30 to 35,000 cases in a career. And in my career, I did the vast majority of my IVs. So it's tens of thousands. It's a large number.
And how many times have you placed a central line?
Objection.
Well, again-
On this issue.
I'm sorry?
Objection based on the court's prior ruling, this issue is irrelevant.
Your Honor, she does talk about the skills necessary to place the central line, and we will offer proof if the court allows on the problems with the ID placement and the central line placement that happened in Mr. Carruthers' execution. But I can offer her qualifications.
Why don't we do this? Why don't we solicit from her testimony that you know is admissible?
Okay.
And then when we get to the stuff about other people's executions that we already know the court has a problem with, then we can talk about those. But it would be much cleaner, I'm sure, assuming qualifies as an expert and whatever she's going to be qualified as an expert, let's get whatever is admissible for sure. And then anything we're debating about, then we can debate about that after you see what you got.
Okay, understood, Your Honor. Her qualifications and experience with central line in her response to objection is relevant, because she's going to talk about the alternative.
You can go ahead
central line.
and get into her qualifications.
How many times have you placed the central line?
Again, I don't have a log of how many I've placed, but based on the number of heart cases I've done as a cardiac anesthesiologist and average OR cases, it's well over 4,000.
In addition to being in the operating room, what other tasks did you take on as an anesthesiologist?
Oh, well, I mean, a lot of them, but I think the ones that are relevant to the qualifications you're talking about here is that I was, for about 10 years or so, in charge of the program that educated and guaranteed the continuing qualifications of all of our providers to place central lines as a part of their practice. So I instructed over 160 providers in our department, attending anesthesiologists, residents, and CRNAs, and also had responsibility for reevaluating their skills every 2 years and either certifying them as competent or referring them back for further training or further clinical experience before we would let them place central lines at the University of Washington Medical Center.
Thank you. Can you explain what an anesthesiology preoperative assessment is?
Well, there are a couple of phases to the assessment. The one that patients typically think of is they meet their anesthesiologist moments before they're going to the operating room, and the anesthesiologist comes and listens to their heart and their lungs and talks about the anesthetic. And that's the day of surgery pre-op assessment. But at most large centers, and certainly at the University of Washington, we have a perioperative anesthesiology clinic where we see patients several days to even several weeks ahead of surgery. And our task there is to evaluate their medical status to make sure that they are prepared and ready to go through surgery, that there aren't some conditions that we need to correct before they go through surgery, that there are some questions that we need to have answered both from them and from their doctors before they go through surgery, and to make sure that we're ready for them to smoothly proceed to anesthesia and surgery.
Okay, very well. Have you been qualified to testify as an expert in anesthesiology before?
Yes, many times.
And have you published referee articles on anesthesiology?
On anesthesiology?
Subjects related to anesthesiology.
Yes, I have 168 publications, most of which are in referee journals over the course of my career.
And have you been qualified as an expert in lethal injection matters?
Yes, I've testified in court on lethal injection matters in the past.
Your Honor, I knew that she admitted to testify on anesthesiology and lethal injection matters.
Yes, I would. I'm also not clear on what's meant by an expert in lethal injection matters.
do was recorded, and that's why I was gonna let you go there and
Let me clarify that. Have you been admitted to testify at a lethal injection hearing? At a hearing?
I'm sorry, you broke up there, and I apologize, I didn't quite catch that.
Okay, have you been admitted or permitted to offer testimony on matters related to lethal injection?
Yes, I have.
you shouldn't ask a question, I'll let you.
Good afternoon, Dr. Van Orn. My name is Will Ayers. I'm an attorney for the state of Tennessee. We appreciate you being here today. Just a few questions for you about your background. So, are you still a practicing clinician?
I retired from clinical practice just a couple of months ago, so up until a couple of months ago, yes.
Okay. Congratulations on your retirement. Hope you're enjoying it.
Thank you, it's been a trip.
So, do you recall roughly when the last time was that you would have set an IV line in a patient?
I'm sorry, it said an IV line?
Yes, when the last time was that you set an IV line in a patient? It doesn't have to be down to the day, just roughly.
It would have been within a month or two of my retirement, so in the last several months.
And you're not a hematologist, right?
No.
You've never managed a patient's condition related to a blood disorder?
Both as a perioperative physician and an anesthesiologist, I've had to manage patients with hematologic disorders with regard to how that disorder affected their anesthesia care. But I'm not a diagnosing physician for those disorders.
Thank you. You would agree that an execution is not a medical procedure, would you?
I would agree with that.
Have you ever worked in corrections?
I have not.
So, do you have any specialized experience in carrying out death sentences?
As a physician, I've not participated in carrying out death sentences, no.
Do you have any specialized experience in planning executions?
As a physician, I'm not ethically allowed to participate in planning executions.
Have you ever been consulted as an expert to help the state draft or revise an execution protocol?
Because that would violate ethical tenets of the medical profession, I cannot participate in forming recipes for lethal injection or other methods of execution.
Oh, just a moment, we had an objection.
Okay, I think we're getting away from her qualifications to testify on medical and scientific issues that are in front of the court today.
Well, you kind of have, I think you have the right to find out why you were introducing her as an expert in lethal injection.
All right, very well.
Yes. Thank you, Your Honor. So, just to clarify for the record, your answer to the last question was no.
I'm just remembering the last question. I'm sorry I got lost, but that's...
The question was, have you ever been consulted as an expert to help a state draft or revise an execution protocol?
Thank you. No.
And if the Department of Correction were to ask you to do that, would you consider it?
I would not consider participating in drafting a policy or procedure for any kind of execution that would violate medical ethics.
Have you ever personally witnessed an execution?
I have.
How many?
I've witnessed one.
Are you personally familiar with the qualifications of any members of Tennessee's execution team?
I have read the Tennessee protocol and what they state are the qualifications necessary. Is that what you mean?
Other than reading the protocol, do you have any personal knowledge of the qualifications that any member of the Tennessee execution team holds?
I am familiar with what the physician involved in Tennessee executions has testified to in court
I'm gonna stop
as
right
his
there because
qualifications.
The court's ruled on that issue, and that's not coming out.
Apologies, you just asked me and
Sure.
yes.
So those are all my questions, and I would like to move to limit Dr. Van Horn's testimony if the court is ready to entertain such a motion.
Let me answer a couple of questions. Maybe I'll make you attempt to clarify. Are you offering her as an expert in anything other than anesthesiology?
Your Honor, she's going to testify about vein access issues, and she is going to testify about a literature review of executions and the fact that lethal injection executions have a lot of problems with vein access. And in the state's brief, they asserted that she's not qualified to testify about neuropsychosis. But
Are you planning on trying to get her to testify about that?
well, she's going to testify.
I'm trying to determine what you are offering her as an expert in and whether she's going to try to testify outside that field.
Your Honor, as far as the neuropsychosis, she has observed that that's a diagnosis in Ms. Pike's medical records, and she opines that people with clotting disorders are at a higher risk for vein access because they have to get blood draws frequently that can damage their veins, and they're at a higher risk of clotting disorders. And that is something that she's managed in her practice. So I feel she is qualified to testify to that.
Okay, so that would be in the field of anesthesiology, is that?
Yes.
So but you said, when you tried to qualify her, you said you were going to qualify her as an expert in lethal injection or something.
Your Honor, I misspoke. What I should have said is that she's been admitted to offer expert testimony in lethal injection proceedings, and that testimony will be about her literature review of lethal injection executions that they're high risk or difficult for venous access for a lethal injection is a challenging undertaking. And she offered testimony in that based on her review of a large number, her literature review of a large number of lethal injection executions.
So what's the statement to say about her testifying based on her literature review? With the understanding that, your expert is going to testify based upon their literature review.
So the state opposes Dr. Van Horn testifying as a so-called expert on execution procedures, which is what she's holding herself out of. Her report discusses what she terms botched executions based on a literature review. But she has just testified that she has never participated in planning or assisting with an execution. She said that that's against her code of ethics. She said that she never consulted on an execution protocol or anything like that. And so there is nothing in her training as an anesthesiologist that qualifies her to opine on whether or not a given execution is botched, or to opine on whether there is a specific risk of complications in an execution setting. As she just admitted, an execution is not a medical procedure. They are not the same thing. And so having no expertise in the field of corrections and prison administration, she's not qualified to opine about execution procedures. The state would also...
Let me interrupt you, just hold your thought this one. Are you going to ask her to testify about execution procedures?
Your Honor, I'm going to ask her to testify about venous access and central line placement, and factors factors that make venous access difficult and factors that are specific to this pipe that make venous access difficult. I'm gonna ask
Well,
her.
obviously, I have no problem with any of that, but I'm waiting for the, and we're gonna ask what else?
And she's gonna testify about what happens if there's a blowout, what can happen if there's a blowout of a chemical like pentobarbital, that it can cause significant burning. And she is gonna testify about the difficulties of,
Wait a second.
yeah.
My understanding is that she's going to testify with any human individual, execution or not execution, there are difficulties in the peripheral IV access.
That's correct, Your Honor. So we feel she's
So, I mean, is
qualified.
that what you want to establish?
Yes, yes, it is, Your Honor.
So why does she need a literature review to tell her what she already knows?
So she's going to talk about Ms. Pike's unique characteristics in venous access. She's also going to talk about the fact that there have been blown veins in other executions that have caused significant burning, and that is the type of risk
Wait a
that,
second, wouldn't there be blown veins in any kind?
well, a situation where the needle either tears or pokes through the vein and the pentobarbital doesn't travel to the heart. Instead, it settles into the tissue, which causes serious injury and also can cause the electrocution, or excuse me, the execution to possibly not succeed or to last a very long time. And she has reviewed a couple of cases where that happened, and that's the type of risk that Ms. Pike faces if there's a blowout in her veins.
I know there's a couple of problems with that. The first being that those issues, the scope of what happens from pentobarbital into the body, is after peripheral IV access has already been achieved. So we're already off the reservation in terms of what the Supreme Court's order is talking about. It's focused on peripheral IV access. We don't intend to contest Dr. Van Norman's qualifications to testify about achieving peripheral IV access or anesthesiology. I think we're on the same page there. But when we start talking about things that happen after IVs are inserted, such as extravasation, which is in the report, that's when a chemical leaks into tissue surrounding it. Infiltration, which is what happens when an IV that's inserted somehow gets misplaced or jostled around and goes through the vein, as you just heard about. Those are things that happen after IV access has been achieved. So those, by definition, are not before the court, they're outside the scope of the order. I'll also point out that, back to the issue of correctional experience, her report goes on for many, many pages about her views of complications in executions, her views on what constitutes a botched execution, what the error rates are for lethal injection. Those are correctional matters, and it's not something that, at least so far, she's been demonstrated to have any professional expertise in as an anesthesiologist.
Your Honor, the issues that are before the court regarding vein access is whether peripheral vein access or the attempts to achieve that are going to cause serious illness or needless pain. And the fact that you can get a needle in somebody's body doesn't mean that you have successful peripheral IV access. So the issue of a blown out vein where pentobarbital flows into the person's body is encompassed within the peripheral IV access issue. So speaking to Tennessee Supreme Court's, to that part of the state's argument. And as far as reviewing the other executions and talking about the percentages of rates, the court is going to be asked to decide is it sure or very likely that Ms. Pike will suffer needless pain. And we think the fact that over 50%
leeway here, but I'm not, number one, I'm going to allow her to testify as an anesthesiologist. She's not an expert in legal injection or executions or anything else. She's done a book report. When I was a child, and I had to do a book report, I went to what we called in those days, y'all might remember, but it was an encyclopedia. And I looked up what was in the encyclopedia and I did my report. Well, was I an expert? And now they go on AI or Google something and do a literature search and report. Does that mean she's an expert? So I'm going to allow some of this, but we're not getting into, she ought to be able, from her expertise, to testify about the pitfalls of what happens without talking about 55 other executions that she's done a book report on.
Okay, we'll limit the risks of blowout and.
I'm not limiting you, whatever's in her field of expertise, but let's try it, like, let's go ahead. I'm going to allow her to testify, but anything she says about, from a literature review, I have to assess what weight. How do you define a botched execution? How does the literature that she reviewed define a botched execution? I mean, we can find statistics that support both sides. In this case, I have no doubt. I have to look at the methodology behind those. If we're talking about somebody that did a book report, with no other expertise in executions, it's a review of the literature, so we'll see. Go ahead. She can, let's start with her testimony. I'm sure she's got a lot to say about the pitfalls of what could go wrong with placing peripheral IVs.
Okay.
Crank her up, and I'm sure he'll pop up if he has a problem.
Dr. Van Norman, can you tell us what peripheral IV access is?
Well, peripheral IV access, as opposed to central IV access, is access in basically the veins of the limbs, the peripheral veins that are not in the pelvis, belly, or heart, or chest. So this, or in the neck, in the jugular vein. So we're really talking about veins that are in the arms and legs, and sometimes some superficial veins of the skin.
And what factors can make gaining peripheral IV access difficult?
Well, there are both general factors that would make it difficult in just about everybody, and then there are specific factors for specific persons, specific patients that need to be considered. So the general risks are greatly increased of difficult peripheral IV access in people who are obese, when the veins are less than 3 millimeters in diameter, when the veins cannot be felt, or when the veins cannot be seen, the veins that you're trying to access cannot be seen. All of those factors increase the risk that you'll have a difficult IV access or an IV access failure by between 4 and 10-fold.
Jeremy, approach. Norman, can you see the document that is the document available for you?
No, I can't see it yet.
Okay, it's just a moment. Okay, can you see it now?
Now I can see it, thank you.
Okay. Have you had a chance to review some of Ms. Pike's medical records?
I have, yes.
And do you recognize these pages from her records? Your paralegal can sort of look through those?
Yes.
If I may-
Yes, this is,
Can I interject just quickly, and this is for record-keeping purposes? We produced medical records that had bait stamps. I don't see bait stamps on this, so can you tell us where these came from?
We were not able to decipher how the records that you produced were based in. These are Ms. Pike's records that we requested from the prison, and I'm sure the President Council has seen those. But we can take a moment if we need to.
That's okay, I was just wondering where they came from.
Okay, they're records from the prison, medical records.
Well, we've got to manage the number of pages, and we're going to mark these pages.
Thank you, Norman. Is that going to be the same? Excuse me?
Can you exhibit this? Is that the selected medical records?
Yes, that's part of it.
We're going to introduce this separately.
Yes, Your Honor. Dr. Van Norman, have you had a chance to look through the records there?
I'm sorry, that broke up. What,
Have you had a chance to review the records that are on the screen?
yes,
And what are those records?
Well, these appear to be the records that, from Christa Pike on some blood draws that she's had. So phlebotomy for some regular blood tests that she undergoes. And this is one of, I should say, a number of these kinds of sheets that appear in her medical records.
And what do you notice about the gauge that's used for her blood draws?
Well, for blood draws, they've used a kind of needle that's called a 23 gauge butterfly. And a 23 gauge is an extremely small needle. It's not the size of needle that we would normally use to administer anesthesia except in babies or in very small children. And the butterfly is because the needle's so small, the butterfly, it's called a butterfly because there's little wings on the sides of the needle that allow us to stabilize it on the skin.
And what do you notice about where the blood is, where the vein is entered on your body?
I'm sorry, it's still breaking up. Can you repeat that?
What do you notice about where they had to stick her to get the blood?
In this particular case, they put the 23 gauge butterfly into a vein of her left hand.
And why would a phlebotomist use someone's hand?
Objection.
Usually they-
For expertise.
I'll overrule.
I'm sorry?
Why would you try to do a blood draw in someone's hand?
In general, because I can't see a vein or feel a vein in the arm, hand veins are particularly fragile and they're also particularly painful to draw blood from, but they also are a little easier to see sometimes. So.
Your Honor, counsel let me know that we disclosed to the
total pages in your medical record?
It's going to be less than 20, less than 15 probably. It's not a huge amount.
Is that small, you can do either you want to do?
Yeah, for sure.
Sure. But since you're taking the time to bring this to me, we're going to mark this one document for this.
Got it. Thank you, Your Honor. And Dr. Van Norman, have you reviewed this page in your records?
I recognize it. It's a bit small for me to see if it's possible to enlarge. Otherwise, I do recognize the page. So, perfect. I can see it now. Thank you.
And what does this tell us about Ms. Pike as far as vein access risk factors?
Well, this is a page from Christa's medical records that show her medications, but up in the left-hand corner, upper left-hand corner, you see her vital signs and a description of her, and it points out that her BMI is 30.76, so she is an obese patient, and obesity is one of the main risk factors for difficult IV starts.
Thank you, Dr. Van Your Honor, may I approach? Your Honor, I see that I have failed to move the document that had the BMI on it into evidence. I moved that into evidence, and I also failed to move the document that tracks the blood draws into evidence. I moved that one into evidence as well.
I'm going to mark it as a representative. Say, as any guesses, just speak up. So we're marking those IV records exhibit 6, the one that shows the BMI is exhibit 7. And what does this one show?
Well, Dr. Van Norman, can you see it?
Yes, I can see this exhibit 5.
Okay. And what does this record show?
This is also from the same records that I reviewed for Christa Pike, and it contains a notation about a condition she has called essential thrombocytosis, which is a condition we have to manage as anesthesiologists in the perioperative period because it's associated with increased clotting and paradoxically with increased bleeding.
We're going to mark that exhibit 8.
Okay, thank you, Your Honor. So, the diagnosis of essential thrombocytosis, you mentioned that it is an increased risk of clotting. Are there any issues associated with blood draws that this condition calls for treating?
Yes, with both blood draws and IV starts, and both are relevant to anesthesia care. These patients all have increased clotting of the blood because they have an elevation of an element of the blood called platelets to a very high degree, and it causes both small and big blood clots to form. So we are managing their clotting in the setting of surgery. In addition, when you injure blood vessels, platelets activate, and these people will have increased clotting and potentially internal scarring of the veins. All of them have a form of what's called microvascular disease, that because of the scarring and difficulty with platelets in the veins, they have often smaller internal diameters, they have more bleeding if they have a broken vein, and they have more chance for for the vein to clot off and the IV to clot off if they have an IV start. So they are more difficult to access because of smaller scarred veins, have a higher propensity for clotting the IVs off when they have them, and present a problem with oozing and bleeding around the veins if there's a break in the vein that can make IV starts more difficult.
Okay, so based on the review of Ms. Pike's medical records, have you formed an opinion as to whether she is at high risk for failing to gain peripheral vein access?
Yes, I have.
And how certain are you of that opinion?
She has a significantly elevated risk of problems with IV access, as evidenced by the fact that she has essential thrombocytosis and its problems, plus she's obese, plus they're already using a tiny child's needle to try to draw her blood. So her risk is quite elevated, and my opinion is to a reasonable degree of medical certainty on that. These patients in the operating room can be very difficult to have IVs in.
Okay, so we have talked about the risk factors that are present in her medical records, and that's just for gaining access. How is a blood draw different from setting an IV?
The phlebotomy and starting an IV are two different procedures. When we're drawing blood, all we have to do is get the blood drawing needle into a vein. It can be quite small. We're not trying to infuse drugs or give fluids through it, so we can choose a very small needle. And we only have to get that needle a fraction of an inch, really just a millimeter or so into the vein, because once the little hole in the needle is in the vein, we can withdraw blood. We don't have to thread that needle into the vein and risk rupturing the vein. The vein can be pretty small and give up its blood because we're not trying to put an object in it. IV starts involve not only threading a needle which has a catheter over it, a sheath over it. We have to thread both the needle and that sheath into the vein. You have to go quite a ways into the vein. And it's a bigger diameter with the needle and the catheter are a bigger diameter even for the gauge of that you're putting in, because you have a little IV sheath over it. And unless you get that the needle positioned well into the vein, and you won't be able to thread the catheter off of it. And a common problem in IV starts is that people don't get these threaded far enough in. And the further you have to thread those into the vein, the needle and the catheter, the more likely it becomes that you can rupture the vein or go through the backside of the vein wall and cause the IV not to work. And more likely you'll have the vein blow up and not be able to put an IV catheter in it.
What size needle is usually used to place an IV in an adult?
In the case of anesthesia, we like to get something called an 18 gauge IV. As the gauge number gets smaller, the IV gets larger. So larger numbers mean tinier IVs. We want to be able to give fluid, and we want, most importantly, to be able to push drugs through that IV. And we need a larger gauge. An 18 is an average. It's very common, however, in obese patients to use a 20 gauge IV, which is smaller than an 18 gauge, but is still very much larger than a 23 gauge needle.
What happens if the needle is too big?
Well, it can do a number of things. If the vein is rolly, it can push the vein away. You can injure the vein, rupture the vein, and more likely you'll tear the vein as you try to put the catheter in or as you try to put the larger needle in. Well, during the IV placement, what happens is you get bleeding, and in the case of someone with essential thrombocytosis, you're going to get potentially more bleeding than usual. But you get bleeding around the vein, that compresses the vein, makes it even smaller and more difficult to get into, or displaces the vein. So you get a big bruise there that's pushing the vein off to the side, and it can be difficult to feel, difficult to see, and difficult to get an IV in. The more times you poke a vein unsuccessfully, the less likely it becomes that you're going to be able to get that IV in.
And if you use too large of a needle to gain IV access, and what can happen to the chemical or that is going through the IV?
Well, both, if you're putting fluid through the IV, whether you're putting fluid or drugs, if you damage the vein, putting them in, you have a much higher likelihood that that drug or that fluid is going to end up in the tissues around the vein, partially or totally. It can be just partial, or it can be total. And there it will have, it may have detrimental effects on the tissues around the vein. If you're trying to elicit an effect from the drug, you're going to be getting less of it into the bloodstream where it'll have its effect. So if you get a large infiltration, the drugs have diminished effects. And that's been an effect that's been seen in executions.
Okay, what happens if you use a needle that's too small?
If you use a needle that's too small, two things can happen. One is it's just really hard to get any kind of volume into the vein then. For example, the Tennessee protocol calls for the use of a 50 cc syringe. They're going to be pushing 50 cc's, which is a large amount of fluid, into the vein. Through a small catheter, it will take quite a while to inject that. So for example, pressing just about as hard as you can with a 50 cc syringe through a 22 gauge needle, which is larger than a 23, you can only get that 50 cc's in over about a minute. You can't give it much faster than that. In my report, you can look at some flow charts that show that. So the more volume you're putting through the IV, the longer it takes. That means that if you're, again, administering a drug, the drug will not get to as high a peak level because you're administering it over a longer period of time. And in the case of, for example, pentobarbital, it's being cleared from the blood very quickly, and so you never get up to the level that you would get with a larger IV, and you're going to see lesser clinical effects. And that's also been seen in executions. That's one problem. Another problem is that the pressure that you have to use to push that drug through the IV is higher the smaller the IV is. And you guys, and what comes out the end is the pressure that you're putting through the IV. You can think of it as if you're washing your car and you're just kind of rinsing off some of the dirt on the car, and your hose is flowing at a particular rate, and it washes things off, but you run across a place where you need to clean the car a little bit more, maybe some of the dirt hasn't come off. What do? We put our thumb over the end of the hose to make that a smaller opening, and what happens? The pressure at that opening goes sky high, it goes way up. Well, when that jet of pressure, the same thing happens with an IV. When you're pushing a syringe through a tiny IV, the pressure that's coming out the end is high, and just like in that hose, it comes out as a jet. And in smaller, fragile veins, that can cause the vein to burst. And then you're back at looking at a situation where your drug or your fluid is not going in the vein. It's going into the tissues around the vein.
Dr. Van Norman, are you familiar with the chemical pentobarbital?
Yes, yes.
What characteristics does it have?
I'm gonna
Pentobarbital.
her expert report says nothing about the characteristics of pentobarbital.
Is there anything in the report about
Your Honor, her report talks about if a chemical moves out of the vein and into the tissue, that you are going to get burning. I don't have the report in front of me, but that's
and its sister thiopental, which is identical in characteristics to pentobarbital, are extremely caustic chemicals. They're like Drano or lye. And if they're injected into tissues rather than, say, spilled on the skin, or injected into a high-flow bloodstream, high-flowing bloodstream, if you're just injecting it into tissue, they cause a deep chemical burn that is very severe. It destroys tissue on contact. And back in the days when we were giving thiopental as an induction agent, we used to occasionally see this, where you inject the drug and your IV isn't working, or the IV breaks when we're giving the drug, and they get a partial or total extravasation. It is excruciatingly painful. I've personally seen patients scream when that happens, and I've personally had to deal with burns that happen from barbiturate injections of pentobarbital or thiopental during anesthesia care. And if you don't act quickly, even if you act quickly, the patient is going to be left with burns. But if you don't act quickly enough, they will be extremely severe burns. In addition, I've also personally seen that you don't get the same clinical effect when that drug doesn't get totally in the bloodstream. Pentobarbital will not have as much, it doesn't have clinical effect in the tissues. So the clinical effect you'll see will be reduced by whatever amount, whatever percentage is given into the tissues rather than into the bloodstream. So you get reduced clinical effect, you get local excruciating pain, you get local instant destruction of tissue damage. And those are experiences that I have direct knowledge of from my anesthesia practice.
Dr. Van Norman, we've discussed that a needle that's too big can damage the vein, and we discussed that a needle that's too small can also have issues with that. Have you been able to form an opinion as to whether Ms. Pike has an elevated risk of IV access difficulties during the execution?
Based on her characteristics that we can read in her medical reports, she has a highly elevated risk of a difficult IV access, somewhere between quadruple to 10 times the chance of a person who has not got her conditions of obesity and essential thrombocytosis of having, or small veins, of having the same problem. And that is to a reasonable degree of medical certainty. She has elevated risk.
Okay. What does the protocol say to do if the IV access fails?
The protocol instructs that the physician will place a central line.
Your Honor, for the court, I'm going to talk with her about the alternative first, that the central line.
You're going to talk about the 23 gauge needle first, and then the central line? How are you going to do it? Or are you giving up on the 23 gauge? Let's not waste our time.
Okay. Your Honor, our experts have explained that a 23 gauge needle is not sufficient to manage the lethal injection chemicals because of the extreme pressure that the chemical will come out. So we are focusing on the central line.
So you're withdrawing that as an alternative?
Yes. So I'm gonna invite Dr. Van Norman to discuss a little bit about central line and the qualifications or background that the physician would need to do that. Dr. Van Norman, what is?
If I may, so the court ruled that the qualifications are not relevant. What is relevant is the relative benefit of the central line as an alternative. So as a proposed alternative, the court has to presume that whoever places it is qualified. So qualification is not a here nor there.
I'm going to let them, their proposal is that the only person that can do this is a physician. the alternative is, what is it? Feasible and readily available?
Yes.
And the U.S. Supreme Court has said it's not feasible and it's not readily available if it would violate someone's canons of ethics to participate. So are we really just going in circles with this central line thing?
Your Honor, the protocol provides for a physician to do the central line. Apparently, in the Carruthers execution, they were able to find a physician who attempted that. And Ms. Collins testified that she confirmed that that person, she confirmed their credentials.
Well, I mean, I've already ruled that's not relevant to this inquiry. The only relevance that the central line has is that it's your proposal that instead of peripheral IV, that there should be a central line. That's where you start. The more invasive procedure, we start with the more invasive procedure, but the only person that we say can do that is the doctor, but your own witness says the doctor can't do that. So, I mean,
Well,
we
Your Honor,
just,
I would,
you can work that out with her. It doesn't make sense to me that we're talking about a central line when, as an alternative, when your own witnesses are going to say that nobody in the medical profession is going to do this. So y'all can explain that. It doesn't have to make sense to me. As long as it makes sense to the court that's reviewing this,
Right.
that's okay.
Dr. Norman, when you were talking about whether a physician would do this, were you describing the ethics rules?
I was, yes, but I was describing also my personal response to the ethics rules. I don't make a judgment about whether anyone else would do this.
No, wait.
Okay.
Let me just make sure we're all on the same page.
Yes, Your Honor.
You're aware the U.S. Supreme Court says that an alternative does not have to be adopted by state if it would require someone to violate their canons of ethics.
Your Honor, the protocol now calls for a physician. That's in the protocol. The issue is that the TDOC has struggled to hire a physician who has appropriate training and qualifications.
That's not the issue in this proceeding. It may be the issue in your overall arching lawsuit, but that's not the issue for the questions that the Supreme Court has asked us to focus on. And under the law that both sides have cited to me, you have to identify an alternative to the state's planned execution that is reasonably available and easily implemented. And the U.S. Supreme Court says that that alternative, the state is justified in not adopting an alternative that would require the medical profession to violate their canons of ethics. But the alternative you proposed is that requires a physician to violate their canons of ethics. Now, I understand your position that they using a physician that's violating these canons of ethics, but that's a different issue. We're talking about your proposal as an alternative is that a central line being the primary goal, but it has to be set by a qualified physician.
Yes, Your Honor, a physician.
So I'm going to let you put on your proof, but go ahead. But I don't know what you're going to do with the fact that doctors are not allowed to do this. And that that's a legitimate reason for a state to not adopt your proposal.
With the court's permission, I would like to brief whether doctors, licensed physicians are allowed to do this in Tennessee. I know the state testified earlier today that they do have licensed.
Well, I tell you what, why don't we not worry about
just open my questions. They asked me to determine whether your alternative methods are more beneficial. I'm not using the exact words.
Right.
They didn't ask me to determine whether it's reasonably available, and all those other requirements. They didn't ask me to determine whether the states refused to do it or whether there was a legitimate penological reason. They only asked me to compare. So you don't have to explain that to me, but you probably don't have to explain that to the Supreme Court down the road. I'm just going to focus on what they told us to do. So.
Thank you, Your Honor.
So according to your proposal, you want a trained, qualified doctor to do this, and you're going to ask her what the benefits of going with central line placement in lieu of peripheral.
Yes, Your Honor. Dr. Van Loan, what is the central line?
A central line is a central IV, or a central line is placing a catheter, usually a longer catheter because they're deeper veins, into the veins that are inside, basically inside the body cavities, or that run into the body cavities. So these would be veins that run into the pelvis, the abdomen, and the chest, and specifically veins that go in the heart. And central lines, the typical ones that are placed either in the internal jugular vein, the subclavian vein, which runs under the collarbone, or the femoral vein, which runs in the groin. These veins are different than other veins in that they're much larger. They have a much larger access site, much larger blood flow, and they don't have valves in them that impede blood flow or that slow drugs down from getting to the central circulation. So they're a placement into a much larger vein that is within a body cavity. Or the neck, I'm sorry. I keep forgetting that the neck isn't there, so yeah.
How hard is it to place a central line? Dr. Van Norman, how hard is it to place a central line? If you are trained and have a lot of experience, they're not all that difficult, but they are very prone to extreme complications. Complications such as a rupture of a main vein inside of a body cavity, you could bleed to death in a few seconds. Placing either the guide wire, which is a special wire that's put through the needle to help guide the catheter into the vessel, can cause stroke and fatality if you place it in an artery, such as the carotid artery, subclavian artery, or femoral artery, all of which run right next to their respective veins. There are lines that are placed in the chest, like subclavian veins, and even the jugular vein in the neck can also clip the lung and cause the lung to collapse. There are a number of life-threatening complications that can occur if these are not done properly, and they have a fairly high complication rate, although the mortality rate, the risk of death, is not extreme. About 10% of these lines have serious complications, such as placing a needle in the artery, in the carotid artery instead of the carotid vein, or putting a guide wire into one of the arteries, or rupturing the vein itself. So training and continuing clinical experience are absolutely necessary to be able to do these lines accurately, efficiently, and safely. And what qualifications do hospitals require for a physician to have that privilege?
Well, hospitals go through what's called a credentialing process before they'll let anyone of any practice variety practice under their roof. They want to make sure that they are qualified to do so and that they've gotten the training to do so. And in the case of central lines, most healthcare organizations require that a physician show that, first of all, they did receive actual training in how to do the line, and that since the point of training, they have continuing clinical experience, because it isn't sufficient to train 20 years ago, for example, or 15 years ago, and then place a line that's dangerous to place without continuing practice at it. It's a manual dexterity type procedure, and if you don't do it often, you aren't going to be as good at it. So most institutions require that if a physician wants to place a central line, They show that they've had the training, they document their recent clinical experience, or they meet some training or continuing clinical experience requirement that the hospital itself sets up to show competence. And generally the cycle of re-privileging is about every 2 years. So about every 2 years, a physician is going to have to show to either the department or the hospital that they have those skills if they want to place a central line. Not all physicians want to place central lines, so they don't have to go through them.
Okay, how common is it to use an ultrasound when placing the central line?
Today, ultrasound is a standard of care. It's used in every line unless every one of your ultrasound machines isn't working. These are handheld devices now. They are ubiquitous and everywhere, and you use them for central line placement every single time unless literally you can't have an operating machine or you're violating a medical standard of care.
And you've reviewed the protocol, the lethal injection protocol.
I have.
And did the protocol list any qualifications for the physician?
Objection, the court
Yeah.
has ruled on this, and
I'll sustain that objection.
Okay, Your Honor, could we move then to the offer of proof part of this that talks about the qualifications and what the lack of qualifications that the physician had in the attempted execution of Mr. Carruthers?
I've ruled that not admissible, and you just want to make an offer of proof. Does the state want to,
Your Honor, we could tender her report.
I'm inquiring whether the state wants it. I could let them make an offer of proof and tender the report as for ID only, not as a trial, or let that deprive you of the opportunity to cross-examine. Again, once deferred to you, you know, the law says that when it's absolutely, positively, clearly irrelevant, that it's not an error for me to deny it all. We're trying to see, to me, it's absolutely positive. I'm trying to think of the facts.
Your Honor, we appreciate that. I will.
Let me hear what before you, he may save us the trouble. Can I introduce her report as an ID on former offer of proof?
the state would agree with what the court said before lunch, which is that if we have to submit offers of proof for every evidentiary issue the court rules on, we're going to be here in the next week. So the state would just ask the court to rule that it is relevant, the difference are relevant, and we can move on. They are going to have a chance to prove this in the Supreme Court. Just because they can't introduce proof in this evidentiary hearing doesn't mean the issue is gone forever. And so we would ask that we could just move on from this topic and get on with the testimony.
Your Honor, I could move through this topic very quickly.
Well, that's what you said last time. An hour later, we were still going on about the statute.
Okay. It wasn't an hour.
I'm sure I exaggerated, but you made it sound like when I'm going to be brief, it's going to be 2 minutes, and it exceeded that. I tell you what I'm going to do. I know what I'm going to do. Explain exactly what you want from her.
She reviewed Ms. Delamorado's declaration, and based on the facts that Ms. Delamorado observed, she offers an opinion that the physician intended to place the central line in Mr. Carruthers was qualified because he made several egregious mistakes.
Here's how I'm going to handle this. I'm going to rule that it's not admissible. I'm going to exercise my discretion not to do an try, but I think, I think we're gonna move on. I'm not gonna.
May I offer her report for identification only?
Yes.
Your name?
You have that?
I do. And may I have just a moment to check with my colleagues and share what
Do
we need?
y'all, do anybody need, I was gonna sit here, but anybody need a recess?
Maybe 5 minutes from now?
5-minute recess, and we'll grab a copy and make that the next exhibit when we get back.
Dr. Van Martin, we're taking a 5-minute recess, and then the state will ask you questions.
So I'm sorry, I should stay, is that what you're saying?
Yes.
When you were in clinical practice, did you use that word very often?
In anesthesiology and pain medicine, we use lots of words to describe pain, and excruciating is a word that we do use to describe very severe pain. So yes, we use it in practice.
Now, on page 6 of your report, you use that word excruciating to refer to the insertion of a needle for peripheral IV access. Is that correct?
Can you, I actually have my report in front of me. Would you give me the line so I can look at that?
So again, this is on page 6, and it's, it's in the first numbered paragraph. You see that paragraph?
I do.
And are you saying in that paragraph that, well, let's just read it, complications of peripheral and central line placements are common during lethal injection executions. These complications lead to protracted attempts at placement of venous access catheters, and these attempts are excruciating. And it continues on. So is it your contention that an attempt to achieve peripheral IV access is excruciating?
I think if you read the sentence, you'll see that what I said is that protracted attempts at IV access are excruciating, and yes.
Okay, so you would agree that tens of thousands of people get IVs in this country every single day?
Yes.
And that each one of those people is stuck at least one time with a needle, right?
Yes.
And some of them are stuck more than once.
Yes.
And among those, a smaller portion are stuck several times.
I don't know that it's a smaller portion, but yes, there are people who are stuck once and have their IV started, and there are about 60% of people that will have one or more attempts.
So when, in your view, does it become excruciating to achieve IV access?
Well, it depends. If it's a patient who already has a significant amount of pain with IV starts, as some do, it can be excruciating on a single attempt. Multiple attempts, generally people get more, and this is from experience of starting tens of thousands of IVs. People get more and more anxious, and as each attempt, as the number of attempts increases, they get more and more painful for them. So it depends partly on the patient when it becomes excruciating, partly on whether there are multiple attempts, although even a single attempt can be if it's not done properly or if the patient already has pain. So it's not a question that's easy to answer for lots of people. I'd have to know the patient and the person and what difficulties they were having.
Let me ask you this, in the tens of thousands of IVs that you placed in your career, did you ever warn a patient before you placed the IV that they were about to suffer excruciating pain?
Brian, I'd like to object, just the paragraph 1, she says that repeated IV attempts during executions. So just to put that in context, she's talking about the repeated attempts at IV access during executions and the complications from that. So she did not say that your Rotamine complication with an IV in a clinical setting is excruciating. It's very clearly talking about repeated attempts and prolonged efforts at IV access during lethal injection is what this paragraph is about.
So what's your objection?
He's assuming facts, not an evidence. That's not what the report says.
Well, I understand that the report says, but I thought she just tested it, you know. I'm going to give him some leeway to do his cross-examination, and so I'm going to overrule your objection, but I know that that's what the report says.
Thank you, Marty.
Last question on this topic. As I was saying before, in the tens of thousands of IVs you placed in your career, did you ever warn a patient that they were about to suffer excruciating pain?
warn my patients about how much pain I think they'll feel. I don't remember a specific instance, but it is entirely possible that I have. I've certainly warned them that this might be severely painful. However, I'll point out that when I start IVs, I also use local anesthetics so that they have less pain.
Would you always do local anesthetic when you started an IV?
I always give a local anesthetic when I'm starting an IV. Always.
And you would agree that sometimes in a clinical setting, it is difficult to achieve IV access.
I agree, yes.
And in your experience, has it sometimes taken several attempts to get peripheral IV access in a patient?
Yes, sometimes, but not commonly.
And does that sometimes require attempting IV access in different parts of the body?
It can.
And will patients sometimes bleed when that happens?
I'm not sure I understand what you mean by bleed. You mean like, do they sometimes get a little bit of blood around the IV, or?
Yes.
Yeah, that can happen, certainly.
And have you personally served as an anesthesiologist in procedures or surgeries where it has taken multiple attempts to get IV access?
Yes.
And in those cases, did it take several minutes?
As opposed to, I mean, yeah, it takes probably about 2 or 3 minutes per IV attempt.
Have you ever been in a procedure in a clinic where it took half an hour to secure IV access?
It would be extremely rare for me to take half an hour to get IV access. I'm sure that some people have had that happen.
But have you personally witnessed that?
I'm sure I have. I can't think of a specific instance.
But it's not unheard of, is that what you're saying?
No. I mean, yes, that's what I'm saying.
Thank you.
Yeah.
So, some questions about some other terms you use in your report. The first being infiltration. So, is infiltration when an IV catheter is placed somewhere outside of the vein? Do I have that right?
Well, the way I've used it in my report, I defined it in my report because I'm using it specifically in an anesthesia context. And what I said was that an infiltration is, I believe I mentioned that infiltration is when there's a displacement of the IV catheter partially or totally into tissues such that there is fluid that goes from the IV catheter into the tissues. Extravasation is very similar, but I'm using it to mean that when a drug is injected rather than just fluid flowing through the IV. I'll point out that these terms have different meanings if you use them in the context, in some other context. For example, some folks define an infiltration as any time fluid or a drug makes it outside a vein, because of the IVs outside the vein, but that the fluid is regular fluid, it's benign, and that extravasation is when the fluid is what's called a vesicant, or a fluid that can blister or burn the tissues. Injecting pentobarbital outside of the vein would be, under those circumstances, called an extravasation, because it is a vesicant fluid. It has a quality that it can burn just by itself. I don't mean the sensation burning, I mean it can literally cause a burn.
Yes, and can infiltration occur in a clinical setting?
Yes.
Can extravasation also occur in a clinical setting?
Yes.
You refer in your report to the central line as a, quoting, relatively dangerous procedure. Do you still hold that view?
Well, first of all, I was actually not saying that myself. In the report, I am quoting a colleague, Andrew Bowell, who refers to these as a relatively dangerous procedure. I happen to agree with him, but I just want to be clear that that is not a quote of me. That is a quote of someone else.
Yes, thank you for that clarification. And you testified earlier about some of the complications that can arise from central IV access, such as the rupture of the jugular. Was that a potential complication of central line access?
Yes, I don't think I referred to that earlier, but what I said was that you can damage the veins and get injections outside the veins, and that includes the veins I spoke, any of the veins I spoke about, the jugular, the subclavian, the femoral.
And you mentioned lung damage as a potential complication.
It is, because the lung is near in the upper chest. It's not a potential complication from a femoral line. But when you're placing one of these lines, either via subclavian route or via internal jugular, it is possible for the needle that is looking for the vein to actually nick the upper part of the lung. The lung comes up much higher in the chest than you think it does.
Do you consider peripheral IV access to be a relatively dangerous procedure?
No, the reason I would distinguish between the quote danger end quote, and again I'm quoting my colleague, between peripheral lines and central lines, is that the potential complications of a peripheral line are not immediately life-threatening. It's really hard with an IV catheter to have a complication placing in a peripheral vein that would immediately put the person's life in danger. But it is not difficult to have that experience happen with a central line that's improperly placed.
Now, you earlier discussed some of Ms. Pike's medical records. You were shown when you pull exhibit, this is exhibit number 6. Can you show that to Dr. Van Norman? This is the blood draws. We're going to try to pull this back up on the screen for you. Unless you happen to have a paper copy with you of Ms. Pike's blood draws. Do you have a copy with you?
Oh, are you asking me?
Yes.
No, I don't have a copy of it right in front of me at the table.
Can you see that on your screen, a document?
I can. Yes, I can.
Okay, so this is what was previously marked as Exhibit 6. You would agree that this is a phlebotomy record, correct?
That's correct. It is not an IV placement.
And do you have any personal knowledge of what equipment the phlebotomists at the Deborah Johnson Rehabilitation Center use?
No.
So you don't know what all size needles they might have at their disposal, do you?
I do not.
And we see on this particular page, there's a mark next to a 23-gauge butterfly needle, correct?
I'm sorry, say again?
Actually, strike that question. So, for all you know, they only have one size of needle at this facility, right?
I suppose it's possible, but to only have 23 gauge short needles for potentially obese patients would make much sense.
And you don't have any personal knowledge about what kind of gear they got with you.
That's correct.
Did you see in your review of Ms. Pike's medical records any notes or statements that had trouble securing IV access in Ms. Pike?
I did not see any documentation of IV access in this Pike, period.
And your report mentions a scoring system called DIVA. Are you familiar with that?
Well, DIVA isn't as, well, it's variously referred to as a scoring system. It's also an abbreviation for difficult IV access, so.
And, but are you familiar with that term and that concept?
I am.
Can a score or a value be assigned to a person based on risk factors for difficult IV access?
There are a couple of papers that sort of convert the risks into a scoring system, yes. But most of them actually just, because the risk factors are variable, most of them list the risk factors and what the so-called relative risk or odds ratio are of a difficult IV based on the presence of those factors.
Okay. And so, also in this, I'm going to ask another question about this exhibit that's in front of you. Did you see any documentation in these blood draw records that indicated there was difficulty in achieving venous access in this Pike?
These are blood draws, they are not IV access, so you can't, it's not the same thing. So there's no documentation here about IV access. And being able to get a small needle into a vein does not predict whether you will be able to get an IV into that vein.
Yes, thank you. My question was actually, with respect to the blood draws, do you see any notation that the phlebotomist had trouble drawing blood?
Thank you, that's a good clarification. No, I did not.
In this Pike's medical records, did you see any documentation of the phrase small veins?
I don't recall seeing that, no.
Do you recall any documentation of non-palpable veins?
No.
Do you recall any documentation of non-visible veins?
No.
And you've never examined this Pike personally, have you?
No, I wasn't given the opportunity.
And so your conclusion about her risk for IV access is speculation, isn't it?
Well, no. She is obese, and she has that, at least that risk factor, and obesity is a significant risk factor for difficult IV access. And she has essential thrombocytosis, which increases problems with IV access in my experience as an anesthesiologist. And so I'm not speculative about those. Those are elevated risk factors.
Now, in your experience as an anesthesiologist, would you make a call about what size needle to use to achieve venous access without ever seeing the patient?
There are sometimes procedures that dictate what size IV we have to have in, yes.
So is your answer to that previous question yes?
Sometimes we have to, yes, sometimes we know that whatever procedure we're going to have, we need an X-sized IV. I'm trying to answer your question as exactly as you asked it. So yes, there are times when we know that we're going to have to use a certain size IV.
Okay. And this is not the first time you've offered an opinion as to whether an inmate in Tennessee is likely to suffer harm during execution, is it?
No.
Do you recall the case of Byron Black?
I do.
Do you recall offering an opinion in that case that Mr. Black would suffer pain from an ICD device?
Yes.
Do you recall stating that that was a virtual medical certainty?
I stated that it was a virtual medical certainty that if the device fired during his execution, that would be very painful and that there was a high risk that that device would fire. Because clinical experience with ICDs, which I have as a cardiovascular anesthesiologist, means that I have clinical experience with what are called inappropriate shocks.
happen, did it?
It did not. He did not have his device fire, but that doesn't mean that there wasn't a high risk that it would fire, and it was a virtual medical certainty that if it fired, that it would be extremely painful.
But that did not happen, did it?
His device did not fire during his execution.
Now, as for Ms. Pike, do you have any personal knowledge as to whether she has inflammation or clotting in her veins?
All patients with essential thrombocytosis have increased clotting, increased oozing, and microvascular disease.
But you're not a hematologist.
I'm an internist, and I deal with thrombocytosis, and I also deal with perioperative issues in essential thrombocytosis.
In your experience as an anesthesiologist, did you ever do anything different to achieve IV access in a patient that did have thrombocytosis?
Yes, among other things, I have used an ultrasound device to try to locate veins and to find the largest veins that I can get. In addition, perioperatively, we have to manage some of these patients are on antiplatelet drugs, so they take drugs that make them ooze, and sometimes they take drugs to make them clot during surgery. There are some medications that we give. And so, depending upon the presence of those medications, we may adjust the medications. I've also adjusted the site where I start my IVs in patients like this because the small vessels are going to be more difficult.
But Ms. Pike does not receive antiplatelet medication, does she?
I don't remember if she's currently on aspirin, but she has been on aspirin, yes.
Do you consider aspirin an antiplatelet medication?
Aspirin is the definition of an antiplatelet medication. It is what cardiologists use in heart patients for many antiplatelet procedures. They use aspirin to prevent strokes, to prevent stent thromboses when they place stents. It has a direct antiplatelet action, and it is in the class of an antiplatelet drug, yes.
And you would agree that Ms. Pike's records show that she does not have any symptoms of thrombocytosis?
Thrombocytosis, in terms of having clots, can be entirely asymptomatic.
But you do not see any evidence of symptoms in Ms. Pike's medical record, did you?
I don't recall specifically, no.
Your report states an opinion that more frequent blood draws makes veins more difficult to access. Would you agree?
My report states that, yes.
Yet it cites no sources for that proposition.
Well, the source is an anesthesiologist who has placed tens of thousands of IVs. So in my clinical experience, that is true.
So, in your experience as an anesthesiologist, would you always have prior knowledge of how many times the patient's blood had been drawn?
I often would, yes, actually, because it's documented in their medical records. And most of the time I'm taking care of patients in my own institution. So yes, I would usually know.
Do you see any indication in Ms. Pike's medical records that her veins are going to be difficult to access because of blood draws?
What kind of documentation would I don't understand your question. There's no documentation that anyone would write that would say she will have difficult access because she has essential thrombocytosis. We simply are aware of that of the fact that she has a higher risk for having difficult access.
I just want to confirm with the court that the 23-gauge butterfly has been withdrawn as an alternative.
Yes, Your Honor.
Okay. No questions on that one. That's all my questions. Thank you, Dr. Hamlin.
Okay, thank you.
Redirect.
Dr. Norman, you testified on calls that extravasation does happen in a clinical setting.
Yes.
How common is it for extravasation of pentobarbital to occur in a clinical setting?
Well, phenobarbital is not used in very many medical settings in the United States, and it never has been. We have used its sister drug, thiopental, which has the same alkalinity, the same caustic action. It's a barbiturate. It's chemically almost identical. But it was used as an anesthetic induction drug back in the 80s and early 90s. But because it had many problems associated with it, and because other drugs came along that were better, we stopped using it. But I trained and did my anesthesia fellowship as well as my early years as a cardiac anesthesiologist using thiopental, which is that drug. And I have personal clinical experience with what happens if that drug extravasates.
And what happens?
Objection, asked and answered.
I'll just throw a question. Your Honor, that's all I have.
Anything else? All right, ma'am. You're off the look.
Thank you, Your Honor. Have a good day.
All right. What do you want to do next? Need a break or?
Your Honor, we had a 10-minute break and then we'll call our next witness.
10-minute recess.
handed you a document. Can you identify that for us?
Yes, this is a copy of my curriculum vitae, a professional curriculum vitae.
Does it accurately represent your professional background?
Yes, it does.
Your Honor, we moved that into evidence.
All right, we'll mark that exhibit 10.
Dr. Zivit, tell us a little bit about your formal education related to getting your medical degree.
I attended 4 years of college in Canada. That was a mix between the University of Manitoba and the University of Toronto. After that 4 years, I was eligible to apply to medical school. At that time, a degree was not required to be eligible to apply to medical school, so I took the courses necessary to apply, and I did, and was accepted to medical school at the University of Manitoba in 1984. I spent the next 4 years in medical school, which was the time it took to complete that degree. I graduated in the spring of 1988. And then my postgraduate training first year was in Toronto at Mount Sinai Hospital in the University of Toronto system.
Dr. Zivit, I'm having a little trouble hearing you. I could ask you to speak up, please.
Yeah, okay. So I said I finished 4 years of college, or of medical school rather, and then I went to Toronto, Canada, and did a postgraduate year of training that entitled me to practice as a family doctor if I chose, but instead I elected to continue training and was accepted to a program in anesthesiology at the University of Toronto. I spent another 4 years there to complete my specialist training in anesthesiology at the University of Toronto, and earned this specialist designation that in Canada is referred to as the Royal College. So I have a FRCPC after my name, which is a fellow of the Royal College of Physicians of Canada. And then from there, I completed that, I guess, in 1993. I then went to the Cleveland Clinic in Cleveland, Ohio, and did 2 additional years of training, which when I completed that, I was able, I earned a specialist certification from the American Board of Anesthesiology in anesthesiology, and also a separate subspecialty certification in critical care medicine. I finished that in 1995.
Okay. And what is the critical care specialty? Are you practicing in that field now?
Yes, I am.
What does that involve?
So a critical care physician works in an intensive care unit and cares for a variety of patients, really the sickest patients in the hospital who require intensive care. These are patients generally who are either on a mechanical ventilator because of breathing problems, or their circulation is very weak and they need special medication or machines to maintain circulation, or they have serious infections, or there's really a variety of kinds of conditions that where a person may find themselves in intensive care. And so I'm an attending physician in a couple of different intensive care units at Emory University currently.
And are you practicing now as an anesthesiologist?
I practice so I'm an anesthesiologist with a subspecialty in critical care medicine. So these days my practice is really in intensive care full time. But as an anesthesiologist, I'm called upon to do things that are particular also to anesthesiology as it applies to situations sort of outside of the operating room. So it's kind of a combination of anesthesia and critical care medicine that I'm doing.
And have you testified as an expert in anesthesiology before?
Yes, I have.
Do you have any juried or refereed articles that have been published?
I do.
In anesthesiology?
I do.
Your Honor, we moved Dr. Zivit to be recognized as an expert in anesthesiology.
State here, board hire.
Your Honor, I would like to order, just based on his report, we feel that his opinions do go beyond the scope of anesthesiology. But as far as giving him as an expert in the field of anesthesiology, we have no objections.
I'll allow him to testify
expert in critical care.
Okay. Any objection to critical care?
Depending on what critical care includes, Your Honor, we have opinions in Mr. Zivit's report that go to resuscitation after and mental health and pulmonary edema and thrombocytosis. We think that thrombocytosis, the mental health, and the resuscitation are irrelevant and go beyond the scope of his expertise.
Are you going to,
Your Honor, we're
some of
going to,
these you may be doing and some you may not?
correct, Your Honor. He's going to testify about pulmonary edema and thrombocytosis.
Okay, but not the.
Not the resuscitation or the mental health.
You want to word iron, but I'll.
On the thrombocytosis issue, yes, Your Honor.
Okay.
Good afternoon, Dr. Zivit.
Good afternoon.
My name is Samantha Morris. I'm with the Attorney General's office. Just to be clear, your experience is anesthesiology with a subspecialty in critical care, I think is how you phrased it.
Yes.
In anesthesiology and your subspecialty in critical care, do you ever have the opportunity to care for patients who are diagnosed with thrombocytosis?
Yes.
And do you diagnose those patients with thrombocytosis?
On occasion, yes.
Do you believe that you are qualified to do so even though you are not a hematologist?
Yes.
Okay. So you're board certified in what exactly? Anesthesiology?
Anesthesiology and critical care medicine.
But you are not board certified in hematology, correct?
I'm not.
So without that board certification for blood disorders or hematology, how would you be able to help people with platelet disorders such as thrombocytosis?
I encounter in my job, both as an anesthesiologist, but in particular as an intensivist, I encounter patients who have bleeding disorders on a daily basis. And I see a variety of conditions related to either platelet dysfunction or other kinds of disruptions within the coagulation cascade. I use medication to specifically either augment or retard coagulation as needed depending upon clinical situations. So, and I've been doing this for decades. I consider myself to be an expert in this field and comfortable to discuss this subject.
Have you ever written an article on platelet counts or thrombocytosis?
No.
Have you ever testified as an expert to thrombocytosis or blood disorders?
No.
So is it fair to say that this would be the first time that you have presented yourself as an expert in a court of law as to blood disorders and thrombocytosis?
Well, in a court of law, but not as an expert in clinical practice.
No further questions, Your Honor. We would move based on Mr. Zivit's testimony, however, that he not be permitted to testify in the field of hematology, specifically thrombocytosis.
Well, I've declared him an expert in critical anesthesiology. I'm going to allow him to testify. If any opinions he has, I will assess that when I determine the way that I'm going to give those opinions. It depends on whatever factors you two lawyers bring up. I'm going to go ahead and allow him to testify. The test is whether his testimony might be helpful to the court. The degree to which it's helpful, we will determine later, but I'm going to allow him to testify.
Okay, thank you, Your Honor.
Dr. Zivit, have you read the Tennessee protocol, lethal injection protocol?
I have.
And what chemical is used to induce death?
Pentobarbital.
And what characteristics does that chemical have?
So pentobarbital is a drug within a class of drugs referred to as barbiturates. Pentobarbital is a barbiturate, and there are other drugs in that class as well. They work similarly. Some of the differences between them have to do with dosage, specifically duration of action. There are some unusual properties also within the sort of less commonly used barbiturates, but that's basically what they do. I mean, they're used, I suppose. Do you want me to speak about, I'm sorry, what they do or how they work? Or?
What I'm particularly interested in is what would happen if pentobarbital comes in contact with human tissue?
Sure. So pentobarbital and drugs of that class are, in order for them to be injected into the body, because it can also be ingested as a pill, they have to be prepared in a specific kind of way. The term is to constitute them, or they're reconstituted from a powder into a liquid. In order to get them to be a liquid, then the solution has to be of a certain form. And in this case, the solution that pentobarbital is something in chemistry referred to as an alkali solution. There's a scale of the way that we think of chemicals, and we classify them as either acids or bases. It's a scale referred to as the pH scale, and it goes from 1 to 14. 7 is the middle, and 7 is neutral, neither acid nor base, and the neither acid nor base is water. Something that's important to understand about the way that we classify drugs along this sort of chemistry classification has to do with the fact that the scale itself is something called a log scale. So a log scale means, although the number goes up by 1, say from 7 to 8, it actually increases by a factor of 10 each time. Now, you're probably familiar with the log scale when we think about earthquakes. So earthquakes are also a log scale. That's why an earthquake of 3 or 4 is of a certain size, but an earthquake of 7 or 8 is enormously bigger, even though it's only a few numbers.
And where does pentobarbital fall on the scale of measuring?
So pentobarbital is 9 or 10. And so that means and each time you go up by 1, it's a factor of 10. So from 7 to 80 would be 10 times as strong an alkali. From 8 to 9 would be 100 times. And then 9 to 10 would be 1,000 times. So 1,000 times potentially stronger an alkali than water. And also as a similar kind of compound, it's like bleach. So bleach has a similar kind of pH. It's a very caustic substance.
And so if, asking my question again, what happens if that substance comes in contact with if pentobarbital comes in contact with human flesh or human skin, what happens?
So what will happen is that the substance is caustic to tissues. It will burn it, essentially. And the reason why we can use it at all is because we use quite a small quantity, and it has to be kind of normally in an IV that's flushing continuously with fluid and brisk circulation. And so in that way, we've been able to use these drugs in a clinical setting. I've used sodium thiopental, which is a drug similar to pentobarbital, thousands of times before it was pulled from the market. So I have a lot of experience of injecting that particular drug into intravenously in the beginning of an anesthetic.
So, but if pentobarbital comes in contact with skin, what happens?
So it's very caustic. It can burn it, and especially if it travels beyond outside of a vessel, then getting into the tissue itself, that can be very caustic and result in a very serious burn.
Okay, thank you.
Hey everyone, we're having difficulty hearing council's microphone.
I'm having trouble hearing you. Okay. She's going to get closer to it.
Thank you.
Dr. Zivit, I handed you a document. Can you identify that?
Yes, these are two autopsy reports. Two, I think, or just one? I'm sorry.
One.
Just one, yes, of Byron Lewis Black.
And what is the date of death for that?
The date of death on this form is August 5th, 2025.
Okay.
Did you say 5th or 6th?
5.
And did you review this report in forming your opinion in this case?
Yes, I did.
Okay. Your Honor, we would move this report into evidence, this autopsy report. It's Byron Black, who was killed under Tennessee's current lethal injection protocol.
No objection to it being admitted as an exhibit, but I would, Your Honor, object to Dr. Zivit interpreting this document. I think he's been admitted as an expert in the field of anesthesiology, not pathology or medical examination. So we would object to him interpreting this autopsy report.
I'm just going to ask him one specific fact about the report, Your Honor.
Well, we don't have a jury here. I'm going to let her ask the fact, and then I'll decide whether it's clear.
Dr. Zivit, on page 4,
Yes.
did you notice any remarkable findings about Mr. Black's lungs?
Yeah, the section in lungs here, I'll read it. Shall I just read it?
Well, just, I mean, if you can just say what
Well,
the finding was.
What's noteworthy here is the presence of fluid within the lungs, and also a change in the color, a red-purple change in color, which would be as a consequence of the presence of blood, and that would be an abnormal finding, in this, and an unexpected finding.
Did
Is that all you want?
Did you find any observations of contents of his lungs? What was found in his lungs?
Well, it says here that the pulmonary parenchyma is non-crepitant, red, purple, and exudes.
You said that loud.
Oh, sir, I'm on page 4, where we're the summary and interpretation section.
And I'm sorry, there's also fluid that leaks out of the lung, when it's cut. If that's what you're asking me. And these are, the fluid specifically is contained within the airways, and this is something that shouldn't be present.
We may not be looking at the same document. Are you
Why don't you
looking?
approach him and show him what you're talking
Oh, in the summary.
Yeah.
Oh, I
page
see.
4.
The summary, okay, I was reading this section here, I see.
Just take a moment and read that summary.
Sure. These documents are
1 second.
oh,
You finish reading it?
yes, yeah. So in the section that's called summary and interpretation, the language is a bit different than what was described earlier in the document, but their summary is that there's pulmonary congestion and edema. Edema is the medical word for blood, essentially here, and I think that's what's at issue here. And again, that's something that should not be present here. So the lungs are basically heavy, full with congestion, fluid, and blood, and there's blood in the airways as well themselves.
I'm going to note your objection to one page.
What is the objection, Your Honor? What is the objection, Your Honor?
I believe it was outside its scope.
Yes, Your Honor.
I overruled that and put a market exhibit on that.
Okay. Your Honor, may I approach again?
You have the copy that she just gave you.
Yes,
I'll approach.
thank you.
And can you identify that document for us?
This is an autopsy of Harold Wayne Nichols.
And what is the date of death on?
This is December 11th, 2025.
And again, looking for the,
Your Honor, we would make the same objection as to this autopsy report as well, that it's outside the scope of his expertise, that he has been able to testify.
I'm just going to report what the autopsy shows
Yeah,
that some other physician.
he's going to note that the autopsy report found pulmonary edema.
The autopsy was not done by Dr. Zip.
That's correct.
He's just reading what's in the report.
That's correct.
Harold Wayne Nichols, yes.
Why don't you go ahead and ask him to do it? He talked about it, but he didn't really do it.
Identified it? Did,
Tell us what's in the report.
okay, I was looking, Your Honor, myself to move the testimony along. I apologize, Your Honor. Dr. Zivit, on page 3 out of 4, the section on respiratory system,
Yes,
what does it show the cut surfaces of Mr. Nichols' lungs had?
so it says here the cut surfaces of the lungs exude marked amounts of blood and frothy fluid.
Okay. Your Honor, I would move this into evidence as an exhibit.
Noting the objection remark that exhibit 12.
So how common is it for a person to have pulmonary edema?
And what certain, like, just in terms of, like, someone who's walking around, is that what you mean, or someone who is sick?
Okay, let me back up a minute. Have you studied, how common is it for lethal injection by pentobarbital to cause pulmonary edema?
So I have reviewed autopsies of of prisoners executed with pulmonary edema in a number of states over a number of years. I've looked at many autopsies for lethal injection, probably close to 300. And I've looked at pentobarbital, midazolam, and also, that was sort of where I primarily studied, although I've got some experience in other combinations. But this finding of pulmonary edema is very common with pentobarbital, probably on the order of 65 to 70% of the time. So I would consider this to be, it's not a glitch. It's a normal finding, a normal and common finding of pulmonary edema when people are killed with pentobarbital.
Okay. And what does a person suffering pulmonary edema experience?
So pulmonary edema is essentially, the term itself can be broken down into the two words. So pulmonary refers to the lungs, and edema is the medical term for blood. And so it means basically blood within the lungs. Pulmonary edema is generally a combination of blood and other kinds of fluid that accumulate within the lungs. And it's an extremely uncomfortable feeling. The lungs themselves really are designed for the air we breathe, and no fluid normally occupies the airways and the special places where air is exchanged, where gases within air are exchanged with blood. As an example, I consider if you drink a glass of water, and if a little bit of that water goes down into your trachea by mistake, it's an extremely uncomfortable feeling. You cough, and it's very uncomfortable because the lungs are designed to resist that very action. And so now imagine taking an entire glass of water and pouring it into the trachea. And it's a terrifying experience to try to breathe through this fluid, and that's what people who are afflicted with pulmonary edema face.
How quickly would pulmonary edema set in once the lethal dose of pentobarbital has been injected?
Well, in having reviewed this, my opinion is that it happens very rapidly. That the time it would take for pentobarbital to travel from the arm to the lungs is really only a matter of moments. And so almost instantly there's likely some pulmonary edema that's occurring. And we can surmise this by observing people who have been executed with pentobarbital and some of the movements that they make, or coughing, or even complaints that people have made before they've died. And so I think it happens quite rapidly.
Can you explain how the pentobarbital causes pulmonary edema?
So my opinion is it has to do with the fact that the solution itself is this very strong alkali solution that's caustic. And so when pentobarbital is injected in the huge quantity that is involved in execution, this very large volume of this caustic solution travels rapidly to the lungs. And normally, the blood vessels and the air pockets that are referred to individually as alveoli kind of come up against each other and are separated by a very thin membrane of tissue. And in normal situation, we breathe air in, and the air travels down to these little alveoli, little kind of pockets, and then the blood also then travels and kind of comes up against the alveoli. And then within the air pocket, carbon dioxide crosses this membrane, and within the blood, oxygen that's in the blood crosses into the alveoli, and there's this kind of back and forth exchange. But no blood enters into the alveoli. So here now, the very caustic nature of the pentobarbital basically burns through this very thin membrane. now blood rapidly enters into the lungs themselves. And that's why we are, and also additionally, it can't happen after you're dead. So the only way that this is happening is that the heart is pumping the blood into the lungs. And the reason why it gets frothy like that is because a person is breathing. And so the heart is beating, the lungs are moving, and it's that combination and the caustic nature of the pentobarbital that burns this thin tissue layer. That's why we see this pulmonary edema almost all the time.
Okay. Do you have an opinion about whether lethal injection of pentobarbital can cause pulmonary edema?
I believe, having studied this, that the answer is yes.
And how certain are you of that opinion?
I'm certain.
Okay, so thus far we've talked about the lethal injection protocol the state plans to use in Ms. Pike's execution. I'd like to turn now to talk about how the protocol, how this will apply to Ms. Pike. So I'm going to talk about Ms. Pike's medical records. Have you had a chance to review her medical records?
Yes, I have.
And what medical problem did you notice?
I mean, there are several medical problems that are noted.
But the one relevant?
So the one, that we've discussed is this issue of what's called thrombocytosis.
And could you tell the court a little bit about thrombocytosis?
Sure. So thrombocytosis is defined as an excess number of a cell product called a platelet. And platelets are like a fragment of a larger cell called a megakaryocyte, which normally is born within the bone marrow. So megakaryocytes come from the bone marrow. Megakaryocytes break up into these platelets, and then platelets circulate in the blood. And when you go to your doctor, and your doctor draws a blood test to measure certain factors within your blood, traditionally they may measure the hemoglobin, the white blood cell count, and these things called platelets. And in platelets, the normal number is between 150,000 to 450,000. That's the normal number, and most people are probably in the 200,000 to 300,000 range. It's not so common to see platelet counts even above 400,000.
So what are the risks that a person with thrombocytosis has? You
Sure.
talked about clotting.
Yeah. So I'm sorry. So, and I meant to also add that thrombocytosis then would be defined as a platelet count of more than 450,000. So that would be that's what that means.
And you saw that diagnosis in her records?
Yes, she was diagnosed with what's referred to as essential thrombocytosis, which is like a precancerous condition. Essentially, it's a genetic defect that she has that has resulted in this problem.
And when the diagnosis was initially made, what was her platelet count?
Yes, at that time, her platelet count was around 1 million, which is very high.
And did you notice what her platelet count did after her diagnosis?
Her platelet count does what can be normally seen in essential thrombocytosis, which is this kind of waxing and waning number. Like it's occasionally, when I've looked at it over the years, it's been in the high 400 range, but it's generally at least over 500,000 at all times that I've seen it measured.
Can you explain what paradoxical bleeding is?
So within thrombocytosis, in the context of thrombocytosis,
Yes.
when the platelet count is high, higher than normal, the risk is that the blood will clot more readily. So there is a normal kind of clotting mechanism, which is quite complex and has different elements, but it's there kind of working all the time, that we're alive. as an example, if you cut your finger and you see blood, so you maybe take your hand and you put pressure on your finger, and in a matter of a few minutes, you can take your finger away and there's no more bleeding. And the reason why the bleeding has stopped is because, you know, your normal body's mechanism is there to cause something called a clot, you know, which basically starts with a plug and then other factors are added to it. And if without that, you would bleed to death. And there are certain kinds of conditions that people have that make them very likely to bleed. There are other kinds of conditions that people can have that make them very likely to clot. So thrombocytosis is a condition that makes the chances of clotting, and when I say that clotting, I really mean abnormal clotting, so clotting when it shouldn't clot. But also, paradoxically, that with thrombocytosis, people can also have some increased tendency to bleed, and that's because platelets themselves involve another kind of factor called von Willebrand's factor. And von Willebrand's factor is necessary in something called a coagulation cascade. And von Willebrand's factor both circulates in the bloodstream, and also about 10 to 15% of the von Willebrand's factor in the body is contained in platelets. But platelets can actually kind of consume the von Willebrand's factor, and you can end up with a von Willebrand's factor deficiency. And in that situation, instead of clotting, now you bleed.
Okay. So that's what you mean when you say paradoxical
Yes,
bleeding?
because one would imagine, you know, that if there's more of the factor that causes clotting, it should result in more clotting, not less. But in this kind of paradoxical circumstance, there can be more bleeding than clotting.
Okay. So given the risk of pulmonary edema that attends to lethal injection by pentobarbital, and given Ms. Pike's diagnosis of essential thrombocytosis, do you have an opinion as to any complications that she would face during the lethal execution?
Well, I think there's several things. The first thing we can speak about is the fact that in order to have this procedure done, Ms. Pike will need to have intravenous's started.
Okay, let's just focus on the pulmonary edema.
Okay, all right. So within the lungs, you know, the pulmonary edema, when it happens, is also is an injury. And so now the body has this immediate reaction to being injured. And one of the things that would happen in a state of injury is that platelets are going to be circulating and will be in these injured lungs. And so the fact that there's an excess amount of platelets within the injured lungs can do a couple things. It can cause either more bleeding in this paradoxical problem that we've discussed. The platelets themselves have kind of factors within them that will be released, and they can have even a more intense and worse inflammatory kind of reaction to this injury. So although pulmonary edema can happen, happens commonly, in anyone that's executed, in the case of Ms. Pike, it will be an even worse, if it's possible to imagine, potentially worse example of pulmonary edema that she may face in this case.
Okay. Your Honor, may I have a moment?
Sure.
So we've talked about pulmonary edema. Do you have an opinion as to whether she is at a heightened risk of a clot forming in the IV access or in the IV line?
I think that was the other problem that I think that she faces that is material, and that because of this risk of thrombocytosis, that once an intravenous is placed, first of all, it might be difficult, just because of I understand that
Let's just focus on the clotting
all right.
issue.
So that once an intravenous is in place, the intravenous within the vein, is not supposed to be there normally. And so the body kind of regards that catheter as a bit of an invader and will try to kind of clot itself around that catheter under normal circumstances. So that's called, in this situation where a catheter, is there, we refer to that as thrombophlebitis. So the vessel itself can become inflamed, and then the inflammation, and this happens very rapidly, there can then be a clot because she now has this kind of, because she has this tendency to clot. So this catheter that, that is placed could just clot, and so it just won't work. So that's, I think the risk that she faces that's quite material.
Okay, that's all I have. The state will ask you some questions.
Hello again, Dr. Zivit.
Hello.
I noticed, I wanted to clarify one thing. You stated that edema is the medical word for blood. Is pulmonary hemorrhage not a more accurate statement, and edema more related to fluid alone and hemorrhage blood?
I mean, I think that the Latin derivations of these terms overlap. So when we say pulmonary hemorrhage, then yes, specifically we refer to to blood. And we say pulmonary edema, it can be a combination of blood and fluids, that are not specifically blood, but are a component of blood within the circulation.
But you would agree that if pulmonary edema is mentioned in an autopsy report, it does not necessarily mean there was the presence of blood?
No, no, I wouldn't agree with that, no.
So every time that pulmonary edema is mentioned, you would state that there's a presence of blood?
There will be some blood there, yes.
You stated that before sodium thiopental was, I think you said, removed or not used anymore, you used it thousands of times. And I think you stated that sodium thiopental is similar to pentobarbital, as in they're both barbiturates?
Correct.
Or barbiturates, depending on how you pronounce it?
Yes.
So if those were used in the clinical setting, and may still be used to this day in the clinical setting?
We'll break it up.
Okay. If those are used in the clinical setting, what would the typical dosage be to put someone to sleep before surgery?
Are you asking me about sodium thiopental or pentobarbital?
Barbiturates in general.
Well, we don't use barbiturates in general. We use specific ones in specific situations.
Okay, pentobarbital.
So pentobarbital is not really used, as if you're at the, when you say to put someone to sleep, is that what the word you used?
For an anesthetic prior
Yeah.
to surgery.
It's not technically sleep. So that may be a word that people use, but that's not correct, that it doesn't cause people to fall asleep. We don't use pentobarbital to do that. Sodium thiopental was used as what's called an induction agent at the beginning of an anesthetic, but it's not available anymore because of the death penalty.
I'll rephrase my question. I don't think it was very clear. For the use of pentobarbital in a clinical setting, for an induction agent, or prior to a major surgery or surgery, what would the typical dose be?
It's a fraction of what the state is using. It's not a drug that we use in that way. So I can tell you, off the top of my head, I don't remember the exact number, but it's not used in that way. And it would probably be on the order of maybe a 20th or something more, but I'm not certain off the top of my head, because it's not a drug that, that anyone uses clinically.
So it would be a fraction.
A
of what
fraction,
the state-
yes, a fraction would be used clinically.
And that fraction that would be used clinically would be sufficient to prevent someone from experiencing pain during a surgery.
No,
So they would experience the pain during the surgery if pentobarbital is used as an induction agent.
pentobarbital does not relieve pain in any dose. It's not used for pain control.
So when it's used, or when it was used, if it were used in the clinical setting, it would not prevent someone from feeling the effects of a surgery.
It would not be used, like an anesthetic is not an execution. So an anesthetic involves many, many different kinds of drugs used in combination, and no one would use a barbiturate alone, as I think you're asking me, and expect it to do anything like control pain. That's not what it's used for.
What would it be used for?
Well, first of all, pentobarbital isn't used. It's not used, it's the drug that used to be used was a drug called sodium thiopental, and that would be one drug in a series of drugs that would be used at the beginning of an anesthetic. That period of time is called induction, and it would be part of the combination of medications to create a state that would kind of transition from being sensate, to some kind of state of stupor, all the way to an anesthetic state that would allow for the surgery that I think you're contemplating, but it would not be the pentobarbital that would do that. It actually is fairly short-acting, and so it would be gone by the time the anesthetic got underway for the pain control part of the surgery.
You mentioned that pulmonary edema is very common, 65 to 70% of the time. Do you have any basis for that opinion other than it's your opinion?
Well, I reviewed, I have a preprint where I reviewed 43 autopsies, and then which included, I think, 15 of sodium thiopental, or pentobarbital rather, and found pulmonary edema in that instance, I think it was on the order of about 70%, so 7 out of 10 times. And then I reviewed another 250 autopsies in total. I think I reviewed probably on the order of almost 300 autopsies that have looked at pentobarbital being one category, and have found this persistence of this very high quantity, this unexpected, finding of pulmonary edema that is seen in autopsy. And that's the basis of my opinion.
And it's your opinion that pulmonary edema would be uncomfortable, extremely uncomfortable.
Extremely uncomfortable.
And it's your opinion that the person experiencing pulmonary edema would actually be sensate to pain at the time.
That's my opinion.
And do you have any sensate to pain at the time, Your Honor? And it's also your opinion that pulmonary edema cannot happen after you are dead?
Not to the degree that we're seeing it in these autopsies, no.
I'm sorry, not hearing good. What was the last question?
It's his opinion that pulmonary edema cannot happen after you are dead?
So you're saying where the lungs were pristine, then you die, then you wait, then you do an autopsy, and then you find pulmonary edema. That if you did the autopsy at the moment of death, that there would be no pulmonary edema. Is that what you're asking me?
I'm asking you, you stated as a fact that pulmonary edema cannot happen after a person is dead.
If a person dies and the lungs are undamaged, and then pulmonary edema does not happen after, to any degree, there is some shifting of fluid that can happen over periods of time as the body decays. But in the immediate period, it's not an immediate post-mortem finding of pulmonary edema to the degree that we're seeing in these autopsies.
So it's your opinion that over time, from the time of death to the time of autopsy, the more time that passes, more fluid cannot enter the lungs?
There are, generally an autopsy is done either within hours or maybe a couple of days. At least as I've observed it in the way the state is doing it. So in that period of time, it's my opinion, not just mine, but I think the medical position, that a significant amount of pulmonary edema is not the consequence of just post-mortem, of the passage of time in the post-mortem period that wasn't present, at the time of death.
And do you have, other than your opinion, are there any articles, any research, any studies that you've reviewed to come to that conclusion?
Yes.
And those articles support that conclusion?
Yes.
Is there a reason that you did not cite those articles in your report?
It wasn't asked of that. That wasn't asked of me.
I want to go back to the sodium thiopental and pentobarbital. You mentioned that you use sodium thiopental thousands of times. Does sodium thiopental cause unconsciousness?
I think the term conscious and unconscious are kind of problematic terms, like when you said sleep. I think that there is an altered state, but it's more complicated than these terms, I think, describe. There is a kind of altered state of awareness that sodium thiopental can cause that's pretty short-lived once injected if it's part of an anesthetic. So it's because it kind of rapidly causes this kind of altered state of awareness, that it's useful in the beginning of an anesthetic.
How short-lived would that period of, I guess, unconsciousness is the word I would use, but the period of altered state?
It's probably on the order of minutes, 5-10 minutes, and then a person would begin to, regain their, again now, just for the purposes of this conversation, I'm going to use the term wake, but it's not that, but they'll begin to return to their former state, of awareness within a matter of a few minutes. There are caveats to it, depends on other issues, but in the aggregate, it's probably a few minutes.
And does pentobarbital act the same way as far as the temporary period of altered state?
Well, remember, you're using a much larger dose of pentobarbital.
In the clinical setting, the same setting as sodium thiopental?
Well, I would say that pentobarbital, would act similarly if it was used similarly in a clinical situation. Likely there'd be some, like the drug actually has what's called an alpha and beta elimination. So the alpha elimination, which is why people regain consciousness rapidly, is because the drug is redistributed, it's called. And then there's a secondary thing that can go on for many hours before the drug is actually cleared from the body. But barbiturates, have this kind of rapid alpha elimination that creates this kind of wakefulness that can occur pretty quickly.
Okay, so in the period of altered state, or as some would say, unconsciousness, I think you said it's short-lived, but I think short-lived, you said could be 15 to 20 minutes.
No, I didn't say that. I said a few minutes.
A few minutes?
Yeah.
Okay.
You're talking about pentobarbital.
Yes, Your Honor.
Yeah.
So short-lived, a few minutes. So in that few minutes, in a clinical setting, in that few minutes, would the patient be sensate to pain?
So when you say patient now, we're not talking about prisoner, right? We're talking about a patient.
In a clinical setting.
Okay, I mean, not only are barbiturates not analgesic, that's the technical term, they actually can be thought of as analgesic. It means that they actually can make pain worse. So they're never used as pain relieving medications in any dose, in any circumstance.
Okay, so they would not be used to relieve pain,
Never.
but as far as rendering someone unconscious to where they don't know what's going on. They're in an altered state, I think, as you called it, for minutes.
The beginning of an anesthetic is called, anesthetics have 3 components: induction, maintenance, and emergence. So this is the induction portion. That's what barbiturates are used for, to kind of help you, and certain kind of things are done. Plus the pentobarbital, actually, that we don't use, plus the sodium thiopental is combined with other medications that are in fact analgesic. So that's how we would, that's how an anesthetic would be done.
And that's in the fraction of what the state uses.
Yes.
So would the altered state last longer with a larger dose?
Well, what's happening is that in an anesthetic, you're doing many things at the same time. So you may then initiate the maintenance anesthetic, which is going to start at virtually in a very short period of time after the sodium thiopental is injected. It might be a vapor that begins, that a patient is inhaling. That period at the beginning of an anesthetic, we place something called an endotracheal tube. There's a tube that goes into the mouth and beyond the vocal cords, it's connected to a mechanical ventilator. So there's a lot of things that are happening kind of at the same time. But the pentobarbital is just a way of kind of, creating this sort of state of obtundation. Because starting out with other kinds of anesthetic agents, if we didn't use the pentobarbital, can cause other kinds of adverse things. The gas itself can be unpleasant to breathe, and so the pentobarbital, combined with, again, it would be combined with an opioid, with a benzodiazepine, with a local anesthetic. There's a lot of other things that are going to be mixed all at the same time. All of that is present, but the pentobarbital or the sodium thiopental is there for, the expectation is that it's going to be providing me something, for just a few minutes at the beginning.
And during that few minutes, you mentioned a tube.
Yes.
Kind of, I guess, a breathing tube.
Right.
During that few minutes, is that when that breathing tube would be placed?
Yes.
And during that few minutes, would the patient feel that tube enter their, does it go into their trachea, you
Their
said?
trachea, well, we use pain relieving medications that then block the sensation of the tube going in. Those pain relieving medications may not cause the kind of, altered state that we were trying to create as easily. So when the two are mixed, you get both the pain relieving and then the kind of altered state that the barbiturate is intended to create.
So, would you agree that placing a tube into someone's trachea during that few minutes of altered state would be similar to also, I think you said, choking on a drink of water, going down the wrong pipe?
Well, it's because, it is, and that's why we add medications that block that uncomfortable sensation of something being introduced into the trachea.
I'd like to move on to thrombocytosis. I think you said that thrombocytosis meant more than 450,000 in the platelet count.
Correct.
Did you review Ms. Pike's medical records in this case?
I did.
And are you aware of her most recent platelet count?
I mean, I looked at a lot of information, so maybe you could just tell me the number that you're asking me about, or the time. And I don't have it in front of me. If you want to give me a document, I'm happy to look at it.
Okay.
Let me ask you, doctor, you have an opportunity?
Yeah, I looked at this. You know, I looked at the fluctuations in platelet count, yes.
Doctor, I always counsel my people not to answer the questions are finished. I was about to ask you,
No.
and you had the opportunity to look at the expert reports on the other side of this case.
Yes.
We looked at Dr. Help me out there, is it Antagonini?
Well, I think it's
Your
Antagonini.
name is easy.
Thank you.
Your Honor, he's not looked at
I don't think I've seen,
council's report.
no, I guess I've not seen that.
Okay.
Antagonini, no. Yeah.
May I approach, Your Honor?
Sure. So I've got experts that don't know what each other's going to say? That's not my custom for me in my practice.
Not for us, Your Honor.
Before we go any further, Counsel, can you help me out here?
Yes, Your Honor.
I believe we marked something Exhibit 12 that the court hadn't seen. That's correct, ma'am?
I think that was the autopsy report of Harold Wayne Nichols.
Have that on the desk, please.
Yes, yes, I do. Yes.
You can look at that report for a while. Take yours of business. Mark that Exhibit 12.
I'm going to figure out how to share my screen here, Your Honor.
We look at a case where the experts don't know what the other experts going to say.
Apparently so, Your Honor. We did share expert reports,
Okay.
but it was a very expedited timeline.
It's
So.
time to see.
Okay, I've handed you a portion of Ms. Pike's medical records. Were these within the records that you were able to review?
I believe so. I don't see a date on this, so I'm not sure. This is one single time, and I don't know the date of this.
So if you look at towards the bottom before where it says order result, I think
Oh, I
there's
see.
a
Is it-
line going across. It's highlighted on my screen. It's got document creation date.
Is that the date that this blood was drawn?
It appears so.
So this says August 5th, is that right? No, sorry.
The small print looks like to me May 8th.
Sorry, May 8th.
May
Sorry,
8th.
I'm from Canada, I get that backwards sometimes. So May 8th, okay, May 8th, yeah.
So, again, I think you said that thrombocytosis means more than 450,000
Correct,
in a platelet count.
correct.
Could you review this portion of Ms. Pike's medical records and identify on May 8th, 2026, just a few months ago,
Yes,
what her platelet count was?
it says 452,000.
So would you agree that that is just above abnormal?
It's abnormal. So it's not just above, it's above, it's abnormal.
Your Honor, I would like to admit this as Exhibit 13.
Well, see, we can mark this Exhibit 13.
Okay, so I've handed you another portion of Ms. Pike's medical records. Do you remember having a chance to review this before your testimony today?
I mean, I believe I reviewed this and many other, well, not just these two, but many other examples of her platelet count,
Okay.
which fluctuated.
Now, this is her second most recent platelet count on, could you state what her platelet count was on November 21st?
On November 21st, this says 433,000.
So based on that number, less than a year ago, you would not diagnose her with thrombocytosis.
You wouldn't make a diagnosis of thrombocytosis based on this single, I mean, we know she has this diagnosis, she's had it investigated by hematologists, she has the genetic defect, she has a diagnosis of, of thrombocytosis, that's her diagnosis. There can be periods where the platelet count fluctuates, but this does not mean that she does not have this diagnosis. She has essential thrombocytosis, that's the diagnosis that she has.
What would you define as essential thrombocytosis?
Well, it's not what I would define, it's what the definition is. It's a combination of a platelet count and various genetic findings, that then go along to make this diagnosis. Sometimes it's a bone marrow that's taken and other sorts of things, but that's her formal diagnosis, that she has.
Based on her current, most recent platelet count results, would you agree that her thrombocytosis is not as extreme as it was in 2017, when I believe her platelet counts were 1 million?
Yeah, well, I mean, I think you'd have to just draw it again. Just draw it today and see what it is today. I don't know what it is today.
And if it were similar today to what it was in November, or just lower than what it was a few months ago in May, let me rephrase that. If her blood was drawn today, and it was similar to the counts in November, and lower, just a tad bit lower than her counts in May, just a few months ago, would your testimony be the same regarding the risks posed to her due to thrombocytosis with lethal injection?
I think, just to be clear, that this number, 433, is a high number. So, we kind of draw an arbitrary line at 450. But most people are like 200, 250, 300. Like, this is still a high number. And we know, if I had never met her and someone handed me this, I would say, oh, that's a high platelet count, even 433. So I think that my opinion would not change. I think she has this diagnosis. It's a formal diagnosis. Her condition is not curable. It can be managed sometimes. But, I wouldn't change my opinion. This one single number from November that she's suddenly been cured.
Multiple opinions. Which opinion would you not change?
I wouldn't change the fact that her risk is greater and that she carries this diagnosis of essential thrombocytosis.
So you would not agree that the lower the platelet count, the less the risk of clotting?
I don't understand your question. How low? What are you asking me?
I think she's asking you, the person with 1 million platelet count versus the person with 433 platelet count, which one's going to have the greater risk of problems with the lethal injection?
I think that in both instances, there will be significant risk. That's my opinion. That it's not really easily quantifiable exactly, because a platelet count of 433,000 is still high. And so I don't think that means that if she has that number, if that was her platelet count today, and she was executed today, that it would be somehow protective. I think she has this diagnosis, and I think that her platelet count always generally is running high when I looked at it. So it's, between 450 and 500,000 every time I looked at it. There's more than just these two things that we've seen. So think that's my opinion, that her thrombocytosis is persistent and is material and presents this particular risk to her.
There's been substantial talk about a central line in this case. Due to Ms. Pike's thrombocytosis, in your opinion, of her risk of clotting, do you believe that a central line would heighten those risks of clotting?
I don't understand your question.
If it's your testimony that intravenous access for purposes of lethal injection poses risks of clotting, dangerous risks of clotting, would a central line pose the same risks?
A central line, would pose, could pose a technical risk, that it couldn't be placed. And if it was placed, it could still have, central lines can become clotted like peripheral IVs as well. So there's a central line might be less likely in a larger vein because that's where a central line is placed, but the risk would still be there.
Would thrombocytosis prevent intravenous access?
You mean, if a vein has a thrombus in it, then you can't place a catheter in it, if that's what you're asking me.
No. If someone is diagnosed with thrombocytosis, just that diagnosis in general and a high platelet count, in your opinion, would that prevent intravenous access?
No, intravenous may be started, it just may not last long, or it also may be difficult to find a vein, that's patent and able to accommodate an intravenous catheter.
You've testified on behalf of death row inmates challenging lethal injection protocols in numerous cases across multiple states over the past decade or more, haven't you?
Yes.
And how many states have you testified against the death penalty?
I mean, I've been to or visited death row in 9 states.
You've been doing anti-death penalty work for 14 years now?
I've been doing anti-medicalization of punishment work for 14 years now.
And you've participated, I think your CV lists multiple podcasts, multiple papers, studies against the death penalty and lethal injection in general.
Well, I'm against lethal injection, and I'm not the death penalty, which of course involves lethal injection. That I'm against.
Would you say that that would influence your opinion here today in any way?
No. Well, I'm sorry, I don't understand your question.
Would your view of lethal injection, your personal view of lethal injection, influence your scientific or expert testimony here today?
I have no personal view of lethal injection. My view of it is based upon, what I've learned about lethal injection and what it does and doesn't do.
You've stated that prisons are impersonating medical providers when they perform?
Not prisons, but the act of execution is an impersonation of the medical act, yes.
And would it be fair to say that no matter how lethal injection is achieved, no matter how execution by lethal injection is achieved, you would oppose
Yes.
that method?
I will, I mean, I don't know how, no matter what, I mean, I guess I'd have to evaluate these things on a case-by-case basis.
But there's no form of lethal injection that you agree is humane or not cruel?
In the methods of lethal injection that I've so far encountered, I've not encountered one that I thought, I mean, I think humane is an odd word. I don't know what that means here. I mean, if you mean humane, you mean human-like, which is what humane means. Usually we say that when we've done something terrible. So if that's what we mean, I was only human, then I suppose yes. But it's not a requirement that it be humane. It just is a requirement that it be not cruel. So I think in the methods of execution I have reviewed, I think that there's cruelty is, it's a feature. It's not a glitch.
But that would be your opinion no matter the method of lethal injection, no matter...
Of what I've encountered so far.
No further questions, Your Honor.
Your Honor, may I have just a moment?
That was my fault, Your Honor. I did not move for it to be admitted.
Do you need these from me?
Just briefly, the opposing counsel showed you some more recent lab work that showed the platelet count was not as high.
Yes,
But she still has essential thrombocytosis.
that's correct.
Would you expect the platelet count to be lower if she's receiving aspirin?
It might be. I mean, essential thrombocytosis is not curable. So there are things that can be done. Aspirin is given to patients which can have an impact on their clotting tendency. And so that's why aspirin is given. But it doesn't necessarily drop the platelet number. It just has an impact on the way platelets work.
And I believe you testified that essential thrombocytosis, there's a genetic defect.
There is.
And the more recent platelet counts don't cure that genetic defect.
They
essential
don't.
Thrombocytosis.
No, they don't.
Your Honor, no further questions.
Okay, this is a non-jury matter, and I've got a few questions for the doctor. First of all, Doc, did I read that you are a lawyer?
I have a master's of law.
Is it my understanding that you have not read Dr. Antagonini's report?
I don't know. I'm not sure which report it is, so I don't know the answer to that.
Well, let me ask you, just in prepping for this and trying to get familiar with the law, I read a number of cases that your name appears in that are, and some of those appears in Dr. Antagonini. How many times have you been in the same case with him?
Few times.
A few times? Are y'all best buddies?
Oh, no.
Okay. So you kind of got an idea of what he's going to say.
I got an idea, yeah.
And you happen to be involved in one of the most famous cases, this Bucklew versus...
Oh, yes. Precythe.
How do you pronounce that last name?
Precythe. Bucklew versus...
I just call it Bucklew.
Sure. Yes, you're whatever you like.
And, you know, I guess after you testify in these cases, you read the opinions from the courts.
I do.
And you're familiar with the fact that in that case, they said the most relevant Eighth Amendment question is how long the inmate will be capable of feeling pain.
Are you talking about Bucklew? Yeah, in Bucklew you're saying? Or just, are you
That's
asking?
the U.S. Supreme
Yeah.
Court, the most relevant
Right,
question.
yeah.
How long the inmate is capable of feeling pain.
Yes, okay.
I mean, would it surprise you to find out that Antagonini,
Antagonini, yeah.
after this dose is entered, that at most the person is capable of feeling Would that surprise you if that's what his testimony is going to be?
I would not be surprised if he claims that.
Are you familiar with the methodology that he uses to come up with that?
Likely. You know, I mean, I'd have to see.
This is your opportunity to
Yeah.
refute.
Yeah,
this methodology.
I think that that's, I think that that's, I mean, I think that's an important observation and comment that I would like to comment on his, you know, if that's what he claims, I have an answer to that. Yeah.
It's the most important thing that the Eighth Amendment has for the court to consider. Why is there no mention of that in your?
It wasn't asked of me, you know, it wasn't, I mean, to comment on how long the pain would be present.
So even though you know it's the most important consideration for the court, you don't give me a time frame that a person is going to be capable of feeling better.
Well, I can answer you now if you want.
Would that be outside your report?
You know,
And since you didn't put it in your report, nobody has a chance to test your methodology for coming up with it.
You know, I don't know how to answer you. Like, I mean, I
Why
can.
would you avoid the
Yeah.
most important thing the court needs to know?
Your Honor, if I could refresh Dr. Zivit's recollection with
Okay.
his April 8th report.
Okay.
If you want to ask some questions, I will give way to you.
I think you might still need this.
I may have commented on that, but I can't, let me see.
Just if you could look at paragraph 7.
Okay. Oh, okay, yes, I'm sorry. My mistake, I did actually address that, I just did not recall it. It's in my report.
Is this your addendum or the?
The addendum,
Original report or the addendum?
the addendum.
Addendum. Let's see, the addendum. Death from antiviral infection is not instantaneous.
Yes,
That's your,
yes. It's not instantaneous.
that's your time.
Well,
To where the inmate cannot feel any pain.
no, I think that what we know is that two things. We know that even when people are given anesthetics, like proper anesthetics in an operating room, where all of these things are measured, that a percentage of patients recall what happens to them. They know it's happening. I've also seen on many occasions, frequently, that patients react to pain, even under deep anesthesia. And I also know that this idea about the number of seconds of pain is important, because really the question is, how long can a reasonable person endure terrible pain reasonably? And the example here I say, if you put your finger in a flame and count to 30 seconds if Dr. Antognini, or 20 if Dr. Antognini says 20 seconds is an awfully long time to be burned alive. I don't know, and neither does he, how long it exactly would be. A person, you know, from the beginning of lethal injection to time of death could be 10 or 15 minutes.
Well, we're not talking about time of death, we're talking about the time, we're not talking about, we're talking about the time they can feel pain.
So how long?
We all know that people are going to die later.
Yes.
You're talking about the time of death and you're talking about the person feeling pain, but you've given me no duration.
Well,
Are you telling me you don't know the duration?
no one knows the duration. It's not knowable. I can surmise it, but it's not knowable.
So when you say a person's drowning, you don't know if they're feeling that for 1 second or 2 seconds?
Well, I don't think it's
10
one.
seconds.
I think it's longer than that. That's my professional opinion about this.
But you're not going to give me a time frame or a methodology for how you're doing that.
Well, it's based upon the way the drug works what I've seen in thousands of cases of anesthesia and thousands of cases of pulmonary edema and my opinion and my understanding of the way that pentobarbital or drugs of that class work, I think it could be minutes. It won't be 1 second. It could be minutes or a minute.
So you said pulmonary edema is excruciating pain.
Yes.
But if you don't feel it, it can't be painful.
It happens right at the beginning. It starts to happen at the beginning. So the beginning is when you're going to have the highest chance of feeling it. As time progresses, then you may feel it, then your capacity to feel it will be less.
So the relevant eighth amendment question is how long the inmate will be capable of feeling pain. They also talk about duration and intensity. You get the intensity part, pretty hard. So you didn't put in your opinion about how long that would be, other than it's not instantaneous.
I didn't specify a number of seconds, no. But it's not instantaneous. If that's what you mean, I said the death is not instantaneous.
I'm trying to find
Yeah.
out which expert to believe. And the critical question is not whether someone's still alive after they've injected. It's not whether they're still breathing after they're being injected. It's whether they're capable of feeling pain. When does that happen? Because we're trying to do this in the most humane way possible. And I have to compare the pain that might be suffered versus the pain that might be suffered when someone is hung out the neck. And I have to figure out, those are the challenges that I have. And it was a red flag when I saw a report that didn't tell me about duration. This is your opportunity to explain why you didn't put it in your report when you knew that that was going to be a critical issue.
I'm guided by, by the attorneys who hire me, and I'll try to answer the questions that are being put to me. I'm happy to answer that question for you now, sir, if that would, if I could.
Why didn't you put it in your report?
You're
a lawyer, you're on the most famous
Yeah.
case in the country. The U.S. Supreme Court said the duration is capable of feeling pain is one of the most important. Maybe I don't want to exaggerate. Maybe
I'd have to read it also. I think that also that, the majority opinion there misunderstood my own report, so I have, some concerns about that. Yeah.
we're not going to talk about it. But why didn't you put a duration in your report?
It didn't come up. Again, I'm happy to address it now.
You said the first report, and you said it's false to claim that grief, pain is not material. And the second report, it's false to claim that grief, pain is not material. I read that and I said, is he telling me this pain's going to be grief? And then in your first report, you said that it's like putting your hand over the flame for 60 seconds. And in your second report, it changed to 30 seconds. And I know those are just examples.
I'm just trying to, this question about how long is obviously critical. And I think it's been debated, between the experts. So my contention, is that the amount of time that will be there will be enough that it could be experienced as cruel and painful. That's my medical opinion. My opinion as to how long.
How short it is, it's going to be enough severity.
Yes. Yes.
All right. So why didn't you discuss that in either one of your reports?
I don't have an answer for you. Yeah.
All right. Y'all have any other questions?
Your Honor, I do. Dr. Zivit, you said that the answer to that is unknowable.
The precise number of seconds, is just unknowable.
Why is it unknowable?
Well, I mean, first of all, once a person is dead, you can't ask them whether they experienced their own death as cruel. So we didn't know any of this until we started looking at autopsies. That was a surprising finding. We did not know this. For a long time, lethal injection looked kind of okay, and it was designed to look kind of okay. But it's not okay. It's not okay. And that's, hundreds of autopsies. And my experience of this has convinced me from physical evidence and from my understanding of the pharmacology of these drugs, it's not okay. It doesn't do what it's claimed to do. It doesn't create a painless death. It doesn't create a humane death. It creates a cruel death. And I think that that's by design. I'm not suggesting it was intended, but that's the finding. That's my position. That's always been my position. And I think that even if it's short, even if we could concede that it's some short period of time, that what we know about pain, and as an anesthesiologist, I'm an expert in pain relief. I know that and also I would say that the easiest pain to bear is someone else's. So I think that the amount of pain is very severe, and the timing of it is long enough that the brain can conceive of it, that it can be experienced. That's my contention.
Dr.
I
Zivit?
understand that, but I want to make sure I understand. You have no estimate on the duration.
Only within the time, of some time, within the period of time it takes from when it begins to when a person dies. That's all I can say.
Dr. Zivit, you testified on direct that one basis for thinking it's painful is witness observations of inmates who have expressed profound discomfort or have moved around or...
Yes. Yes.
And is that something that you consider when you're evaluating?
I think that's material. The way that we gauge pain, there is no pain meter. There's no piece of equipment we can put on someone. And what it requires, of course, is our empathy. We have to look at it. And when we, generally we know what pain is. We know what it looks like. I see this all the time. And so it's the empathic nature of people that allows me to watch a person be executed. And from my observation of what they're saying and what they're doing and how they're moving, one can surmise that there's terrible pain there. I've never heard anyone say, this is great, so.
Your Honor, I have no further questions.
If it'll make you feel better, I'm going to put Dr. Agony on grill him on how he came up with this time frame too, and ask him about his methodology. This big.
I'm happy to answer any questions.
The only thing is he won't be able to talk about your methodology.
Fair.
You can say that.
Thank you, sir.
We won't stop here for the evening. Your Honor, our next witnesses won't be available tomorrow.
That's good news. I thought you were about to say we want to take another witness. Why don't we adjourn court for the day or soon now?
Your Honor, when we were here last week, the clerk said that Judge Green might be in the courtroom tomorrow. Is that?
He just graciously agreed to go somewhere else. If you need more time, I can tell him to come back.
9 a.m. works.
All right, so we'll see y'all now. We're adjourned.
Can you save that last bit? Is there a way to make sure we save that? I mean, I have it on the card.
You're gonna say, is it everything?
I want to preserve it. I want to make sure it doesn't get wiped away.